To all present here today. It gives me immense pleasure to welcome you all to the second day of the International Research Conference on Insolvency and Bankruptcy, a joint initiative of IIM Ahmedabad and IBBI. On behalf of the IBBI family, I extend a warm welcome to our esteemed guests for today. Dr. Deepti Mukesh, Honorable Member, National Company Law Tribunal, Ahmedabad. Dr. T.K. Vishwanathan, former Secretary General, Lok Sabha. Professor T.T. Ram Mohan, Member, Economic Advisory Council to the Prime Minister. Dr. Navrang Saini, former Chairperson and whole-time member, IBBI. Shri A. Unnikrishnan, Legal Advisor, RBI. Shri Bhairam Vakil, Partner, AZB Partners. Shri J. Swaminathan, MD, State Bank of India. Shri Sumant Batra, President of SIPI. Professor Laura Cordes, Associate Professor of Law, Sandra Day O'Connor College of Law. Professor Sankeb Mohapatra, Professor Abhimandas, Professor M.P. Ram Mohan, Shri Sudhakar Shukla, whole-time member IBBI, other members of the governing board of IBBI, audience present here today, and stakeholders who have joined us online. Before we begin today's agenda of the conference, I would like to quickly give a recap of day one of the conference. It was inaugurated by Shri Rao Inderjeet Singh, the Honorable Minister of State for Corporate Affairs. In his inaugural address, he cited that the code has assumed larger significance post the COVID-19 pandemic and has been instrumental in saving both lives and livelihoods. The inauguration session was followed by a panel discussion on the theme Banking and Industry Perspective on IBC. This was followed by thought-provoking paper presentations by a myriad of researchers, professionals, and policymakers. Day one of the conference concluded with a workshop on data-driven insolvency research by IBBI and a special address on the topic Insolvency and Digital Economy. We are immensely grateful to all the speakers and participants for their enthusiastic participation in yesterday's discussions, and we hope that the same will continue today as well. Without further ado, we will now proceed with the first panel discussion on the theme Reforms in Insolvency Regime. The panel discussion will be chaired by Dr. Deepti Mukesh and moderated by Shri Suman Batra. We may begin with the discussion.
Thank you so much. A very good morning to all of you. It's such a pleasure to see such a full hall on a Sunday morning, something which I can assure you is not very usual in Delhi, where I come from. It's hard to get people out of bed on a Sunday morning. So thank you so much for attending. We really appreciate it. The topic for the session is reforms and insolvency. We wouldn't really want to delve into what has already taken place in the last nearly 5 years of insolvency reforms. History speaks for itself. You're familiar. We have discussed it threadbare over the last 4 to 5 years. The need for reforms, the reforms that have been undertaken by the government by way of legislative amendments as well as regulations that have been amended. But at the same point of time, those are what we call them as rear view vision. And in order for you to drive ahead, you always have to have one eye on the rear view. And that's how it really works, because that gives you a very good perspective of the law, of how we have implemented it in the past, and how we continue to look at it going forward. And therefore, in that context, as all of us share our experience, our views, our perspective with you, we will continue to reflect on the past as well. But I think, and I gather, and I take the liberty of saying this as something which I think all of us on the panel concur, that this is something which is more as a futuristic, more as ideas, brainstorming, our perspective, which we hope and expect would benefit the policymakers, the market, in terms of addressing and the issues that we continue to be confronted with in terms of making the IBC more efficient and be, if I may say, enforceable at the optimum level. Before I start with panel discussion per se, I'd like to request Dr. DP Mukesh just to make some opening comments as chairperson of this panel. And then we will move on to the question and answer sessions. We've attempted to start dot on time, and I assure you that we'll try and end up also around the same time. Thank you so much, ma'am.
Thank you, Mr. Batra. A very good morning, Sunday good morning to all of you. In a scorching heat, you all have come here to attend and share our ideas. So that's a very welcome step. Rightly, Mr. Batra said that we have already started or we have initiated the reforms in insolvency, because if you see, the prior to code, there are only two laws regarding to insolvency. One was Presidency Town Insolvency Act, and the other one was Provincial Insolvency Act. And as per our experience, because being at bar, I can assure that prior to code coming into force, most of the people, even business class people, they were unaware about the term insolvency or bankruptcy, or maybe very rarely, even in the practice, there was not much of emphasis on insolvency practice. Today, it has become a very upcoming branch of practice, not only for the lawyers, but also for the chartered accountants, company secretaries, and the whole idea about insolvency, what it is, how it is to be practiced, how it is to be resolved, and how we can help the business class or the entrepreneurs to not to go towards insolvency, but do a better business or ease of business. I think that idea has come, and the people in general, I would say, have come to understand the meaning of insolvency and consequences of insolvency, which is a very big reform, according to me. Last 7 years, probably every newspaper, maybe every alternate day, some news about insolvency or bankruptcy, some code, some changes, amendments. I think if Mr. Batra will agree with me that maximum number of amendments in such a short span maybe is witnessed by the insolvency code, and the demands and the litigations and the question of laws which have raised by the various litigants, the interested parties, the common person coming for the rights, financial creditors, everyone, is amazing. So the reform has already started, and we are on the path of it. And while discussing, we will come to know that how we can take it further. So probably we can start.
Thank you so much, Dr. Dipti Mukesh. One thing just I wanted to mention before I move on to the discussion was that I was supposed to be a panelist, but I think IBBA realized that having a lawyer on the panel is very dangerous because they would just monopolize one part with the microphone at all. So therefore, I got a message from Ritesh, sir, would you please moderate it? That was a very clever way of telling that please give opportunity to everyone and not just keep the mic to yourself. But that's on the lighter side. I mean, you all know lawyers can still continue to monopolize, whether as a moderator or as a panelist. But that was on the lighter side. Thank you so much, Dr. Deepti Mukesh, for your opening comments. Yes, of course, I think no law, at least as much as my knowledge goes, in the history of this country or the legislative reforms history of this country have witnessed that kind of backing at the political will in making the law functional, implemented with that kind of might being put behind it as IBC has seen. It's just phenomenal. And it's reflected not just in the acts of various amendments that have taken place, it's also how the stakeholders were brought together, how a narrative was built in the market that this is good, how the banks who were so, if I may say, the financial institutions of banks who were so disenchanted from the experiences of SICA and were completely disillusioned, were brought to try and experiment IBC and have shown tremendous amount of faith and continue to use it and have, of course, also benefited with it. But there is also some disillusionment which continues to exist, and we'll discuss those also. And those offer opportunities to reforms. As you all know, that every crisis, every problem offers a solution in itself, which is for the betterment. And that, in fact, leads us to one of the most, if I may say, debatable issue that continues to still haunt the market. What is the real purpose of the IBC? While the jurisprudence, the preamble, very clearly articulates that the law is meant to resolve a distressed enterprise. It is meant to find a turnaround for an enterprise by way of collective creditors mechanism. Yet, there is a shadow of doubt which continues to haunt IBC, because the narrative, which seems to be still very, if I may say, prominent in the whole discussion around IBC, is that the banks still view it from the prism of recovery. And their entire focus, attention, and even the decision making is driven by the fact that how can they maximize their own recovery, rather than focus at the long-term turnaround of the enterprise, which is not just financial restructuring, but also involves operational restructuring, business restructuring, and also management restructuring, to ensure that the enterprise doesn't end up at the doorsteps of NCLT again in the near future. So, and Mr. Swaminathan, I mean, you know that this is something which is a finger pointed at the banks. Often observations that fall from the NCLT benches as well. How do you respond to that?
Thank you. Good morning once again to all of you, the Honorable Chair, the panel members, and the distinguished audience. It's a privilege to be here, and I must thank IBBI and IMA for this wonderful opportunity. And it's really, really heartening to see not just the seniors, but also so many youngsters participating in an event like this yesterday, and as well as on a Sunday like this today. And the number of papers that are being presented shows the interest that is being shown, as rightly said by the Honorable Chair as well, in this branch of law today, because that in itself shows the future, what the future holds for a legislation like this. So thank you very much for being here, and then thanks again for this opportunity. I wish Mr. Batra was there yesterday also, because today what he was alluding to in his opening remarks prior to passing the mic to me is that there is a general narrative that the bankers are seeing this as a tool for recovery. But yesterday, if you were there, you would be hearing the other side of the story, in the sense that the bankers are not bothered about the recovery. They are accepting huge haircuts in the 90s, nothing less than that. So what the bankers are doing. So the bankers are in a very, very catch-22 situation, that you are damned if you do it, you will be damned if you don't, is where we are. But in any case, having said that, I think this kind of situation is not new to us, because we know that we are an important part of the economy as such. So we have got to take this in the larger perspective. But coming to IBC as such, as all of us know, that the basic premise of legislation like IBC is resolution. I did mention yesterday also, when I was responding or putting a query to yesterday's panel, is that we don't want that narrative to be taken completely towards recovery, while of course we have got to be mindful of recovery. At the end of the day, as a lender, that we have put certain monies out, and there are financial creditors, there are operational creditors, there are crown debts that are due out of failed firm. And while attempting a resolution, we cannot lose sight of recovery. But then I would like to make it very clear that from a policy perspective, all of us very, very clearly understand, as the Lenders Forum, that resolution is the primary objective of a legislation like IBC. So I don't think that there is any moving away from that particular point, and we will stay the course on those lines, despite the criticism either which way, that either we are being pushed more towards recovery or we are being just mindful of resolution, disregarding the recovery percentage. So that is something I think I would like to reiterate. And just to, very quickly to add one more thought to it, is that my request to the rest of the ecosystem players, including the media, is that if this pen or this phone, is damaged and no longer useful to me and consuming a lot of maintenance cost, then I put it on sale. That I might have probably acquired this for $100 or a lakh of rupees. Ultimately, when it is when it is no longer being useful, when it has stopped or when it's a failed device, I put it on sale. The money that I will realize will be purely on the basis of the demand that it can generate. So that is why you have a transparent mechanism where an expression of interest is run, even as part of the NCLT process. And it can go only to the highest bidder. If the highest bidder is going to offer only 10 cents, we can't be looking at the 90. We have to look at these 10 cents that may come to me, number one, instead of this device being completely written off by way of a liquidation. Accept the 10 cents. Is that sensible? Or keep worrying about that 90 cents that I'm losing and then keep on holding on to this and then throwing good money after bad money. That is where the lenders do take a call in terms of, we do run a transparent process as everyone follows, and then it goes to the highest bidder. So my request is that if you start building narrative towards the haircut, then it is likely that the lenders may not take any decision. And in that case, you will have a paralysis and then units will go into liquidation. And the entire objective of a legislation like IBC towards resolving corporate stress in an orderly manner will get defeated. So that's my
right.
submission.
So as I hear you, what you're really saying is this: that this is more a matter of a perspective or a narrative that operates in the market, but that is distant from the reality. In reality, what you're really looking at is a resolution, and recovery is incidental. And of course, you can't lose sight of the recovery, because that, of course, is an obligation that you have to your shareholders and stakeholders. I don't think there is any quarrel with that proposition, or that is really the criticism. But some things that we observe while sitting as an observer on the COC or advising some of the stakeholders is that there isn't adequate attention or insight applied on the other dimensions of the resolution plan. I mean, the dimensions other than the financial aspects of it. How will you turn around? Who will you bring in? What is the expertise of these people? What are your projections for the plan? Would you really be able to service the debt to your incoming lenders, even if you are exiting? Would you still continue to be a relevant player in the market? Or would you be able to sustain all this? I think those questions, as we don't see really coming in from the lenders. I think the perspective is also because of that reason, because optically, we don't really see that happen. Even though it might be being discussed back home in your offices, but we don't see that discussion taking place adequately in this use.
Absolutely, very fair point. I think it's also as an industry, we also must bring this into public domain. Some of what happens is that we are a little cagey about being open on certain things, but the evaluation metrics that are formed for evaluating the success, the potential resolution applicants, is a rigorous process, and that is run over multiple meetings of the COC along with the process advisor and the RP. And this metrics has substantial weightage towards the relevant experience of the PRAs in terms of whether their ability for the particular type of industry or activity and the time and bandwidth and money that they are willing to commit for preservation and nurturing and bouncing back this enterprise back to normalcy. And also their prior experience in terms of such turnarounds which they would have probably done. These all has got a substantial weightage, while financial also has certain weightage. I would say roughly about on a 70 to 30 is the kind of a ratio that we apply in any evaluation matrix in terms of evolving the suitability of, or I would say validating the suitability of the PRAs to the plan. And as well taking into account the financial consideration, and 70% goes towards determining what will be, to what extent the enterprise will be preserved, what extent the employment can be saved, to what extent this industry can be revived, because sometimes these can be very significant players in the industry, contributing to a substantial portion of that particular industrial activity or contribution to the economy. as lenders, we are certainly interested in preservation of this enterprise. So absolutely, as you rightly said, probably the evaluation matrix that happens in the COCs also have got to some extent, we must make it public to the extent that it does not impede the work internally. I think we must do that so that the people do understand as to why a particular plan was chosen, although financially it doesn't look very lucrative. And one more point, just with your permission, if I can add, it was also mentioned by Mr. Shriram yesterday, is also that the immediate cash recovery is one part. That is what generally gets publicized. But there are also deferred instruments, equity stakes that are being assumed, so that in the long run, if there is going to be an upside, the lenders also can be part of that. The other stakeholders can be part of that. Even they are also being considered. So we should not be guided purely by the immediate financial gains that occur, while of course that is what assumes overwhelmingly a larger space in the media, but that is not true. That still forms part of the whole process.
Right.
I would like to add one point here. When we say that this has become a recovery process and it has lost its importance as a resolution, I don't think that's the right way of looking at it. Because when we came out with the code, it was mainly to bring the debtors to come and pay their debt. So when they are paying it, it's a kind of recovery. We are not pressing for recovery, but ultimately the aim is to recover the debt or NPAs or the money which
or 60% is largely dependent on the valuations. And I think this is something which I want to come both to ma'am, you and Dr. Sani. And of course, Ms. Swaminathan and Mr. Souza, please, you also feel free to reflect on this based on what your experience on US is. But let me just please phrase my question for the benefit of your response. We all know that in the last 6 months or so, or perhaps a little longer than that, the issue of valuation has become contentious. Without naming a particular case or two, which caught a bit of a headline because of the huge amount of sacrifices the bank took, the matter even went on the floor of the parliament, and concerns were expressed by the members of the parliament, and in the report of the standing committee, that has been discussed, and we certainly see that there is also in the courts, we see the NCLTs actually asking questions about the valuations. Now, this creates a paradox for the banks because they want a resolution. They know this is the value. There is a valuation system. You bring a valuation report based on that. This is what is being offered. They are really commercially best suited to decide that this is the best way to get exit. You won't get better than this. And yet, then they are often criticized for having really let go at a huge discount. Now, this really has created a bit of a debate in controversies, and is really, even we've heard that the parliament may actually even contemplate saying this is the threshold of the sacrifices that you can make as a plan. Now, that would be unprecedented, and nowhere else in the world, at least I'm familiar with, that is done. And I think that would be a huge setback to the very character, very fabric of the IBC law. But that
to conduct the valuation as per the internationally accepted valuation standards, or as per the valuation standards issued by the registered valuer organizations. So the rule is very clear. They have to conduct that. Whether they are conducting the reports as per the internationally accepted valuation standards or not, that is a question of the review. So presently, of course, the RVOs, that registered valuer organizations, are conducting peer reviews for that. But whether that is sufficient, because again, of course, many people are sitting, MDs of IPs are sitting, and maybe many registered valuers are sitting here. So whether any further check is required on the valuers. But keeping in view the quality and quality of the report specifically, I am of the view that yes, there should be a check, there should be proper review of the valuation reports, and maybe in future an organization or an authority like NAFRA may be required for the registered valuers also, because that is the utmost important. Bankers rely on the valuation reports also, maybe fair value or maybe liquidation value, whatever is there. Because the resolution plan, or if the committee of creditors decides to put it to the liquidation, all depends upon the report of the valuation, and of course if the difference is there, and whether the third valuation report is required or not. So all depends upon the quality of the report. Now coming on the confidentiality. Now how to keep the report confidential? Of course the insolvency professional appoints 2 registered valuers and he gets the report. And it is discussed, and that leakage, basically the leakage of the information about the value of the report. So how to keep that confidential? One thing can be that both the reports of the valuers can be kept in the sealed cover and should be opened only after receiving the resolution plans and opening of the resolution plan. Before that, nobody should know that what is the value which has been indicated by both the valuers. There may be a question that in case of the difference of the opinion, what about the third valuation report? The things may be delayed. So there may be 15 days, 10, 15 days, because valuers generally submit the report. Nowadays, we all talk about the artificial intelligence, and even if the physical visit is required, maybe 15, 20 days delay. But at least we will ensure that yes, report is confidential and nobody is privy to know or what is the fair value or what is the liquidation value. Now, coming on the basically, because Mr. Batra asked me to touch upon the capacity building of the valuers and, of course, the ethics parts. Of course, IBBI has been organizing various seminars and conferences to build the capacity of the registered valuers, and all the RVOs are also very active in organizing the programs for their basically the capacity of the registered valuers. So these are the things, Mr. Batra. Thank you.
And before I'd like certainly like your comment on it, because I understand the dilemma that you face while sitting on the bench, looking at a larger stakeholder constituency than just one stakeholder, and also a degree of public interest. Because at the end of the day, when you're talking of sacrifices by publicity banks, that's a dimension that you can't ignore. Do you face this dilemma, that how do you do it? Because commercially, yes, is well held that it is the prerogative of the COC. But then you feel that it strikes your conscience sitting on the bench that, oh, it's terribly low and we need to question. I mean, how do you think? I know that you'll find it difficult to share because how your mind works as a judge is something which, of course, it depends on case to case, but we would like to benefit from how you perceive things.
Very rightly said that valuation is one of the very critical point when we decide the resolution plans. Now, at certain level, if you see, the code very specifically prescribes that if the COC, and which is also upheld by the Honorable Supreme Court, that COC is the supreme, and the wisdom of COC or the decision taken by COC should not be interfered unless something very illegal is found or somebody is pointing it out. So knowing that, or maybe having a consciously sensed that there is a much more scope for better valuation, looking at the properties, the prime areas, still there are certain parameters which are laid down that if the plan is above the valuation of the liquidation value, then by and large the COC goes for it and approves it. Now when it comes to us, it's only approved by the COC who are the stakeholders, and as very rightly said by Mr. Swaminathan, that instead of not getting anything or waiting till the property gets diminished, we are interested in at least getting something. So same thing, it comes to our mind that if something more is given in the liquidation, better than the liquidation value, and if the COC is of the opinion that something can be done or maybe the business can be revived, then in that case we have to, because otherwise beyond the scope of the code and provisions of the code, we do not have much power in questioning it. Though in few cases, some of the benches, the plans are sent back, they were being sent back, and for reconsideration, maybe considering a better value or maybe a floating EOI again to get a better opportunity for the resolution applicants or better perspectives. But now I think Supreme Court has, Mr. Batra will agree that has come down heavily that after the resolution plan is approved by COC, even COC for a reason of getting maximization value cannot relook at it anymore. So the jurisdiction is very limited to us.
True. At the same point of time, I think, of course, we all know that Supreme Court decided 2 years ago that COC is supreme, the NCLT can't go into it, and there are a number of judgments on that. But lately, one case has actually gone to the Supreme Court where the Honorable Appellate Tribunal has held that the NCLT is not just a rubber stamp. That is not what those judgments need to be read into. NCLT can ask questions. Of course, you can ask questions on the implementability of those plans, because that section 31 very clearly gives you that jurisdiction. But that observation was challenged before the Honorable Supreme Court, and the Honorable Supreme Court has actually said that we would like to consider this issue, whether NCLT is just a rubber stamp or whether on the issues of valuations in particular, can they relocate it? And of course, that issue comes from the fact that last 6 months we've seen a bit of a
Yes.
debate, and that matter is now listed for arguments on 5th of May. Incidentally, I'll have the opportunity to assist the Honorable Supreme Court on that. So let's see how the Honorable Supreme Court responds to that. Yeah.
Because one or two matters where the resolution plan was rejected only on this ground, that the valuation is very low and we don't understand how COC has approved it. So it was sent back for relooking it, and that was challenged, and that is now being considered. Because if at one stage you say that there's a maximization of value, that is the intent of the code. At the other end, you say that, okay, whatever price it comes, and if there are ready resolution applicants who are giving better price and ready to deposit the money, then is it required that we have to relook into it and consider this particular point by giving more opportunity, or we have to simply abide by the provisions of the code? So this is the question.
Yes,
Which is
Mr. Sir, would you like to share your experience on how does it work under Chapter 11? Do the courts really venture into and go into these issues of what the commercial value is, how the stakeholders are being treated, as long as the legal compliances are in place?
Yeah, so I think, based on my experience and in the US Chapter 11, valuation can be incredibly controversial. And the courts, I think, do tend to get a little bit more into it because under our system, we can have competing valuations. So we can have the debtor submit a valuation and we can have the creditors committee submit a competing one. And so we've really, I think, struggled because it's a lot of burden on the courts. And the courts themselves, even though there are formulas they can apply, there's often good reason to deviate from that formula. I think, especially when you're hearing from experts on multiple sides about this is how we got to point A or point B. And so I think it places kind of a ton of work on the courts. Our Supreme Court has on occasion waded into this, and nobody's ever very happy with what they do in terms of the standards that they try to set. I think because they feel that the bankruptcy bar sort of feels like our Supreme Court doesn't understand the nuances involved in evaluation. And so I think, from our end, I think we share a value maximization principle, but we also share that struggle of sort of how we attain that. And in some sense, the job of the court is significantly complicated by the fact that you have these valuations from experts on all sides.
Right. Well, thank you. Mr. Raman, I definitely would like your response to this, but if you could just hold in for a few seconds, because and dovetail your response into another connected issue with evaluation, which I think has a great bearing, which is preserving the value of the enterprise during the CIRP period. Because the valuers would often do the evaluation based on the asset value as on insolvency commencement date. Which is quite strange, because the fact is that you may have had 330 days plus passed and the valuation may have significantly varied from the time or the date or the cutoff date on which the valuation is done. Nobody has really looked into this, and this is something which the IBBI really needs to take it up on priority. Because in those 1.5 to 2 years, significant events might really impact the valuation significantly. And then that is left for the banks to take into consideration. But then, unfortunately, you compare that decision with the valuation report, which are maybe dated. And therefore, I think that is something which we really also need to look into it. But before I amplify that point, I just wanted to sort of reflect my view on what we just discussed on the valuations. I completely agree with Dr. Saini that quality of valuations is something which we really need to work on. If we just start putting an embargo on the banks that this is what you can, this you cannot do with the valuation, that will be barking the wrong tree. And I think that would really be tinkering with the very fundamental objective of the IBC and diluting the whole concept of COC supremacy, which I think is very dangerous. I understand the concern of the parliament, because in their Supreme you can't question it. But they just express a view and ask the executive to find a solution. They don't dictate. But the executive doesn't really have to really sign on dotted lines. They have to come out with an innovative solution to satisfy the parliament that this is the best way of doing it. And the best way of doing it is not to tell the bankers, no, you can't take this much of haircut, you have to take this much only. That I don't think is really the solution. The solution is, as Dr. Zani was rightly mentioning, improve the credibility of the valuation reports, so stakeholder confidence in that. Integrity also. I mean, I think the word integrity is very important. I mean, that's as important for the insolvency professional as the valuers, because You can keep it in sealed cover, it doesn't matter, but the fact is that the valuers know it and they know the numbers, they can pass it on, right? So that may just be, again, an optical confidence building measure that it is in sealed cover. But the fact is that those who know it will pass it on, right? And there are various ways of passing it on. And we know that it is passed on. We know how the market functions. So I think we need to improve the credibility ethics of the professionals so that they understand how important the confidentiality of their work is and how it is linked with their own reputation in the long term. And how should they guard their reputation dearly. And of course, IBWay keeps a hawk's eye on that and questions it in the event there is even an iota of doubt that it has leaked from their desk. But that's okay. Now, just coming back to the issue of valuation, the preservation, while it's easier said than done, how do you preserve the value during this? And so because it is the obligation of the IP, which is a statutory obligation. He has to preserve. The word used in the statute is that he has to preserve the value, not only protect. Now, how do you, protection is fine. I mean, I go and put guards. I mean, that's a myth. That's a myth. You put a guard, but protection is tangible, intangible, both. Preservation is the most important thing because that's where you need money. You may need to bring in bank guarantees. You may need to pay certain vendors. You may need to do a whole series of things in order to preserve the value, for which you need money. And money during the CRP can only come by way of interim finance. And that continues to elude. It is completely elusive. We can't see this happening even after 5 years. Why? Why have we not developed the market for interim finance in this country? And this is where, I mean, maybe I'll come to you first on this, Dr. Samnan, because you are both the consumer of interim finance sitting in the COC, but also the provider of these interim finance as a banker, right? In a different avatar. What do you think? And of course, you can probably link it with the valuation issue as well when you're reflecting.
Valuers are also here as part of the audience. But for the rest of the people, I would like to put some context to it. See, valuation, I think, as all of us understand, is a subjective matter. It cannot be completely driven by mathematics. It's a certain amount of discretion is involved, and the valuer is expected to exercise his best discretion in terms of expressing its value. So since it is being judgmental, it is likely that your judgment may be different from that of mine. So we have to accept that fact that if I put two valuers, that expecting both of them to come with identical number is impossible. Okay, so we have got to, and same thing applies to the IP, same thing applies to the bench, same thing applies to the lenders. Each of us have a right to have the views. Trying to bring a consensus value to this is not something which we can do. So the point number one that we'll have to understand is that valuation is subjective. Number one. Number two, in any valuations, there is a market value, there is a realizable value, there is a distressed sale value, and there is also a net present value of what you can generate out of a particular asset. These are all certain numbers we have to be mindful of. Generally, where people get really carried away is what the market value that as we see. When an asset comes to sale, it is not the same as when an asset is on a going concern basis, kept very nicely, as Mr. Batra mentioned, preserved very nicely, maintained. It may fetch as a going concern something, but then when it is not operational, the plant is shut down for the last 2 years, the valuation was taken at certain point in time. Today, the bidders are looking at and then putting their plans. Whether it will remain the same is anybody's guess. And it will vary from case to case. There is no fixed formula that will depreciate at 10% every year or it will appreciate at 5% every year. We can't put any definitive formula to that. So we need to be mindful of these various components or the elements of even a valuation report. The third, of course, a lot was said about the confidentiality. Even agreeing to an extent that the valuers maintain the highest ethical standards. And oftentimes, in some of these cases, even some of these couple of celebrity cases, as we call, which gets debated in the media, on the floor of the parliament, or maybe in IBPI, in various forums, if you really look at it, Valuations were done, resolution plans were received, they were opened, and it was found that the resolution plans were way below the liquidation value. Then the COC, in its effort to maximize the value, gives further opportunity to the potential resolution applicants. 1 round, 2 rounds, 3 rounds, we provide some time because we don't want to be doing either or, either we can accept that plan and be subject to criticism that, you accepted a plan which is way below the liquidation value. As I said in my initial remarks, it's what the other person, the buyer, perceives as the value. That is what ultimately going to determine, because that's the money he will put on the table. I may keep a valuation report worth 100 crores, but then if there are no buyers at 100 crores, what do? I have two options. Either accept that 50 crore offer and go ahead and be subject to yourself to a criticism, or reject all the offer, go into a liquidation, really test whether this 100 crore is realizable. And then it involves certain time and effort and further money to realize that. So ultimately 2 years down the line, what I would realize probably is in the future. I'm not really sure. I may get 100, may get more, may get less, or I may be spending some more money in preserving the value of this with a hope that I will get this 100, I may not get also. Right? So these are the kind of nuances that play out. So it is very easy to say that, of course, even the Honorable Bench has observed, how is this resolution value finally accepted is so close to the liquidation value? It's because if you go back in history, actual resolution plans which came in that case was way below the liquidation value. And 3 rounds were given, and finally, because by then the liquidation value is in public domain. Obviously, finally, as a buyer, this is like a Karol Bagh buying, you keep negotiating, you never know where you end up. Okay, so I'm sorry, I shouldn't have taken this much of time on valuation.
I think
but
you
I
make
thought
very important points.
taking into consideration of various aspects that was
And
said,
the interim finance.
as to the dilemma that we face in COC is what I was trying to express. And it has got to be seen in that context. So if we are able to understand that, I think we will have a better appreciation of why a particular decision was taken. I'm not trying to hold a brief for COC. COC, Dr. Saini mentioned about capacity building of valuers. It's not that capacity building of valuers alone. Even capacity building in COC has got to happen. As together with IBBI, we engage ourselves in even doing capacity building in COC so that their judgmental abilities are better, that they do it in a transparent and clear and consistent manner is what we all aim. And this is an evolving piece. So we will do. Coming to the interim finance, which again plays a very, very critical, as Mr. Batra said, critical piece in terms of preserving value. 2-3 points in terms of, number one, of course, insolvency resolution in itself, as Chair also observed, is a very evolving piece in this country. 5-6 years in a landmark legislation like IBC is very small. Legislation takes years to evolve. And this is a kind of an evolving piece of legislation. So in that, various ecosystem players have to understand their responsibility and deliver. And one such dependency is interim finance on the lenders. Now, if you see it from the prism of lenders, number one, as bankers, we are conservative people. Of course, as a country also, we are a conservative country. And as bankers, we are ultra-conservative. Now we have put certain money, taken a risk, what we thought is a fair banking risk, and continued to support that company for 5 years, 7 years, or 17 years. And finally, now the company has got into distress. And there is no certainty as to when a resolution could be happening because of the various challenges that we see as the time that gets taken for resolution. So at this point in time, will my boards or credit committees be comfortable, willing to approve or write another check of another 20 crores or 50 crores? Now the question that comes before the credit committees when the IPs make this request and the COC feels that there is a need, but then when they go back to the respective credit committees or boards, the challenge that they face is that, please tell us what is the visibility of resolution, in what time it is likely to be closed out, and what is the likelihood or possible assurance that you can give us that the money that I'm throwing now is not going to just add up to further NPA, instead it will come back to me in a time-bound manner. This particular question, oftentimes we are not in a position to answer very, very confidently. The presenters, as they come to the credit committee, when I sit on the board, I also ask the same question to the presenters who bring this proposal. So this is number one challenge, because there is no timeliness or certainty of the visibility of or visibility of the resolution plan materializing which only can result in this money coming back. It's a priority debt. Obviously, it will get paid ahead of everybody else. That's the assurance. That's a mitigation that is available. But unless we are in a position to give an assurance in terms of the timeliness of this and adequacy of the resolution happening, this particular area cannot develop. But having said that, as we have always worked on an industry-leading thought leadership position as SBI, after about a couple of years of work with all the stakeholders, IBBI, IBA, I'm glad to say that SBI is the first bank today has put a board-approved interim finance policy in place. So we have now put a matrix in place. A board has approved a policy that if a particular proposal satisfies this criteria, yes, I am willing to take that additional risk. So we have put that. Now do we expect, our expectation is that other banks also will follow. So only one more point that I would like to add is that we also probably have to look into, rather than looking into the same set of lenders who have got their money already stuck, are there any players who can come into in terms of distress asset funding or litigation finance or priority debt funding who may have a much higher risk appetite than a usual commercial bank? Maybe if we can develop that, that can probably develop as an alternative means of interim finance.
You in fact preempted my next question and answered that on the need to develop a distress asset acquisition market, distress asset players market. I would love to discuss that topic, but I think we have 2-3 very other important topics to cover, and I know that we would like to leave some time for you to ask questions. So I'm taking the liberty of moving to the next session, and maybe if a question comes on the valuations or distress asset market, we could probably respond at that point in time, maybe discuss this a little bit further. I want to discuss 2 other issues that continue to bother all the stakeholders significantly, and in a way continue to cause shadow on the whole success story of IBC. The first one is litigation. And the second is avoidance transactions not being adequately addressed. Let me just discuss with the litigation first, and I want to make 2 comments. It's because again, in a rule of law country, in a country any which way which is litigious, in a country where we are argumentative, we don't give in so easily. Litigation is a very normal choice that an average Indian makes if he has access to justice. So it is not surprising that we have applications. 2 is early days. Yes, there are bound to be requirements to clarify. But ma'am, you are probably the one who observes this as closely as anybody else every day. And I'm sure you feel very frustrated when some applications come up which are like disastrously frivolous, which are so ridiculous that you believe that this, how could you even as a lawyer file it at times, right? And then of course there are those that you believe that, how can you even decide the matter further unless you decide this issue? And how, directly relevant it is to deciding the resolution plan, or because it goes to the very root of the matter or something like that. But do you really think, and I'm articulating my question that way, because we all know that there are litigations, some justified, some are not justified. Do you think that the IBC is really facing the risk of becoming an adversarial or litigation forum? Because that is not what it is meant to be. By sheer nature and definition of IBC, it is a resolution process which you need to resolve across the table. COC is a mechanism, and RP is a mechanism, and you don't go to the court just on a knee-jerk basis or drop of the hat basis. I think that is the larger risk that we are facing. But your comments on that, please.
This is the first and last question asked to the NCLT members for causing delay. Now, the blame is always put on the tribunals or courts that there is a delay in dispensing justice. I would like to very interestingly quote 2-3 things. Recently, our Honorable Chief Justice of India, in one of the speeches, he has mentioned, in this era of instant noodles, people expect instant justice. But people don't realize that the real justice will be casualty if we strive for instant justice. I think this is self-explanatory. I need not take much of time. You all aware about it. In a democratic country, when there is a statutory right to a party given by the legislation to seek justice of the whatever injustice you are facing or reliefs which you want, can you prima facie on the first stage stop anybody from filing application? That's my question to the probably entire nation. If we say there is a delay because of applications, who is filing applications? It's the people who are filing application. And secondly, we say that they are frivolous. What stage we understand that they are frivolous? Only after adjudication. Unless we address the application, unless we see that prima facie in law, they cannot file application, which are immediately rejected. So it's not that the judges are not aware. Right from the civil courts to the criminal courts, if the application is without any backing of law or not maintainable under law, they are immediately rejected. And in fact, now the trend has started that we put heavy cost in order to discourage such kind of applicants coming and wasting our time. But can you say that by and large, blatantly you can stop bringing applications because we want early resolution? We are resolving an industry which has hundreds of paraphernalia and hundreds of consequential effects on various classes of maybe people, maybe vendors, maybe the creditors, lot of area. It's like you tell a doctor that a chronic disorder or a disease, we will give you 1 month time and you cure it. Can we say that? It's a kind of a disease or a disorder in society. Now, if you go back to the old laws, which were made in 1909 and 1920, almost after 100 years, we have thought of bringing a new code in insolvency regime to bring out certain changes. And within 5 or 7 years, we want to see remarkable changes in spite of accepting that the recovery or the money coming into the economy, the NPS going down, the banks, Mr. Swaminathan also said that we understand that the recovery is much higher. Even the government has recognized it. So we cannot say that overnight it will happen. And if we are sitting there in the bench for doing justice without hearing the other side, because there are times when we hear the applicant, senior counsel completely and we are almost deciding the matter in their favor, but when we see or hear the other side, when we see the documents, it changes the perspective. There are a lot of social factors which are there. There are a lot of parties which are there, which are affected. You can't ignore them. It's not that, okay, you have not paid the debt. This is a stick. Either you pay it or you are debarred from taking management or you are put in jail. We are not for that. And insolvency is not an offense. We have to understand one thing. It's not an offense. If we want to cure, it's a financial crisis or probably financial disorder. And any disorder, when it comes to our life or when we recognize that there is a disorder, by the time it has got long based roots. So to cut the root immediately and bring the justice instant, it's not possible. In fact, in one of the speeches, the Attorney General, Mr. Venugopal, has said that out of 24,000 judicial posts, 5,000 judicial posts are vacant. So again, the question is that, is the judges are incapable of giving justice or are they delaying? My question is to the people. Those who say that there is a delay, of course, the court for the first time has come out with a timeline to decide certain process. Court has never said that you decide application in 5 days. It can't be done and nobody can do that. If you want to do justice, you cannot have a timeline. Only thing is that we have to educate people not to come with the frivolous applications. The trend has already started. We are putting heavy cost. When some frivolous applications come, we debar them from coming again. So strictures are passed. It's not that the measures are not taken. And I'm sure that no judge would like to delay it. Plus, we cannot always think that Western countries this happens, in the other countries this happens. We cannot compare because they are totally different countries. One religion, one language countries will not face the problems which we are facing in India. At different states, you will have different language problems. Even the members, when they are transferred in a different court, the member going from Chandigarh to Chennai will have difficulty in going through the papers. How do you expect the instant justice or instant resolution? So all these factors we have to consider, and I would rather suggest at this panel and to all those who are present here that we always cannot compare that anything with the Western countries or anything with the other countries, because India is multi-regional, multilingual, multi-geographical dimension, the multi-religious countries, and a truly democratic country where every citizen needs to be heard. So in that country, you can't have anything instant.
Right.
Moreover, rightly, I would like to again quote our Honorable Prime Minister Modi ji in recent conference of all the chief ministers and
Chief
yes,
Justice.
justices, he has very rightly mentioned basis of Swaraj in any country is justice. Until basis of justice is not understood by common men, it will not be of any use. So we have to decide, do we want to show the figures that in this years we have recovered this much, we have resolved this much, and those resolutions then go in appeal and stand in Supreme Court? Or do we want to take some more time and go to the root cause, address the common persons? In fact, here, this is a forum where I would like to say that we have still not touched the issues faced by the operational creditors who are totally neglected and not paid even a single paisa in all these recoveries. The traders, vendors, day-to-day suppliers, the partnership firms, the individuals, those who are insolvent, they are there already in existence. We have not even thought about them. So we can't hurry up like that.
You're right, ma'am. I mean, I understand what you're saying.
Yes,
I
I
know.
take your permission for only for 2 minutes.
Only
Of course,
2
doing
minutes.
a rejoinder to the
two-
chair.
2 minutes.
Yes,
2
exactly.
minutes.
But doing a rejoinder may result in contempt, but then being a fellow panel member, I think I'll be given immunity. So it's not my...
more than 2 minutes. Mr.
Only 2 minutes.
Yeah.
I think I just want to put the contexts again in one is the delay part, another is the forum shopping. So what we are genuinely worried about, ma'am, is the forum shopping that people do. And we know that this legislation has a clear NCLT, NCLAT and a Supreme Court structure. And as we sit in this noble state, so we know that the high courts here do entertain petitions which would like to stall the proceedings in the NCLT. And even today there are cases that are pending. So and then there are cases which are pending for admission 3 to 4 years as on date. These are some unique cases, but people have used all possible forums available at their disposal to delay even the admission itself. Well, of course, we are mindful of the pressure under which the judiciary is working, given all the limitations. The only worry is the forum shopping has got to be stopped somewhere so that people are not allowed to litigate on the same issue multiple times in multiple forums.
Right.
That's the only
I
submission.
mean, I
that
think
would-
that's a point well taken. At the same point of time, my view is that forum shopping is an aberration. I don't think that's a norm. Only a handful of those resourceful people who can afford to hire lawyers and go litigating elsewhere, they do it and they will continue to do it. You can't stop them. I mean, that's the historical aspect. But yes, I mean, I think the focus, as I hear both the Dr. Deepti Mukesh and Mr. Swaminathan, is that you can't stop people from going to NCLT. You can't curb their rights. You can impose costs and deter frivolous litigation. You can report those cases widely so that people know that there is a consequence of filing a frivolous litigation. But we need to find something else as a solution to reduce the workload. One is, of course, appointing more members, but that still may not be adequate enough. Because there are so many issues, then you have to provide infrastructure, then you have to provide so many things. There are challenges. Mediation is one important aspect, which I believe may be a very important tool to reduce the workload, where some of the issues which are really on the sparked on the sides go on the mediation, come back after 20 days, 30 days, 50 days. And I'm sure IBB is doing this as a subject for standalone discussion. I don't want to take it up now because then we will lose the time to discuss some of the other topics, one of which I want to discuss before we open it for question and answer session. And that also only for the next 4 minutes. Because something which I've probably taken the liberty of mentioning, because this is something which we face every day is avoidance applications. We all know that we haven't really had many adjudications and avoidance applications. And I won't really blame NCLTs for that at all, because they have to prioritize other matters. Avoidance can be dealing from the resolution plan. But the fact is that should we have an alternate mechanism for this? Should we have special courts, special benches? Because this often may require even cross-examinations, because you are really, the consequences of penalizing somebody, clawback huge amounts of money can't only be done by way of a simple order. It'll keep going in appeal and get tested at the Supreme Court at some point in time. We haven't really seen a test case as such so far. But we really need to pay some attention to this aspect. And I request, ma'am, your 2 minutes on this, and maybe Dr. Su, your 2 minutes on this. And of course, we all know that maybe last comments we will probably. Just 2 minutes on this, because I know that
Very quickly, I'll say that avoidance applications, the applications filed under 43, 45, 66, fraudulent and avoidance applications are maximum consuming time, because there are number of respondents. Maybe it goes up to 80, 120. So receiving the documents from them, going through the documents, it takes huge time. And what we can do, very rightly, Mr. Batra said that ultimately when it is decided that the avoidance or the fraudulent transactions money which is recovered or which will be recovered will ultimately not affect the resolution. It's a parallel proceedings. Even after liquidation, before dissolution, these applications can be heard. So the money which is coming from these, by passing order in these applications, if it goes to the original stakeholders or the creators' benefit, then side by side these applications, probably we can have a structure where these applications can separately be adjudicated along with the resolution going on, so that resolution doesn't get stalled, and the complaint by the financial creators that our resolutions are getting delayed probably can be addressed. But some of the claims or some of the issues which needs to be decided first, like constitution of COC or whatever it is, that has to be decided first before the plan. So that is how it goes.
Mr. Sudaman, I know that US is a very sophisticated, very well-developed market, and but avoidance applications probably don't take as much, because when they get decided, the costs are so high that people don't indulge in that, and I believe they get settled across the table also most of the times before being led to court. Would you like to make a couple of comments on that?
Yeah, so I think that's exactly right. I think a lot of the times you do see settlements just because the cost is so high. And I think part of what we've struggled with in the US, I mean, at least a little bit, is kind of on a similar vein, sort of the extent to which we want to incorporate avoidance actions into the process, how we can decide these issues without sort of delaying the main procedure. And one of the things that we have, I mean, just to tie back into a comment that you made earlier, is, you know, we have started to send a lot of these issues out to mediations. And so thinking about how that can possibly play a role, I think could be something valuable in terms of just thinking about, you know, sort of easing the, you know, the burden on courts and on their dockets, because I know they have avoidance actions have the potential to take up a lot of time, and if you can get them into a settlement, whether through mediation or otherwise, you're going to be, I think everyone will agree, you know, eventually that you're going to be better off.
Well, thank you. My request to IBB, unless of course this is something which is already on their radar, is that to please commission a paper on assignments of avoidance transactions and do an international study on this, because assignment is also something which will take the burden off the lenders, because if they can get an immediate discounted value also, the NPV value of that is quite high. And also the fact is that they can actually, loss of opportunity also is addressed. And then you develop an alternate market for debt trading on that as well. So this is something which also needs to be done, because it will take away the immediate urgency from that, reduce the workload, and also build an alternate market for more players to come into the ecosystem of IBC. This needs to be something which I think needs to be there. Now, I know that I got a mic at 9:35, not at 9:30. So, I would still, take the liberty of asking a few more questions than what normally would leave for a panel. Let's just have another 20 minutes of Q&As. And of course, in that, we will make our comments as well, so that we are not just responding to what we think are the issues, but also have the opportunity to reflect on what you believe as market players that you would like to hear from such an esteemed panel that you have here?
Before we start, lastly, I would like to say one line that companies' mediation and conciliation rules provides for such kind of a panel. The regional director under MCA has started taking steps, and the Honorable President, Mr. Justice Ramalingan, in the one of the colloquiums has said that this will be a priority. We will be looking into it. We will be going for it, as well as we are going to take help of the artificial intelligence in order to decrease the delay and simplify more process. Where it can be done by artificial intelligence, we judges need not spend our time, so that we can give more time in disposing of the applications and dispensing justice.
And also, since that colloquium, the cause list has been restructured, and now the fresh admission cases are listed first, then resolution plan approval applications are taken up, and then miscellaneous are taken up. That practice has started in the last 3-4 weeks, which is also helping the moves things faster. Now, I mean, I don't know who is going to be coordinating, who gets first, or do I have the liberty of deciding who raised the hand first? Please introduce yourself very quickly and keep the please question, no comment for the time being, right? So please, and make the question also very crisp, short, so that please. Thank you.
Sure, thank you so much. My name is Vikash Goyal. I'm a registered valuer, also a PhD research scholar from Kolkata. So one of the things we spoke about valuation as one of the important areas. From an operational standpoint, a registered valuer scope is defined by the resolution professional. And in majority of the cases, the resolution professionals do not ask us to value the enterprise. So the scope is limited to only identifying the fair value and the liquidation value of the assets which are already there in the balance sheet. Is there a view that we should also consider calculating the enterprise value, so that at least the intangibles can be taken into account? What happens if the resolution plan is already there in place? So there's no one doing that at the moment.
Dr. Sani, would you like to take that?
Right now, I don't think this is the thing. But as the valuation is actually done as the fair value or the liquidation value. But if suggestion is there, that can be actually given to the Ministry of Corporate.
My personal view on this is there is nothing that stops you from doing the evaluation, because when you do the assets, you do include in that tangible and intangible both, and the sum of that is the value of the enterprise, in my view. There's nothing that stops. In fact, there's no bar, and also I think you need to read it in a way where you are ultimately giving a value which is a net value broken into asset value, tangible and intangible. And therefore, that is an innovation that the industry needs to bring forward and do it. I mean, I don't really see that how that is a restraint at the moment. At least that's in my perspective. Yeah, please. We'll allow you another question later on, please, but because there's so many hands up. There's a gentleman here. Just one second. The gentleman here. Inko dijiye, please. Gentleman in the front, if you don't mind.
I'm D.Y. Chaudhary, I'm MD of NESL-IU. So I have 2 questions. The real test of recovery versus resolution for a banker is whether the existing bankers continue as part of the resolution plan. It has happened in a few cases where existing bankers continue to lend the new entity. But it is generally an exception, not the rule. Most of the time, the existing bankers exit. So if the existing bankers stay on, existing COCs stay on, so there's a scope for them to, have some benefit from the upside in the firm when the firm recovers.
I don't know if that is a question, but that's on a case-to-case basis. I mean, you can't generalize that as a rule. I mean, it'll depend on whether there's a trust deficit with the management, whether they really see potential in they see that sector going forward or not. That's an individual decision of that particular lender, is how I believe it. I mean, can you generalize it in that sense?
No, I think it's well responded. Essentially, the source of finance has got to be arranged by the successful resolution applicant. It's ultimately his choice. So I'm sure that he will be approaching the lenders. He may as well approach the existing lenders, or he can approach anyone else also, depending on his own banking choice. So we can't generalize that existing lenders should participate. The second is that your objective of that proposition is that whether bankers can be participating in the upside. The answer is no, because that will be a completely new lending relationship. Under new terms and conditions, those credit facilities will be extended. So if there is going to be enterprise doing very well, I'm not going to have a right of recompense of what I lost in the previous resolution. I will get my new money back with whatever new terms and conditions. But the successful resolution applicant is not going to give me anything extra for what I lost in the earlier one. It's not like a right of recompense that available in a restructuring.
That's
So
true, that's
it's not
true.
going to help
Yeah, that's
us
true.
even if achieved.
Okay, Jans, one question here. आपके लिए, please, and then we'll go another question. Okay, I'll come to you after this, please. And the second mic can go there, please.
Yeah, good morning. And my question is to Honorable Member NCLT. This is regarding admission of CIRPs. So as we have already discussed, a lot of delay here. So basically, the admission required to be only three aspects. It's a fact-driven kind of a thing, where you have to just check on three things: debt, default, and limitation. And you also said that you will be using artificial intelligence very shortly. And now there is a provision for IU certificate for default. So I want your opinion that can we cut down this delays, because this leads to a loss of value because of delays, as sir said, almost 2 years, 3 years in admission. So can we handle this delay?
Very quickly, I'll say that the major cause may be pandemic. I'm sure that this is not because of the delay at the level of NCLT. Probably prior to pandemic, we did not hear about such delay of 2 years of admission. Number two, if the applicant is not vigilant enough, sometimes it happens that applicants don't appear. 3 days, 4 days, and then ultimately we have to dismiss it, then come and revive it. So the entire process, nobody sees that how the matter is moved. Number three, I would say that debt and default, yes. But if the notice is issued, the other side has to be given chance of hearing. Because in hurrying up, we should not lose any genuine person to right to hearing. So when we are doing justice, we need to see that certain laws of natural justice and equity has to be followed. And number four, there may be few cases where the applications have been delayed for such a long period. But again, the inflow of filing of applications is such a huge, like in Bombay and Delhi, in spite of having 5 and 6 benches per day. If you have 100 applications, how many can be listed? So there is a delay in listing application because of the huge inflow, and the resources available for addressing those applications is very less. One member taking 2 benches, 3 benches. So again, how much you can attend? It's not that it's deliberately done or it is done because of some infrastructure problem, but these are the practical problems. Mainly this is because of the pandemic. It might have happened because there are a lot of other issues at the NCLT level which we need to address, infrastructure and the other things which the Honorable President is very seriously looking after, and he is very much into removing all the obstacles which are coming in way of the fast disposals.
Right. Yes,
So I can assure.
And I think the results are quite visible and obvious in the last 30 days. We've seen there is a sea change. I mean, we can sense it. We go to court every day and we can sense it. The gentleman at the back, no, just the one who has the mic. Yes, please ask. Yes.
Good morning, sir. So I am Ishan Japuriar. I am a final year GIP student. My question is to the Honorable Judicial Member. Ma'am, so from the data that we have sourced from IBBI, it appears that the average time taken for admissions is around.
So that question has been asked
No,
already.
sir,
Please don't repeat the question. No? If there's anything else, please ask about it.
No, so my just prima facie question was, is passing ex parte orders and allowing like a limited time frame that only for the initial 30 days objections to the admissions or to the approval of resolution plan
That is
can be
done. That
Could,
is-
could that be
that-
done
that
as
is
a
done.
suggestion?
That is done.
is done, yeah.
In my court, not more than 3 chances.
That is
In
done.
any application, in any matter, anywhere.
Just
Third chance,
no,
right to
just
file
one
reply closed, matter closed, ex parte orders passed.
I
Then
need to
they
come
come
back.
and challenge. Then revive it. Either they go to appeal, get it revived, then they come back. So that can't be stopped.
Yes.
It is the people who have to think that they should not come in such a litigative manner
Right.
if they want resolution.
All right, please.
Yes, good morning, and first of all, thanks for the wonderful session. A quick point to Honorable NCLT member in respect of unburdening judiciary. So, quick thoughts, if you could express your opinion. One is that could the procedural matters be delegated to the registrar level rather than coming to the judicial level? And the second, since IP, insolvency professional, is a officer of the court, can some work to make prima facie opinion or first level of scrutiny can be delegated to IPs? Any scope and the future direction on that?
Regarding the procedural part, it cannot be delegated because whatever is done at the registrar level, like filing of the pleadings and completing of the pleadings, at certain level when there is a huge delay, it's been done. With the artificial intelligence, we will be able to cure it probably another in few months. But where the judicious application of mind is required, whether such right can be availed, like for filing additional document or filing any IA, that right has to be given to a judge. That cannot be delegated. So under law. And number two, the IPs, they are already officers of the court. At many levels, they do a lot of work of scrutinizing, like admission of the claim, then verifying the claim, and all that has been done. But when the question of law comes, it has to come to the court.
Right. And if I may just add two comments. One, to your first question, that in fact is a decision which the central government can take by way of amending the rules if they decide that the law of the country permits that certain function which currently falls within the domain of the judicial bench can be delegated to a registry or not. That's a choice that they have to make. And that too by testing it against the law of the land, as the honorable member was saying. And as far as the RP is concerned, again, the same issue. In the personal insolvency, you see that the scheme is that the RP is given the opportunity to report. And that also raises a lot of issues. So I don't know whether that is something which the legislator is willing to do, because they made a conscious choice of not giving that function to the RP in the CRP process, but chose to give that to the RP in the personal insolvency, because the dynamics of the two and the characteristics of the two are very different. And so it's also to provide access and speed. So these are the aspects, but I don't know how feasible it is for that. But yes, I mean, there are policymakers in this room who are listening. It is for them to relate to the right forum. Yes, please. Yes, the lady. Yes.
Since we know that the valuations are not up to the mark, we are receiving the valuations very low, or either the resolution plans are very near about the valuation. So should we share the valuation with the COC and let's have the discussion on it? Make it a public, instead of like we know that sometimes the resolution plans are very near to that valuation. Somebody is able to know that valuation or through. How about sharing that valuation with the COC during the process? Transparency in the process.
Yeah. See, but I no. Again, from an objective purpose, as you look at it, is that going to resolve the issue of controversies that typically surround valuation? My sense is that no. Whether you share it with COC, don't share it with COC. Even the couple of cases which became so much controversial. If you have seen that, it's at a stage where the COC came to knowledge, and thereafter plans got improvised. So I don't think it's going to remove. What will probably help is, one is in terms of, as Dr. Saini suggested, kind of a better template for the valuers to demonstrate, and a skill building for them to make a fair valuation of their task, and then maintaining a confidentiality as required. Certainly these matters require confidentiality, because we don't want the potential resolution applicants to be guided by the valuation that is available. While of course a decision will take both into account, but we would like these two to be segregated as much as possible. So making it public, if something has got to be a secret, that has got to remain with me. The moment I share with the second person, it is no longer a secret. So sharing it to COC, I don't think will remove the difficulties that we are currently facing surrounding valuations. The third and most important factor, which again I would like to reiterate, is resolution plan being around the valuation should not be as much of a surprise to all of us. If, as again giving the example of the fair value of this is 20 rupees, I'm sure anybody who is wanting to buy also will quote 18 rupees or 22 rupees. We can't expect that the potential or probable value of this is 20, but somebody will come at 40. Unless the valuer has done a serious error in terms of putting 20 rupees to it. So the resolution plans will surround valuation, because potential resolution applicants also will have their due diligence and valuation mechanisms.
Just one
I'll
line
take
I
four
want-
more
one
questions.
line I
Just
want
one
to-
second. I'll have to give to maybe later on. I'll have to four more questions. I'm just going to come to it. But before that, I just want to make that I'll end this session with each of the member asking each of the member of the panel one reform that they feel is a priority at the moment. Yes. So please think about it. I'll go to that lady first. I mean, I can't be then not be blamed for not giving equal representation. Yes. Yes, please.
Though this is about the litigation timeline, I have, it's a question basically, but it's a suggestion. When IBC is a time-bound program, the courts cannot work in a timeless manner. In fact, I am a victim of a case where more than 700
Ma'am,
days
please,
of-
not individual cases.
Okay, sure.
Yes, yeah,
sure.
please, not
Here,
individual
my suggestion is that the day one hearing case and the day 700 hearing case should not be put together and lose its sanctity. Instead, wherever, based on the timelines, can it be sorted in the court level so that, some timeline, we are conscious of the timeline in hearing the case and
I think we've got
disposing it off.
Yes.
That's the suggestion.
Just to summarize that there is already a listing year-wise. We list all the matters of 2017 first, then 18, then 19. 22 is given the last chance because the pleadings needs to be completed. We are giving not much time to complete the pleadings. Another hurdle which we have faced is that e-court and e-filing. In the year 2019 December and 2020, when the e-filing started, there are a lot of technical issues, and unless both the filings were complete, we could not take up the matter. It was very fortunate that we could do e-filing prior to the pandemic, so that during the pandemic we could have the video conferencing courts and dispose of lot of matters, probably equivalent number of matters, which we could not have done without e-filing. So the government's emphasis on completing e-filing. So there are teething problems are always there in all the systems, in all the law, and misuse of law is nothing new to us. There are some section of people who are going to misuse it, but then we have to have some patience. It is being improvised at every level. The participants and the interested parties are coming up with new ideas, but we have to have some patience. It can't be instant. It can't be fast food.
So, and not on delays, please. I mean, so we've addressed enough on these, please. Yeah.
It is not on delays. I mean, my question is related to the remarks and whatever you mentioned regarding the preservation of the value and erosion of avoiding the erosion of value. This is a practitioner's issue. And I related this to, there was a circular from IBBI which said that the COC, members of the COC who present in the meeting need to have the authority to take the decision. In my view, it is not happening. I mean, SBI could be an exception. I have never had any problem with that. This is not really happening because there are occasions when the e-voting time is requested for 7 days and some extensions are requested for another 3-4 days. So it is defeating the purpose. And
I understand that, but I want to discuss larger issues, not these operational issues, because every case will have an operational issue. But I certainly want to take one point from there and mention, and this is for the ears of the IBBI representatives here. The point that I made of erosion of value during the CRP process demands that if the COC and the IP feels that he should carry out a revised valuation to capture the right valuation, that should not be seen as contrary to law, because I'm aware that in certain cases, IBBI thinks that no second valuation cannot be done. And I think the market dynamics would often require that if a passage of time has happened, you revisit the valuation. That can't be seen as a violation of the law. But any which ways, I mean, that's the choice that IBBI has to make. Sir, here, one question here, and aap puchiye, please. Aap puchiye, then we'll come here.
Good morning, everyone.
नहीं सर आप एक मिनट पहले उनके पास माइक है उसके बाद सर आपके पास आ रहा हूँ मैं.
Good morning, everyone. This side advocate Dheeraj Garg. Sir, my question is, on the one side, we emphasize on the mediation in the CIRP. On the other side, we try to emphasize that the early CIRP initiated would bring value maximization to the corporate debtor. Don't you think reading mediation and conciliation into CIRP will kill the time for early admissions of the cases, and then another Pandora box of rejections of a mediation process or mediation proposal will increase the burden of the NCLT?
No, according to me, being a trained mediator from Bombay High Court and having done a course and having a diploma, I would say that mediation will not waste time unless the parties want to waste time. Number one. Number two, lot of issues are settled at mediation level because basically nobody wants to litigate. People have now realized that the litigation is a costly affair. It's only for the rich people, not for the small entrepreneurs and the operational creators. So matters get settled, they come across, they come out with the real issues. Whereas when they come in the court, they come with the legal issues or some technical issues. And mediation is always win-win situation. So whatever is decided in mediation generally doesn't go in challenge. It's an one-time settlement and end of it. Whereas in litigation, whatever order you give, it will go to appeal, no end to it.
Absolutely, and mediations can be invoked at various stages for various issues, not just at the pre-admission stage. And in fact, the Prime Minister said that, in fact, in the first term of this Modi government, and also reiterated later that the future is mediation. And the sophisticated economies around the world, US, UK, Singapore, Australia, all of them use mediation significantly in the insolvency process and successfully. So what is stopping us from doing that? I did hear that there was a move by IBB at some point in time to set up a committee on this, but I hope that is expedited. And I know this is a stakeholders issue, whether mediation is a corporate affairs issues or a finance ministry issue or a law ministry issue, but I think all of that can be resolved. And maybe Dr. Saini may want to make a comment on this. Quick comment.
Yeah, actually this has been discussed, and I think the bill is already there with Ministry of Law, and if something is to be done, that can be done at their level.
All right. So एक सवाल, last question.
On the same mediation from the US perspective, what is the scope of work and how do you feel? What is the success ratio? Because it will, if we implement in the had a lot, discussed a lot, would like to hear the US perspective about the successful and scope of mediation.
So basically what it's asking was the experience of mediation success rate in the US.
Yeah, so I actually will be presenting a paper on this afternoon, drawing from some recent US cases. So in general, mediation is viewed very positively in the US. It's very considered very successful. We've hit a few roadblocks, I think, recently because we've had some mass tort cases that have come in where the parties have been a little bit more litigiously minded. There have been more personal feelings than we would tend to see in a corporate case. So that has thrown somewhat of a wrench in, but I think overall, it's been a very positive experience. And so that would be, I mean, going to your last question, that would be the reform that I would want to see.
I'm going to say that maybe, so I take it that you've already said that mediation is one urgent reform that one would expect.
I do. I think, I mean, obviously I'm a bit of an outsider to the whole process, but given what I've heard and given what
I would
I've
echo
seen,
it. I would echo it for you.
I think it just seems very important, at least as a focus. And I think one of the things that I wanted to, that I'll discuss further this afternoon is kind of when you're thinking about mediation, sort of the importance of developing an infrastructure and a framework, because one of the things I think we've done not so well in the US is kind of, we've done a bit of an ad hoc process. And it's worked out okay, but I think we could do better.
Right. Dr. Sen. सर एक परसेंटेज का वो पेपर उनका प्रेजेंट कर रही हैं, आप उनका सेशन अटेंड करिए. Dr. Saini, once anything, I know for you there'll be probably so many because you're an insider, but now you are an outsider, you can say.
Yeah. Since you asked for the reform, only one thing I would like to tell, of course, based on the data, since the voluntary liquidation proceedings are not adversarial proceedings, and of course, with the permission of the ma'am, I would like to share some data. As on 31st March 2022, 644 final reports has been submitted, and out of that, only 320, approximately 50% resolution orders have been only passed, so 50% are pending. And actually there is a process under the Companies Act also, and if assets or liabilities are equal or assets are able to meet the liabilities, then STK2 can be filed and Registrar of Companies can also strike off the company. So likewise, there can be an administrative process for volunteers that will actually reduce the burden of the Honorable NCLT and save the time.
I think Dr. Saini, that's again something IBPA should be listening as to whether we can really tweak the law on that, because this is a subject I know you wanted to discuss, but unfortunately we didn't have the time on our side for that. Ma'am, what is it one thing that you would
One
like-
line, yeah, one line that in the US and Australia, I suppose that before the case goes to the court, a lot of time they send it to the mediation center, it gets settled, and that's how the number of litigation coming to the court is so low, and that is why the disposal is more.
Right.
This is where exactly we have to put our stress on, that if we mediation, if we can resolve it, and mediation, whatever resolution or whatever final agreement, consent agreements, it doesn't get challenged.
Right.
So
Right.
there's no.
So my vote is also for the mediation. So there's 3 already out of voluntary liquidation, which also, I mean, you would also have my vote for that also. Ms. Swaminathan.
Certainly, of course, my vote is also there for mediation, no issue. But then since we can agree on that point, and
Unanimous.
of course, one, in terms of your question as to one, of course, there are several reforms under discussion, as you know, but then in terms of prioritizing, if I can say, let's make the admission process a lot more objective, give extra wings to the information utilities. If there are going to be prima facie evidence available in terms of the document produced and as available with the information utilities are there and a default is established, let's make the admission as quick as possible without giving a lot of time being spent on the admission stage. If we could do any kind of change in rules or process which can facilitate that, that will be good. The second request that I can add is, once a resolution plan is approved, the order by an adjudicating authority is something can be a time-bound activity. These are only 2 requests that I can make.
Both the things are being
when
addressed.
the patient is on the table, we don't have a control.
Very well. Very well. Thank you so much.
Admission and
We finished dot on time. I got the mic, as I said, 5 minutes later than the scheduled time. I ended exactly 5 minutes after the scheduled time. Thank you so much for your attention. Thank you so much for your interest. And I have to thank everyone on the panel for their very valuable contribution, comments, and also above all for sticking to the timelines, being very short-stripped, and also bearing with me because I was always constantly pressing my phone as an indication, and also constantly, bringing my mic more close to my mouth so that they know that I'm wanting them to stop. But thank you so much. I appreciate it very much, and thank you for inviting us. Thank you for inviting me.
Thank you, sir. Thank you, esteemed panel members, for covering a lot of ground and building the narrative on pressing issues, which I'm sure are being discussed by all stakeholders in various forums. May I now request Mr. Amit Pradhan, Executive Director, IBBI, to present a memento to our panel members as a token of our gratitude and appreciation. Sir, I request you to please present the memento to Dr. Deepti Mukesh. Dr. Deepti Mukesh. May I request Professor Laura to kindly accept the memento? May I request Sri Sumant Batra to please accept the memento? I request Sri J. Swaminathan to please accept the memento. I request Dr. Navrang Seni to please accept the memento.
At least we can say this was a timely started and timely ended session, no delay.
Thank you, sir. Thank you, ma'am.
Just 1 second, please. Please be seated. Just 1 second, please. May I request all the presenters, please submit their claim reimbursement form, as well as please give us the consent from either yes or no to publish the papers, final papers, as you have a special journal. Please, we have received only 10 such consents only. So kindly, please submit at the reception desk. Thank you, and please join us at tea at the outside. Thank you.
second panel discussion scheduled for today on the subject insolvency and bankruptcy resolutions. I welcome our esteemed panelists, Dr. T.K. Vishwanathan, Shri Bhairam Vakil, Professor T.T. Ram Mohan, and Shri A. Unnikrishnan. The panel discussion will be chaired by Dr. T.K. Vishwanathan and moderated by Shri Bhairam Vakil. Just for information, one of our panel members, Shri Anurag Das, the MD and CEO of International Asset Reconstruction Company, he could not join us for the panel discussion today. So I request, sir, to please proceed with the panel discussion.
Thank you. Thank you to IIM for being such gracious hosts, to IBBI for this terrific conference, and it's superbly organized. And to all of you, I'm surprised if I'm right, then this is the last panel discussion. So to have a full room is very gratifying. And the least we can do, even though there's a really august panel members, is that we will, give you all half an hour at least for questions. You all have been such patient listeners. So now, it's your time to speak rather than only us speaking. So I truly have, a great honor. Mr. T.K. Vishwanathan is the godfather of IBC. The only reason we broke all records, 13 months we completed the law start to finish. Even Singapore took 3 years. Not often that we move so much faster than Singapore. Was thanks to his stewardship and intellect taking us through the process. And then, of course, we have Professor Ram Mohan, who I think needs no introduction, another huge stalwart. And I have to say the economists on the BLRC were, the ones that gave us a lot of very valuable input. And last but certainly not the least, Mr. Unnikrishnan, who is the chief legal head at RBI. RBI, as Mr. Vishwanathan will confirm, played a stellar role right from the inception. In fact, the then governor, Dr. Raghuram Rajan, even hosted us and attended quite a few of our deliberations. And then, as was discussed, a lot has already been said yesterday. But right from day one, when IBC was done with so much effort and speed, it was hardly being used. The only bank that filed it in those days was Innoventive, ICICI. So then the government and RBI had to jump in. You all know about the first 12 cases, and they were the largest ones. So it's quite rare that a new law is hit with the largest cases, all in several billions of dollars. And the great thing, of course, we have to be critical, but sometimes we should also be appreciative of all that has been achieved by all the stakeholders, united in purpose. So we achieved a lot, including, I would say, NCLT, NCLAT, all the way to the Supreme Court, that the jurisprudence that was developed in those first 3 years because of those very complex and huge cases, I think normally for any country, it would have taken at least double the time. So we should now take benefit of that jurisprudence. In many ways, it's like people say a silver lining of this awful COVID problem has been that digital India has done in 2 years what would have normally taken 6 years. So it is literally in the same way if you go through the jurisprudence all the way to the Supreme Court. So those things, with all respect, I would tell the judicial members that they don't need to regurgitate those issues. However, it is actually a large measure of blame is on my community, because it has become such a lucrative area of practice that you have the best lawyers in India who are fighting these cases. And therefore, sometimes NCLT, NCLAT, etc., give them too much respect and patience, especially patience. Of course, you deserve respect, but you can't go on and on listening for days on a point that has already been decided by the Supreme Court. That's my point. So it is, Sumant said that we should not talk about time, but the problem is, and I'm sure Professor Ramon will elaborate on this, there is a direct nexus between time taken and recovery. So you cannot lose sight of that. Time is of the essence. This is an economic law, and you have to keep it. I'll just end by saying you have to keep it simple. We took a lot of pain. We could have made it much more complex. We were talking about a different class of creditors. We saw in US and UK there was massive litigation on classes of creditors. So we avoided that. It's not that we were not aware of it. So we have tried to keep it simple. The processes and procedures are detailed. IBBI done a tremendous job. So there really doesn't need too much application of this natural justice and long hearings. It's you just see what the procedures are. It's like a referee. You don't become a player in the cricket match. You're like a referee. You see the procedures have you adhered to, you move on. I mean, admission was supposed to be 14 days, not 700 days. So I just wanted to reiterate that. That was the idea behind the government's idea of coming up with this was purely to get speed, recovery, maintain jobs, and, obviously create a healthy environment across. So with that, I'll just dive. Sir, would you like to have some comments, please?
Thank you, Behram, for the setting. You described how we did that in 14 months. Let me first start with how this week envisaged. There's a lot of history behind it, and I am really the only continuous link in this process for the simple reason. Very rarely a draftsman of a bill gets an opportunity to defend it till the end of its life. It has never been the case. But I had the opportunity of defending 2-3 acts, and this act is very different type of a code. I've always been saying that this Insolvency and Bankruptcy Code is a jewel in the Indian statute book. Why? I've been in the Law Commission as a member secretary. We have done a lot of research, and I've been a legislative secretary. I have drafted many legislations for more than 3 decades. And I have served all the political masters, and I was a law secretary defending the government. Then I was a secretary general of Lok Sabha where bills were passed. Then ultimately I was with the president when the bills were assented. So that gives me a round the view clock, 360 degrees view of how law is born, what are the forces which shape them. So when Arun Jaitley handed over this task to me sometime in 2014, he was in a very, Vakil was there. He said, yes, Vishwanathan, try your luck. He was also not sure. He told me it's a great challenge. Twice we have made an attempt and we have failed to reform this insolvency framework. You try. But I had a special relationship with Arun Jaitley because 2 decades ago, he made me legislative secretary when he was a law minister. And he had reposed enormous faith in my drafting skills. The proof of pudding lies in its action. So any legislative policy has to be enacted into a legislation. Unless you get a bill, it's of no use. It can be debated endlessly and it will not see the daylight. So we started the work with great amount of skepticism. Batra knows. I have seen Batra 2 decades ago when he used to come to the Law Commission. And he was talking about insol conferences in Singapore. He was inviting Justice Jeevan Reddy and Jagannath Rao. But not many people understood what he was talking about insol. We only knew about Provincial Insolvency Act and President's Insolvency Act, and nobody understood whether any cases have been filed at all. Batra has been battling it. Then Justice Vadwa, he started the process, and there is a lot of interest amongst the judges, Sikri, Lokur, others showed much interest and started taking interest in this process. Now, this code, when we started drafting, everybody was skeptical. He said, you are going to bring in one single law for personal insolvency, then also corporate insolvency. What is this? How will you do that? But the directions are very clear. Then we went ahead. we drafted the legislation. In November 5th, I handed it over in 2015 to Arun Jaitley. It was introduced in December. It was passed in 2016 budget session, went before the committee, passed, enacted. In 2016, October 1st, the bankruptcy board committee. Within 5 years, it has taken, you're all here. I defended the code before the committee. The code, many MPs asked me, you are just trying to figure out a new profession, resolution professionals. Where are you going to get these people from the sky? You will bring them. I said, we will, profession will emerge in the due course. We have enormous talent in this country. And this is a piece of law and economics. It is a financial legislation. And it affects our credit market in a great way. Unikrishnan is here. Credit market today, you know what is ailing them. So we try to address the problems. We have excessive financial dependence on financial institutions. We wanted the bond market to flourish. We don't want people to go to the banks. Most of the problems which are now we claiming criticism is all legacy issues. We are trying to pass from one legal order to a new legal order. And in such a moment of transition, there's going to be a lot of confusion and a lot of vested interests will be there. Once these legacy issues are solved, then we will have a credit market which is really healthy. And our dream of India becoming a restructuring hub, Batra used to tell me, we always wanted to be a global hub of arbitration, but then that is not happening. And at least in restructuring, we have capital to come into India to structure it. Interim finance will play a lot of role. No, I will not go into the specifics. You have been talking about timelines and other things. These are all issues which will come up. But the most important thing about this legislation, which I will say, is in legal research in India, all of you know, it has never been systematic or it's not based on empirical research. All of us know it's all dependent upon some accidents of litigation, some court saying something. When an act is passed by a parliament, each department of the government is entrusted with managing and operating the act. So they don't have much resources to see how the act is operating. How do you test the efficiency or the effect of any act of parliament? How do you do that? How do you do that? You say this insolvency and bankruptcy code has not achieved its purpose. Or what is the test on which you have passed this judgment? You tell me, what is the test? You have empirical data. Tell me which law under the Indian statute. I know I am very thorough with the Indian statute book. 30 years I've lived with them. I slept with them because I'm a draftsman. There is no metrics, no valuation metrics except for Income Tax Act, Customs Act and GST, where people have figures on the hand. They know which item will be taxed, what will be the revenue. That sort of metrics is not available for any other Indian penal code, also is lacking. So, but insolvency and bankruptcy code is address this problem directly. It is based upon research, empirical data. You have so much of data at your hand. Now we live in the age of big data, data analytics, artificial intelligence, everything come in. Then we brought in how to address this information asymmetry. RBI is working day in and day out to enhance these things. We amended the Securitization Act to create a registry where more and more secured interests are brought in. So we are battling with that. Now this act is implemented incrementally. Batra has always been telling when you implement, personal insolvency will have a lot of social strife. You're right. We have not touched that for the simple reason, we are not, Indian people, common man is not available, he is not aware of how to manage his personal finance. In USA, schools are giving lessons in personal finance. How do you manage your finance? How do you create wealth? For a healthy share market, that is required. If you want people to go and play into the share market, people should know how to manage their wealth. When the personal insolvency is brought into force, you're going to have a lot of problems because people don't know. They have a credit card. Everything is going to end up in insolvency. How do you do that? So we have a fresh start process. We need to have more capacity advocacy process to inform these people how to manage their personal finance. This debt recovery tribunals, I have given this jurisdiction to them, which is highly criticized, I know. But then, if you start a separate bankruptcy tribunal, our bill would not be in the table right now. You see, it took 10 years for a company's labor tribunal to be operationalized, went into court. So, we discussed with the finance minister and he said, you do it, let us see. And the law is done. If you see a need a separate court, we'll do that. But right now, in fact, there is a demand that why are you creating? Pardon? Pardon? But in fact, there was a great demand from the judiciary, judges. They are saying, why are you creating separate tribunal? Give it to the high courts. We will handle it. But we had that experience of the official liquidator, all those things. We didn't want to get into the same trap. And secondly, if it has gone to the high court, the government's power to drive that legislation will be lost. Initiative will be lost. They'll be looking to the courts for everything. But that has been taken out. Because all the criticisms against the code, it has come out very well. And because we have, recovery is not a test to find out whether this act is failed or succeeded. We wanted rehabilitation, but that has to happen. And there are a lot of issues where expertise is emerging. Valuation. Valuation is a new area where we are all getting into it. Price discovery in a market economy is very dicey. In government, when we try to disinvest, price discovery was always been a headache because ethical questions are involved in that. It's not really market decision. And then people are afraid of taking decisions because politics enters there. So price discovery gets into this. Valuation is always bound to have difficulties, but I think in the course of time, things will settle down. Now, having said that, you have a great potential for this act to set the trend for new form of law research, because the government has constituted a committee to look into this working of the court periodically. We brought so many amendments, they're still looking at it. No other act has such a powerful support system. No other act such a powerful, because secretary here, the corporate affairs secretary is full-time engaged in this. He holds meetings, we deal with issues, we try to suggest, we bring in ordinances when necessary. That is a great thing. No other law. Then secondly, the ecosystem servicing this thing is enormous. This sort of ecosystem is not available for any other act of parliament. If all acts of parliaments follow the same procedure, all law reform will reach a great height, and this is showing the trend. I don't want to monopolize much. I want now.
Thank you. Thank you. Thank you. Thank you, sir. So I think, so again, just to reiterate, and then we'll move on to the current, though you have heard so much about the amendments that are necessary. So last bit of history is that, again, the point made that there were some macro goals that we had while drafting this. And one of them was to deepen the bond market and to reduce the reliance on the banking sector, which was in the mid-80s, while in many countries it is far lower and it's almost equal, so that the blue chip companies should go to the bond markets rather than putting it all on the bank shoulders. So I think we have made some good progress there. Of course, as many of you have said, it is still early days. It's 6 years, of which, frankly, 2 years were lost through COVID. So we are moving in that direction. And the last point was, again, there is a lot of misnomer about operational creditors. The truth is, and IBBI has done a fantastic job. They are sitting on both sides of the hall. That the data on OCs, if you can generate, because a lot of it, when we say one of the best things that happened, the behavioral change, the credit culture. Yesterday, you also heard the joke, I think Mr. Sunil Mehta made, that previously when someone was a huge defaulter, it was the bank's problem. Now, when they're losing their company, that's not the case anymore. So this, with the operational creditors, what we were told, especially the small guys that the member also mentioned this morning, they did not even get an audience. They had no chance, no bargaining power. So what we have changed is now they have huge leverage. In fact, sometimes there's criticism from the corporates, they have too much leverage because they can take a company into IBC. So if we can get the data on how much OCs have recovered, either through the threat of IBC or after admission, but thereafter 12A withdrawal, I think that will give you a sense that actually the law has helped the operational creditors a lot, and that was certainly a goal for us because, as all of us know, MSMEs are a huge part of our economy and huge part of the jobs. So now, instead of talking economics, I better move to the real expert. And Professor, if I can ask you that besides IBC, to create the ecosystem that we are trying to create, which are the other parts of the ecosystem, other laws which you feel will get us there?
Thank you, Mr. Vakil, and good afternoon, everybody. One of the difficulties in being on a panel in the last session is that you wonder what is the new thing you have to say when so much has been said over the past couple of days. And I have to say that you had some very thought-provoking and insightful exchanges and observations made in these 3 sessions, which have been quite educative for me personally. I think one of the things one can do is to, I think, reiterate a few points which bear reiteration for the purpose of having clarity or agreement amongst ourselves. Because unless we are agreed on some basics in relation to the functioning of the IBC, it'll be very difficult for us to sort of move forward. So I think it was very gratifying for me to hear from Dr. Deepthi Mukesh, the honorable member, that the focus has to be on the recovery rate, whether you like it or not, because I think we need to be very clear and we need to have some kind of agreement on this. Because when you say that the efficiency of the system has to be improved, which is why I think we are having this conference here and all these deliberations have been going on, what we want to see is how to improve the efficiency of this system. And you cannot even begin without setting a proper benchmark of efficiency. And I, for one, am unable to see what benchmark, what meaningful benchmark you can have other than the recovery rate. Because if you get into this question or this point which was made yesterday, that the bankers are not there merely to maximize the recovery rate, but they're also there, to make sure it's a going concern, to make sure that the resolution is achieved, etc., etc. If you bring in, some higher purposes in life other than the recovery rate, I'm afraid that's the path to nowhere. So I think whatever you do, finally, the metric that we have to agree on, a very fundamental metric, is the recovery rate. Now, how do you improve the recovery rate is something which I will come back to later, because now I want to sort of address the question which Mr. Vakil has put to me, which is what are the larger changes which you need in the ecosystem apart from the changes in the functioning of the constituents of the IBC that we've been discussing over the past couple of days. So let's begin by just having a basic conceptual framework. So you have an asset, and the intention is to preserve as much of the value of the assets as possible. So once the default takes place, you want to make sure there's no further erosion in value or the maximum value is recovered. But I think you have to sort of go back further. When you say that you want to protect the value of the asset, you have to go back in the value chain and start from the banker's end. So first thing is that once you have created an asset, you have to prevent it from turning bad. So that's the first thing. Because once the asset turns into an NPA, and given the kind of NPAs that we have in the system, if you are going to move such a large number of cases into the IBC system, then I'm afraid there's really no salvation from the problems that we are talking about, the clogging of cases, the delays, the low bids, the poor recovery rate. All these are inevitable once large volumes get pushed into the system. So of course, I think, some of the points that were made about streamlining the admissions process, they are valid. We've been talking about increasing the number of benches, increasing the number of judges, all that is fine. But you see, if you take a basic problem, such as congestion on the road is congested. What is the solution? Broaden the road. Is that a solution? Not really, because the moment you broaden the road, more traffic will come onto those roads. So how do you solve the problem of road congestion? You have to address the pricing of vehicles. You have to make private transport expensive. You have to make public transport inexpensive and efficient. So that's how you address road congestion, not by broadening the road. So what I'm saying is, no matter what improvements you bring about within the IBC system, and I'm not for a moment taking away from any of the suggestions that are made, they're all very valuable suggestions. You have to address the larger system and begin at the banker's end. So within banking, what are the things that need to be done? Well, first, risk management in banks has to improve considerably. So this means not only improving the quality of management, especially, the public sector banks, which still have 65% of the banking system, the functioning of boards, the risk management committee of the board of banks, how are they functioning? What is the quality of board? So you have to begin from there. So first thing is risk management, avoiding concentration risk, etc., fundamentals of bank. After that, once the loan has been sanctioned, you make sure that at the first warning signs, you either exit the exposure or you address the problems that are arisen. Now, a great deal of this happens in project finance. So the moment, because project finance happens over many years, and the moment you discern certain problems or you pick up some warning signals, the bankers swing into action. But in balance sheet lending, I'm sorry to say this doesn't happen, except perhaps in consortium cases and a few of those cases. So I think the capacity to react to early warning signs is simply not there within the banking system. Then after the default happens, what do? I think the first job of the banker is to sit across the table with the management or the promoters and try to resolve it at the banker's end. So we talked about, the role of mediators and, the important difference that mediation can make to this entire process. But I would say before that, the bankers themselves need to sit across the table and see what sort of meaningful resolution can be achieved. But what has happened consequent to the IBC, which is perhaps unfortunate, and given the way that the public sector banks operate under numerous constraints and the fear of attracting the action of vigilance agencies and other agencies in respect of decisions that they've taken, what has happened is that the immediate reflexive action of bankers is to push cases into the IBC. So I'm sorry to say that a great deal of preventive and other actions which need to be taken at the banking end of the spectrum, unfortunately, I think that has taken a backseat. And the immediate reaction of most bankers is, let's push it into IBC. And if you do that, no amount of improvement in efficiency, the IBC system is going to address the fundamental problems that you have, which is the large volumes which are there. And, the challenges based on the principles of natural justice, etc. Again, it was very gratifying to hear the honorable member speak up for the judiciary, no matter how unpleasant it is for bankers and others to hear this. But I think the judiciary has a role to play in terms of hearing the other party. And given the infirmities of the legal system, given the problems inherent in standing up for the principles of natural justice, the delays and other things which we are seeing, my contention is they cannot be resolved beyond a certain point. So to look for solutions within the IBC system per se is not going to do much more than mitigate the problem. And the solutions have to be found much earlier in the entire spectrum. So in this context, let me also say that I'm also in favor of exploring the pre-pack process for corporates. I mean, it has happened in the case of SMEs, but not much of that has happened. But in principle, the pre-pack process is very valuable because, again, it promotes resolution between the banker and the promoter or the management. And then the advantage with pre-pack is that you put it through the IBC process so that somebody gives a stamp of legitimacy and the banker doesn't have to fear the consequences. So I see the merit in pre-pack is that it will encourage the bankers, especially in public sector banking system, to sit across the table with promoters and management and try to resolve problems at their end. So, the basic point which the Deputy Governor made yesterday, I think is worth reiterating, which is that the IBC should be the last resort of banks and not the first resort, which is what has been the unfortunate consequence or unintended consequence of the enactment of the IBC. Now, the other thing which we're talking about, just, strengthening the IBC and sending out a message to promoters, etc. I think the point which the IMA director made yesterday is worth reflecting on. What is the benefit that you get? Of course, the creditor's hand is strengthened, and therefore we can expect the economy to benefit from lower cost of borrowing. But we also need to see what this kind of stringency or even strong arm tactics that we're trying to use under IBC, what impact it is going to have on the promoters. I'm really concerned at the debt to equity ratios which we are seeing in Indian industry today. There was a survey of about 1,500 companies done by the RBI, which was quoted in one of the reports recently. And I'm a little appalled to see that the debt equity ratio in these 1,500 or so companies is about 0.2 or 0.25, which is absurdly low, which tells me, which certainly gives me an indication that consequent to the enactment of IBC, the borrowers or promoters are reluctant to take on more debt. Now, you don't want that happening, because if that's going to happen, how is investment going to happen in the economy? Of course, the response to this is that industry is not investing because of all the uncertainties related to Corona, etc. But promoters and entrepreneurs are not looking at 2 years of Corona. They're looking at the long term. And I cannot see anybody who has a reasonable bet on the Indian economy and is looking at 6.5 to 7% growth rate will underinvest to the extent that the debt equity ratio should be so low. So I think when we think about improving the efficiency of the banking system, the IBC, and all the other measures that we are talking about, the larger impact on the economy because of the impact it is having on promoters and borrowers also needs to be taken into account. So let me conclude by just saying that when you're looking at the economy-wide impact of whatever solutions you're thinking of, then you have to think of the entire spectrum, starting from the bankers and going right to the conclusion of the IBC process. If you're limiting your solutions to the IBC end of the spectrum, then I'm afraid you're going to create a new set of problems, and perhaps the problems that we have been dealing with, we will not be able to do anything more than mitigate them to some extent. I will stop.
Thank you. Thank you very much. No, so I think that's very clear that there's no silver bullet in life. So you have to take a holistic approach, and in a country of our size and complexity, there are certainly challenges. But again, I want one last time to reiterate that I would only request all the players in the IBC process to please keep it as simple as possible. Do not create complexities where you don't need to. And, Sumant is a very old and dear friend, so I can say that I frankly was a little surprised by the amount of time your entire panel spent on valuation. Because valuation in the US context, and again I want to reiterate, we advisedly stayed away from the US model. So US model is debtor in possession. US model, the court plays a huge role. Even though Dr. Vishwanathan is steeped in law, or through the committee deliberations, it was that keep the role of the courts and NCLTs as light as possible. This is very much a economist market-driven process. Let the market discover the price. So the only role valuation plays is as a safety net. So for the dissenting financial creditors or the operational creditors, because they don't have a voice at the table, this is a safety net. So I think that again it's creating a lot of controversy because I guess media, high profile, etc. The one point that comes out of this, and it takes it back to delay, though Suman said please stop talking about time, but half the problems are caused by delay, is that if it's more than 12 months, 18 months, 24 months, the experts will decide. I think, sir, then you may have to revalue, because the valuation is certainly going to go down. We all know that. And therefore, then the earlier valuation may not hold good. I think the point Suman made. But other than that, to focus so much on valuation, it is entirely market driven. That liquidation of fair value is not the guide for the COC. Whether we like it or not, thank God the Supreme Court has repeatedly said do not second guess the COC's wisdom. So with that now, I will, Mr. Unikrishnan, I hand it over to you again. We talked about, credit culture, which is very, very important, in many, many ways, because the credit uptake is low. But on a lighter note, Professor Rammohan, I think given where the world is today, given where interest rates across the world are today, maybe it will be a blessing in disguise that our leverage is so low. But I say that only in a lighter way, because one of the key areas where we have a huge amount of walking still to do is infrastructure. And in infrastructure, we all know the leverage is usually high. You mentioned project finance. Again, there were people like SBI playing a big role, but we need to come back to that, because again, infrastructure, project finance has really taken a beating, and the country can't do without that. And I think, again, foreign debt and equity will not be that easy to come by. So really, it will be people like SBI doing the heavy lifting. As Professor Rammohan has already taken us, I'd be very happy to have your macro broad thoughts, but he's already jumped into pre-pack and opening pre-pack, which I completely agree with, and we'll have a detailed discussion on that. But in a way, I think Mr. Swaminathan ended his panel with the perfect entree to ours, that there's a bottleneck in the start, the admission process. We've spoken about a lot of solutions. I think also the honorable member yesterday, Mr. Gosavi, said, just make it one, make it simple, which is what I personally feel. So on the admissions process, in the middle, the bidding process, definitely, and I'll also come back to Professor Rammohan on that, because if it's not a level playing field, we can't get all the international players, and the less competition, the more inefficient the price discovery is. So coming and hitting a 6 in the 21st over is not helpful. So we need some amount of clarity on which the PPIRP does very well, I believe. And the last is the exit. So that's what Mr. Swaminathan said, the entry and the exit, the approval on the resolution plans. Again, NCLT should streamline that. If you have other issues, put them apart, but at least approve the resolution plan. Don't let it hang fire. So with that,
Hello. Actually, a lot has been said about the delays in admission process in the last few discussions. If anybody asks me what was the focus of discussions in this 2 days discussion, definitely it is a delay. Now, delay part, no. I've been a member of the governing board of IBBA for the last 6 years. And this issue has been coming up again and again, that what is causing delay in the IBC process. It was really interesting to note that initially, all the attributes of delay or attribution of delay was being made to the promoters. Promoters were not cooperating and they were not giving details. And then the employees of the company who are loyal to the promoters are not coming forward and giving us the details. That was the first allegation. Secondly, it moved out from the promoters to IPs. See, IPs are either lawyers, chartered accountants, or company secretaries. And they do not have enough idea about the business. Therefore, it is causing delay. And some people, it was not in the board, but sometimes individually also, when they come to know that I'm a member of the board, they come and say, no, the judicial infrastructure is quite, and they entertain any number of interim applications, and it is causing delay. Many factors were brought in towards the judicial delay in that. And finally, it was the members of the COC. They are not given proper mandate to come to the COC. So they are not taking appropriate decisions. And that is getting delayed. Each of them are focusing. That is allegation. I'm not saying yes or no. Each of them are focusing on their recovery, how much they will get, and not about the general resolution of this thing. These were the general allegations. Luckily, nobody has told me so far that it is the members of the governing board who are delaying the process. Maybe they will wait for me to go out of the board, and then they will come and say, you are equally responsible for the delays. But see, that has been the general trend. So, and whenever, statutorily some time limit is fixed, it is always getting crossed. Say Consumer Protection Act or any other act which is fixing time limits. So, a recent instance is the amendment of CPC, where a written statement is to be filed within 30 days, which can be extended to 90 days on giving proper reasons. But nobody is sticking to that limit. And the courts have been interpreting that whenever a statutory time limit is fixed for the judiciary to follow, that is only directory in nature. It is not mandatory. So, and if we go otherwise, the effect will be on the litigants. I do agree with that. So, there is no point in simply saying that the judiciary is delaying it to say we have fixed 180 days, 330 days, and nothing is coming within that limit. But one recent suggestion, which, that also has been a focus of attention here, focus of discussion here, is about an automatic admission process. Now, Mr. Vakil was also referring to that a little before. And you see, this automatic admission process, as a matter of principle, it looks very attractive. Now, there can be some documents which, let us say that we prescribe by regulation or rules, that there are certain documents which can be taken as prima facie evidence of default. Now, I do not know how far the courts can or NCLTs can proceed without looking into it further, just accepting. Say, first suggestion was banker statements. A certified extract of a banker's book has to be accepted as prima facie evidence of default. Even prima facie evidence I will accept, but people are suggesting that don't take it as prima facie, it is proof of evidence. As I was a practicing lawyer, I am quite reluctant to accept a bank's statement as a proof of a default of a particular amount. There were so many allegations, so many cases where the documents were wrong. And one reason that is again projected is that RBI is inspecting the banks or NBFCs or this thing, therefore they have certified that these accounts are proper. RBI is not inspecting all the accounts of banks. They are, the inspectors are looking at special accounts or which they have some information or they want to create, see some particular account. Not that everything is verified by RBI inspection team. Now, and even the audits are not that much foolproof. So taking a banker's book as ultimate proof, I'm distinguishing between evidence and proof in this. Evidence is okay because prima facie it looks good evidence, but taking it as proof, I'm not that much comfortable with that idea. The second thing which is suggested is about acknowledgement of debt. Acknowledgement of debt, if it is a genuine document, definitely it is an indication that the party is agreeing that there is a debt pending. But see, I know many cases where at the time of granting of the financial accommodation itself, people are taking these acknowledgement letters. It is only filled afterwards, like checks which are given on, I'm not saying generally, I'm talking in some cases at least, that the acknowledgement letters are taken prior to that. And there were cases where the party is dead, but he has given acknowledgement of the debt. That seems to be the kind of evidence that are coming to courts. So acknowledgement of debt, maybe that also is somewhat an acceptable thing. Of course, subject to, some principles of natural justice that can be. So banker statement and acknowledgement of debt. These are, whichever form it is, acknowledgement is in the balance sheet or whatever it is, in the form of letter, is all right. But people are coming forward with the suggestions that we should take an advocate's notice, a notice from an advocate as a proof of debt. People are suggesting that earlier restructuring done in an account, that should be taken as proof of debt. And even some have come to the point that the fact that there is a repayment schedule and the assertion by the creditor that there was no repayment, that itself has to be taken as proof of debt or evidence of debt. Now, when you go downwards like this, it becomes very, very questionable. And the role of the NCLT or the court becomes, it increases so much. Now, how do you come to a conclusion just on the basis of an advocate's notice, which is lying maybe unreplied, that there is a default? Many of these notices are not even reaching the parties. So I had a case when I was in practice, an immediate neighbor who used to come to us and talk in the evening, and we used to send a notice, and then it comes back saying that parties, where we found that the door is locked, and so that is the way in which the notices are going. So all these things, taking prima facie as proof of default and going on a mechanical way becomes highly questionable. Then, people may ask, then what is the way out? I can only say that we have to employ the basic economic principle of people respond to incentives. So incentivize the IPs, incentivize the other stakeholders to act in a timely manner. It can be financial, or it can be a promotion thing, or it can be anything of that sort, consideration for new appointment. All these things can be taken, but accepting certain documents as proof of debt and then going for a resolution or a liquidation or whatever it is somewhat questionable. Because we are all collecting suggestions from public, and it has so that way the stakeholders can come out with comments on what is the appropriate mode to decide what is prima facie evidence, and then on that basis we can initiate the process. Okay, thank you.
Thank you very much. Dr. Vishwanathan, anything on the changes and amendments to make it more?
I would just like to add to what Unnikrishnan has been saying. There is a need for an urgent Public Records Registry Act. You will agree with me. And now in 2016, the SurFaCI Act has been amended to make it mandatory for all security interests to be registered with the central agency. There is an act. I don't know whether it's been brought into force. And they have identified what are the transactions which should be registered. And then they said it will be deemed to be public notice. So, and ultimately, we need to have a public records registry where you can capture all ancillary information. That is very important. Defaults occurring in electricity bills, credit card bills, etc. That gives you a holistic picture about the credit status of an individual, and all your difficulty about proving it, that becomes historical thing. I think that is essential.
No question. I think in fairness, there were the successes were the regulator, of course, was set up again in record time and has done a terrific job. I think that everyone will be unanimous on. I think, sir, you mentioned about the insolvency professionals. So that was a brand new set of professionals. Everyone was very concerned. I think in 6 years, we have almost doubled the number of insolvency professionals as the UK. Of course, our population is also slightly larger. But I think it was a tremendous effort on everyone's part. I think information utility, it was first of its kind. I think to the best of my knowledge, no other country had it. Just like no other country had the boldness to do Section 29A. And that is still, has again got a lot of miles to go. It took the longest, and I completely agree that we need to have this, as Mr. Unnikrishnan and Dr. Vishwanathan have said. All I'm saying is that if all other areas, whether it's medical, every area in the world has benefited from technology, we can't be so different. I mean, also COVID has shown it now. So we have to take the benefit of technology. Of course, the document should be prescribed by IBBI. And don't let perfection, going for perfection ruin a good result. So I think we do need to make some progress there. And so now you coming back to the 3 parameters very quickly you were mentioning. I mean, what we normally say is, of course, recovery is the first. So pre-IBC, it was 22%. It went to a high of about 46%. Now it has dropped. IBBI will have the best statistics, but I think it may be 40. People say don't take the best cases. that's ridiculous. I hope you agree, because then you don't take the worst cases. You have to take the stats as they are. So we've doubled. The best in class, Singapore, Canada, etc., are in the 70s. So we have a lot of room for improvement, no doubt about it. The second stat is time, which is directly correlated. Time from 6 years. We again, we started with 270, then we made it 330. Of course, the courts have said that this is not mandatory, but for many years, up to the first 3-4 years pre-COVID, we were less than 1 year. Less than 1 year is best in class. Whether you take Singapore, US, UK, everyone, that's it. They're all in that ballpark. So actually, the main thing was not to slip. Unfortunately, we have definitely slipped. So from being best in class, we have dropped again. We have to just make sure, and that's why we are spending so much time on it. The last one is cost. And on cost, we were around 9%. We are now around 1%. And I dare say 1% will probably be again best in class. I can't think of a jurisdiction that will do better on that. So, Professor, those are the parameters that I get from IBBI. I'm sure there's, parameters that we have missed out. We can do better. But again, comparatively, we have a lot of international colleagues here. I think we are doing a reasonable job. Your views on that and any other observations, any other insights, IBC or ecosystem that you would like to say before? I think we'll do one last round, and then I promise the floor, we'll give them sufficient time.
Well, yes. So, I began by saying that you need an operational benchmark for testing efficiency. And the one that suggests itself to me is, as I mentioned, the recovery rate and all the other things that you're talking about, the time taken, etc., the delays, they all have a bearing on this benchmark. And I think so we sort of need to resolutely focus on this. So when we test the working of the system or the constituents thereof, so whether it's the committee of creditors or the insolvency professionals or IBBI itself, I think the working has to be tested against this benchmark. And the question that we need to ask is, what is the tightening that we need to do in respect of each of these constituents so that we arrive at a benchmark, we meet the benchmark in a way that is extremely satisfactory. So a recovery rate is 35 or 40% or whatever is regarded as acceptable. I think that has to be the operational goal. So let me just look a little more closely at the functioning of two of these constituents, the committee of creditors and the insolvency professional. So the insolvency professional, among other things, is providing a liquidation value based on the valuation received from two different people. And I think the important question that has arisen is, how do we know that this valuation is correct? And no matter what you may say, you say there's really no question of getting away from the valuation issue. So whether it is the IBC or disinvestment or privatization or whatever, all the controversies eventually center on unsatisfactory valuation. If you don't get the valuation right, then you're going to discredit the process. So we should not be surprised that the Standing Committee of Parliament focused on the poor recovery rates, because in the mind of the public and therefore in the mind of the representatives of the public, this is going to be a highly contentious issue. And so you cannot brush it aside. Now, what we heard in respect of the valuation done so far is that it's subject to peer review. But I'm sorry, I think no peer review is ever going to be satisfactory. This principle of self-regulation has not worked anywhere. It has not worked for the stock exchanges. It has not worked for the investment bankers. It does not work for the brokers. It does not work for NBFC. So self-regulation is no regulation at all. So somebody performs, somebody else evaluates. And therefore, we need an independent evaluation of all these valuations that have been done. So I will come to that very quickly. So let me just state the principle that all this which is happening under the aegis of these different constituents needs to be subject to an independent evaluation. Now, what about the committee of creditors? So we heard time and again from all the participants the ruling of the Honorable Supreme Court, which is that the wisdom of the committee of creditors is supreme. And we also heard that, that has come up for some kind of a challenge and the hearing is due before the Honorable Supreme Court. So the committee of creditors, how does it function? So you have to compare the bids that you've received against the liquidation value. So we looked at the liquidation value. Let's look at the bidding process. How efficient is the bidding process? One of the conditions for efficient bidding is that you should have multiple bidders. In how many of these cases have we had a large number of bidders? Have we examined this? What attempts have been made to ensure that there are a large number of bidders? Now, in some cases, it may be necessary to give the mandate to an investment banker to go and find bidders. They're not going to come to you just because you put up something at some website. They're not going to come because of that. Or do we need to create an online platform which is marketed internationally, where all these things are given a much, these cases are given a much higher profile? So unless the bidding process is made more efficient, and I say one of the conditions, there are a number of conditions for efficient bidding. You should not have collusion, you should not have information asymmetry, etc. But I think from the operational point of view, the very basic requirement is that you should have a large number of bidders, because without that, you're not going to get a bid which is attractive enough to be compared with the liquidation value. And the more the number of cases where the bid is close to the liquidation value, the greater is the room for controversy and the greater is the potential for this entire process to be discredited. Now, one of the things which I want to submit to you for your consideration, is this section about not allowing a defaulter to bid. Now, this seems sort of automatic, many people take it as a given. So you don't want to encourage moral hazard by allowing the promoter to come in and bid where there's a case for default. But the question I want to put to you is, what about cases where the default has clearly happened for reasons beyond the control of the promoter? So an adverse court judgment. At the time of bidding for the 2G licenses, who would have imagined that those licenses would be cancelled? How on earth is the promoter to know? When you're bidding for the coal blocks, how do you know that the coal blocks are going to be cancelled? So when a banker is lent to a miner, how do you know that the mining license is going to be cancelled? So in all these cases, is it possible for, since we grant that the wisdom of the committee of creditors is supreme, can we allow them to take a call on whether in a given situation, the default has happened for reasons beyond the control of the promoter, and therefore you allow the promoter to come in the interest of getting a higher recovery than otherwise? So, you may wonder, why I keep harping on this issue of recovery, because unless you are focused on this, my concern is that this entire process will get discredited for this reason alone. In any privatization or disinvestment case, the moment the valuation question is not addressed satisfactorily, immediately it's going to translate into a scam. It has already translated into a scam. In the case of the hotels which were sold 20 years ago, the honorable courts have revived that on precisely these grounds. So whatever the conceptual, reservation some people may have about the recovery rate, etc., what I'm saying is, from the operational point of view, you cannot get away with it. And therefore, we have to see how we can strengthen the different constituents with a view to attaining a better recovery rate. And the point I would make to you is that there is a need for an office of independent evaluation to be set up under the aegis of the IBBI, which will take a sample of cases which have happened, look at the valuation, look at the resolution, look at the resolution time, look at the functioning of the committee of creditors, etc. So this is basically replicating what is happening at the IMF, where the IMF is an office of independent evaluation to look at a sample of cases which the IMF has dealt with. Now, if that is not satisfactory, then I would say that you need an independent audit of the IBBI itself. In fact, there is a case for, I've been pushing this before the Honorable Standing Committee of Parliament on the attached to the Ministry of Finance, that in the case of all regulators, you need periodical independent audits by eminent professionals, whether it's RBI or whether it's SEBI or IBBI or anybody else. You need an independent audit to see whether the outcomes are in accordance with the expectations and what needs to be done. So you need to look at the outcomes and you need to look at the internal processes as well. But if that is considered too radical a move, I would say that a starting point would be to set up an office of independent evaluation within the IBBI itself.
Thank you. Thank you. No, I. Terrific, terrific.
Is it there in the public domain? Is that report there?
So, no, IBBI has definitely been a path breaker on many of these issues. On 29A, the truth is it was a decision by the government, very clear, eyes wide open, and it's up to them now. I just want to make one point, the telecom license issue comes up again and again, that you have to be a continuing defaulter. So if you are not a continuing defaulter, there's a period of time before that you go to the banks or go into IBC, then you are not going to be hit by 29A. So the idea was that there were historic repeat offenders, and that is why 29A came. If today the government feels that times have changed, we've cleaned up all the backlog, so be it. I mean, that's a decision for them to take. But on the valuation also, one more time I want to reiterate, liquidation value is certainly not the aspiration of IBC. If you're getting just liquidation value, something has gone terribly wrong. Again, there were a lot of historic cases. If you have been in ICU for 6 years, the odds of you jumping up healthy are very unlikely. Now we've probably gone through most of that backlog. So today, unless the asset is so bad, I don't think the aspiration is liquidation value. That's all the point I'm trying to make. It was a safety net for the dissenting. It was not an aspiration like it is in other jurisdictions. So I just wanted to be clear on those. Also I wanted, your thoughts on, because there's been so much said about PPIRP, and Professor also said it's probably an idea whose time has come. There are issues that it's debtor in possession. We've talked a lot about mediation. So they're saying it's against the basic architecture of IBC. But I think in a way, the sooner we resolve, the better it is. We all agree with that. So if it's debtor in possession, it is de facto mediation. It may be the right thing to do at this point.
I think we discussed that in the committee. I know we have to deal with the sectorial adjustments. So we thought we will try. It has worked well in UK and other places. Let us see. I just want a quick rejoinder to Professor Ram Mohan's two queries. I understand his economist uneasiness with dealing with lawyers' way of thinking and working. He said about setting up benchmarks for acts. I'm afraid that is loaded with a lot of value judgments, because in acts, different people view different acts in a different sense. Even Parliament doesn't know what is the object of the act. They enact something, and then it acquires the soul of its soul. So that becomes contentious. So what is the role? What is the object or the benchmark for IPC? How do you judge that? Is to punish people or is to be a crimeless society? So the two people will never agree. Ultimately, that will be a justiciable thing, will go to the court. That's our difficulty, because lawyers, we are arguing, we'll never agree on anything. It goes on litigating. That is you have to pardon our profession. Secondly, 29A we never wanted 29A when we drafted it. We were aware of this problem. We wanted the committee of creditors to be sovereign. Very clearly, finance minister said they are sovereign. They can do anything. They should not be questioned in a court of law or by the tribunal. He was very clear. 29A, all of you know why it came in. Because of people started gaming the system, so it was brought in. And so that has created problem, because it was never in our idea. What you said was in our mind. If beyond your control reasons you have fault, then the banker should take a credit. So this has caused some problem because of how people started. When you when people try to resist vested interest, things happen as a result of that. No, I mean, as
You must advise the government. Sir, your view, and I would love to hear, I'd love to hear Mr. Unikrishnan on 29A and on the PPIRP for thrown open to everyone. I mean, 29A, in fact, the MSMEs, there are, you know, that's another point I wanted to make to you. IBBI, I think, has done a terrific job wherever there's a good asset. And of course, all the other bankers, both domestic and international. So wherever there's a good asset, we see a lot of, I mean, just now for Reliance, I think there were 56 EOIs. So I don't think that is a big issue. The big issue comes in the smaller companies. There it is an issue. And there the promoter is usually the main guy who's going to give you the best deal. So knocking him out is going to create many more liquidation. But all I can tell you is that this was eyes wide open. That's all I can say. So.
See, one thing you were talking about that assessment. He already said that there was an external assessment. We have an internal assessment also. The board members assess their performance. So actually, we have a tendency to give 100 marks to ourselves, but that is part of it. But there is an evaluation of what is done both by the board as well. I mean, board means governing board as well as the insolvency board as a separate institution. Yeah, no, there is an evaluation. There is an external evaluation. There was, and then that report is yet to be discussed. And the other thing on that, on regulation making, we have a principle of, say, going by the cost benefit analysis. I mean, that is what we are supposed to do. So what will be the benefit of a regulation? But we don't attribute any particular figure to that. This will be 50% beneficial or 100% beneficial. I mean, taking together, usually this principle is taken from the Administrative Procedure Act in US. So there has to be a cost benefit analysis, and many of the newer legislations are putting that whenever a regulation or a subordinate this is made, you have to evaluate the costs and benefits. So it is somewhat generalized thing, but there is an assessment. There is a general assessment of what are the benefits and losses in that. Okay.
Open to the house, please.
They're important, and that's why I'll take the opportunity to do this. The first thing I want to say is that on the principles, everything that Professor Rammohan has said, I completely concur with him. Not just as an economist, but also as someone who's a student of insolvency. I think he's completely hit the nail on the head. I mean, the articulation probably we do and how he does may vary. Now, let's say to begin with the measure. How do you measure? What he mentioned about the recovery is probably the low-hanging fruit, because that's the most easy thing to do. You know, how much have you recovered? That's one measuring tool that you have, and the two other you mentioned. They're all visible, tangible. You can pluck them. They're on the lower branches. But the way we really do it, and which is the most challenging task, and I think that's something which really institutions like IIM must be doing is, and that's what really is the value add. That when you turn around these assets, bring them back into the economy by passing a resolution plan, what you're really doing is an asset that was lying dormant, but which is otherwise capable of contributing to the economy, but was in poor management's hands. You're really transporting it into the hands of a more competent and able management, which will be able to use it optimally in the economy and contribution to the GDP happens.
No doubt.
Right? And the preservation of jobs. That's also another objective, because that also is. Because every enterprise has an economy around its own, right? It serves an economy, and that economy, whether it's dormant, is activated, is a very important way of measuring the larger success of IBC.
Of course.
Right? That is one point. On 29.
Well, the biggest success we are not saying is the behavioral change.
Yes.
The credit culture change is huge.
All this is cool. Yes, please.
Yeah. So, so this is the point that you made, and several people, including the bankers, made this point that, what we are doing is a noble task of preserving the enterprise and the jobs and so on, which is fine. But don't you need to preserve incomes and jobs in banking? So you see, it cannot be that you preserve the enterprise.
Yeah.
You preserve the enterprise at the cost of the bank.
Completely agree with you,
The
yes.
bank's capacity to lend, which is what has happened. And in the process, you have undermined the bank's capacity to lend and create new jobs. And therefore, it cannot be. So I'm sorry, I have great difficulty in accepting that argument, which seems very lofty and noble. But I think this is why I'm saying there is no getting away from the recovery rate, because the recovery rate is what strikes the balance between the interests of the enterprise and the interests of the banking system.
Right. And in fact, to that extent, with all due respect to the Supreme Court, I disagree with the judgment which says that it is not meant to be a recovery. Recovery is a very fundamental, integral part of the whole resolution process. There will not be any resolution without recovery, and there will be no incentives for anybody to participate. And we moved to insolvency because our other recovery mechanisms like DRT and otherwise failed. So I completely agree with this. I was not disagreeing with you. I was only saying that we need to start measuring it at some point, because I was making the point of the measuring of the outcome. The second point that I wanted to make was just one second.
Okay, yeah, because the post-students.
Yeah, 29A. I wanted to make on 29A. My opposition or a criticism or disagreement, howsoever you may articulate, of 29 is well known. I wrote a piece which I summed up by saying exactly the point that you made, that every person whose name is Prem Chopra is not a villain, right? There are people who may have failed their enterprise, or the enterprise may have failed for reasons which cannot be attributed to poor management or dishonesty or inability to pay because of mismanagement or whatever it is. There could be external factors which were beyond their control. How do you make that distinction? That judgment is best left to the lenders, because they have a relationship with the borrower. Whether they can bridge the trust deficit or whether they just want to exit is a choice that they have to make. It can't be made by way of a legislative provision. It was good for initial years, but I think it has been diluted and it needs to be diluted further. And it has a direct linkage with the shrinking of the market for resolution applicants, because you disqualify so many people, not just the core promoter, but the whole ecosystem around it.
You're in Delhi, Dr. Vishwanathan is supporting you. Talk to the decision makers.
Yeah, I have been saying, and I think there is a beginning to be some flexibility on that, is what the point I'm making.
Other than creditor in possession and debtor in possession, there has to be a flexible method where, where people fail because of some reason or other, they should be in possession. Is it the
when the law that was passed by the Parliament in 2013 November, which was never notified, had a hybrid of the two, which is a kind of another avatar of a pre-pack, which is what the world is moving to in the last 10 years. If you see Singapore, if you see what UK is doing right now, they are moving away from the traditional verticals of corporate creditor in control and debt in possession, and moving to a hybrid system where the creditors make a choice. If they have a trust deficit with the lenders, they will say, we'll go in creditor in control. We want an independent management. But where they feel that with some correction that mistrust can be bridged, then they say, okay, we will allow him to first right of refusal to present a plan, but it has to be under the oversight of an independent professional. But you don't cause disruption by changing the management.
Please.
Approved and disbursed to all the stakeholders, whether they're valuers or insolvency professionals and so on, has actually tremendously gone down, which definitely would lead to the quality of services or the outputs that's going to go in. What we are seeing is maybe a resolution professional is hiring one top valuer firm and then one small valuer firm probably, and then arm twisting the other valuer to say that, no, we're only going to pay you 20,000 rupees for a valuation engagement, that too we're going to pay you after 12 months from the engagement. So, maybe the cost is going down artificially because that's really not how it's supposed to happen. Any views on thoughts?
No,
on that?
I agree. I mean, penny wise, pound foolish. So that should not happen. But I think even without that, we are very cost competitive as we are in so many areas globally. I mean, compared to, but certainly I don't suggest that. I mean, L1, we know what that does. So I'm not suggesting that at all.
Sir, so the main goal of IBC has been to resolve rather than liquidate. But we have chosen to have a sequential process. Like first, we go for resolution, and if it fails, then we go for liquidation. Cannot this priority be still preserved and we go for a parallel process wherein we gave some weighting factor for a resolution plan rather than a liquidation plan? Because I find a lot of similarity in the process, and we are repeating the whole process sequentially, leading to delays. So can we come up with some weighing the resolution plan more than the liquidation value, liquidation plans or liquidation of assets, and do them parallelly? That will save a lot of time.
No, I think the priority is very clear, and I think it'll be a bit chaotic. You can use, I hear what you're saying, that if there is some tasks that are being done twice over, you can use that, but again, if a lot of time has elapsed, it doesn't help. I think running them parallel won't make sense, but I mean, the chief architect is here, so you can hear from him.
I think it's too early to experiment right now. Let us wait for some more time.
Yes, COC can indicate that resolution nahi hone wala hai. I'll stop wasting time.
All of it being disposed in a liquidation plan, and any continuum of that, wherein not four assets may be disposed and four assets, some four business may continue. We invite all plans and they are evaluated, and maybe we can give more weightage to the resolution plan rather than a plan with liquidation.
Yeah, no, I hear you. Yeah.
Good afternoon, everyone. Sir, on the first issue, when we talk about recovery, we barely pay any attention to recovery made to the operational creditors. So it is their interests which are being wiped off very largely by paying.
You didn't hear me at all. I said this is a big misnomer, and I'm requesting IBBI to give you a fact that the OCs have done extremely well through IBC.
Correct. And this could also create a chain of series of insolvency, consequential insolvency by wiping their claims off in the insolvency.
Yeah, so I mean, you are not going to give away your company for a few lakhs or a few crores. So most of those get resolved. No one takes the chance of losing their company. Are you with me?
No, sir. Certainly, I'm not able to clear myself. I'm saying that by wiping off the operational creditors' claim, by not giving them.
But you're not wiping out, because usually what happens is you settle the operational creditor upfront to avoid the IBC proceeding. I think you need
in a process
to know,
of resolution plan, sir.
You need to know the recovery that OCs have got versus FCs. Once you get that ratio, taking pre-IBC also, then we can certainly have a discussion if OCs have been hit hard.
Though, sir, my question is in respect of approval of the resolution plan, sir.
No, I understood, but you have to take a holistic view, no? If the guy's got his money and gone home, how can you avoid that? No, it is. It is. I think, in fact, DG yesterday mentioned it. I think we can collect that. I think.
Sir, I think I.
No, but pre-admission. Correct. You're clear.
But in a resolution.
No, I understood what he's saying, but you have to take it together. Yeah, but But the idea is that OCs were getting a bad deal pre-IBC, especially the small OCs. Because don't forget, Tata Projects and L&T can also be an OC. So I'm saying that for the small OC, the security guy, the catering guy, we discussed it at our meetings also. For the MSMEs, is it better now or before? It is clearly better now because they have huge leverage. You're not going to lose your company to save that lakhs or few crores.
But sir, can we have?
Yeah, I'm just saying take it together.
Sir, can
I'm
we have a
with you, I'm
reserve?
with you. I've understood that in a plan, the OC gets liquidation value.
Correct. Which is
But
still-
you all have all told me that in many cases, everyone's getting liquidation value. So then it's the same.
Sir, on the second aspect, can we link PIRP to the debt exposure rather than MSME? Because there could be a situation that a MSME, non-MSME having a 10 crore of exposure.
But we are saying open it to everyone.
Yeah, that's if that happens, then it doesn't survive. Thanks.
So my one of the points I want to make is about how interim financing is being viewed at. A lot of comments have come forth saying that it's like throwing good money after bad money. So instead of looking at it as if you're throwing bad money after bad money, can it be seen as like a priority sector lending, or like we have a rule that we have to give way to the ambulance? So when a corporate is on the road of reviving, so why can't we have a kind of priority sector lending, making the banks spare out a particular sum for that kind of lending?
I mean, it's a good thought, but I think it'd be very difficult. I think the better one is in Suman's, and what I think maybe you mentioned, that this is something that you have to make it market attractive and bring in other players. Because, you know, if SBI is already stuck with thousands of crores, it's going to be very tough for their board to write another check, though you heard that they are considering it, they've got the parameters. And of course, it is priority, by the way, it's super priority. And you're going to get a much higher interest rate. But there are other players, which Suman knows well, international players, who do this for a living. So maybe you need to bring in those guys. And I mean, I don't think that. Mr. Batra is offering, Baba, usko AMC karke, he'll head the AMC.
No, but 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 who will take the lending decision? So the problem doesn't go away. So you're passing the buck from the banker to this. So no. So yeah, but the vigilance people will go after these fellows on the same ground. You know, so I mean, the thing is that, you know, this entire process and the, you know, recovery and all that, it has to gain a certain amount of credibility for bankers to have the courage to attempt interim finance. So this process has to play out, and, you know, the entire process has to gain far higher credibility with with Parliament and with the general public before bankers can have the courage to do that. I mean, conceptually, yes. I mean, if you think that, you know, there's a case for lending, you should do it. But the point that Mr. Swaminathan made is a very valid one. Try convincing the board to approve a credit decision of that kind. It's an uphill task.
But we also, Professor, we also have the FEMA issues, because there are foreign players, because the coupon is so rich, are willing to do it. But I think RBI has some concerns on that. But because it will be a high coupon.
Because this will also prevent CDs from falling into liquidation.
No question.
Sir, good afternoon, and thank you for some of the plain speaking today. My question and request for some views. I'll request attention to the fact that success of any major resolution lies in the capability of reaching out to as many resolution applicant as possible. In that regard, compare the ecosystem with the investment banking system whereby there is a M&A league table and many of the connected dots, whereas IP is as the born investment bankers. How do we strengthen their hands in terms of creating some kind of marketplace, be it electronic or physical, to reach out to the prospective resolution applicant? That is a big question mark always I have in mind. Any thoughts, please? Thank you.
That's a very good question. We've talked about this, that IBBI has done some efforts on this, maybe, as you say, together through the associations, through investment bankers. Certainly there have been, in the larger cases, investment bankers involved. But basically it's something that the ecosystem has to develop with the regulator. I think together we need to do this.
Thank you.
डिजिटल प्लेटफॉर्म कार बेचनी हो ना, घर पे 24 घंटे में पैसा आता है सर, सैल्यूट करके जाता है. आई मीन जस्ट माय थॉट. तो डोंट वी थिंक वी कैन क्रिएट ए ऑनलाइन प्लेटफॉर्म? सर राइटली मेंशन, आज अभी मुंह से बोलो सर, इंटरनेशनल मार्केट है, घर पे आएगा, सैल्यूट करेगा, सर मैंने अपना गाड़ी बेचा है, विद इन 24 आवर्स. सेम वे एज SBI is the lead banker, thousands crores are stuck. तो विद इन दिस होल प्रोसेस, यू नो, वन कांट सेल. मतलब इफ यू परमिट, आज जो पैसा 100 रुपये मिल रहा है, 2 साल अपने को भी पता है सर, आधे से कम मिल रहा है. So because of the law, because of so many judicial, because of involving many stakeholder, can we come out with a little bit, मतलब in between this initial becoming NPA 90 दिन पे होता है, there is no CA report, मतलब which you know can prescribe कभी ये account और खराब हो जाएगा. So with the using of the digital form, मतलब many of this Modi government does a lot. I mean, be flexible, empower the COC, what is written in the Supreme Court, say practical आओ, बेचो, जेब में पैसा डालो. I mean, using the online auction on the digital globally. I mean, my just thoughts adding to Mr. what Rahul mentioned.
No, but I think RBI and some of the banks are working on a secondary market for loan platform, electronic platform. So that is coming, I believe, very, very soon.
Yeah, I mean, that will result into a more recovery and increasing that what
Of
sir
course.
said, you know, intent. Practical, I mean, saying, sir.
This will be the last, sorry.
IBBI already has empowered these platform for distress assets.
Yes.
So that provides a platform in which buyers can bid for these assets, and it's a transparent way. Yes, it is being used, but more awareness needs to be created. In fact, this platform has not just for inviting bids, but also a provision for inviting bid for interim finance also, through a reverse auction process. So, I mean, those outside the COC can also participate in it. Yeah, possibly more awareness needs to be
Marketing and awareness, we should do more. Yeah. So thank you to my esteemed panelists, and you have been a fantastic audience. Thank you so much.
Thank you, esteemed panelists, for that thought-provoking discussion and giving us all plenty food for thought. And thank you for engaging with the audience and addressing all the questions. I now request Professor MP Ram Mohan from IMA to please present mementos to our distinguished panel members. So I request you to please present the memento to Dr. T.K. Vishwanathan. To Shri Behram Vakil. To Shri A. Unni Krishnan. And to Professor T.T. Ram Mohan. Thank you, sir. We will now break for lunch, and after lunch we will have simultaneous presentations in Seminar Hall 1, 2 and this auditorium. And the presentations will continue till 5 p.m. and then we will reconvene for concluding the conference at around 5:15, 5:30. Thank you, everyone.
Hello, 1 2 3 mic check. Hello. बराबर. Hello, 1 2 3. Hello, hello.
Organizing its third annual quiz on insolvency related matters. We had earlier conducted two quizzes successfully where we had more than lakhs of students, those who have participated, or stakeholders, those who have participated. So may I request all here present, this is just an informal, can they raise their hand if they have participated in our third quiz? Great. So, no issue, still time is there. So kindly just log into our website ibbi.gov.in. In the home page itself, we have a tab called Third National Online Quiz. So you will get the link. We are organizing this in association with mygov.in. So kindly register and do participate. Yes, sir, only 10 minutes. It will only take only 10 minutes. Thank you.
Yeah.
मैं वो बताते हैं साइड में खड़ा हो तो खत्म
Yeah, that's what I said. I'll let you know.
Good afternoon, one and all, for the afternoon session of paper presentations for the International Research Conference on Insolvency and Bankruptcy. We have our esteemed panelist, Dr. Aparna Ravi. She is a partner at Samvad Partners, and Dr. Sri Ritesh Kavdia. He is the executive director at IBBI. So just to lay the rules about how this is going to work, we have 4 paper presentations for the day. For this session, each paper presentation would be timed for 17 minutes, and we would have a 5-minute question-answer session. And we ask everyone to stick to the time limits. So the first paper presentation for this session is, the topic is IBC, Balancing Fairness and Equity. It would be presented by Ms. Pooja Singla and Mr. Vinay Pandey. Over to them.
Good afternoon, everyone. We are 2 authors and we are presenting the paper on IBC, Balancing Fairness and Equity. So the objective is very clear, that for any law to be effective, the processes must be fair and equitable for all the stakeholders. And in context of IBC also, this has been said time and again in various committee reports. If we see the Bankruptcy Law Committee report, which is the foundation of IBC, it has provided that a collective mechanism for resolving insolvency should be within the 4 corners of fairness and equity for all the stakeholders, and it is one of the hallmarks of a well-developed insolvency regime. Also, the creditor rights have been given utmost importance. Also, the World Bank Principles for Effective Insolvency and Creditor-Debtor Regimes has recommended that the creditor interest should be safeguarded and by the appropriate means, so that they effectively monitor and participate in the insolvency proceedings, as this is necessary to ensure fairness and integrity in the entire process. Then we have UNCITRAL Legislative Guide on Insolvency, which has also noted the importance of impartial resolution of insolvency and the preservation of insolvency estate to ensure equitable distribution of assets among the creditors. Lastly, we have a report of the working group on outcomes under the Insolvency and Bankruptcy Code, which has suggested a 3E framework for measuring outcomes of the code. The first E is effectiveness. It's a measure of the extent to which the insolvency system has achieved its intended objectives. The next E stands for efficiency, a measure of the extent to which the system has achieved its objectives with the minimum use of resources. And the third E stands for efficacy. It's a measure of the extent to which there exists some connection between the insolvency subsystems with the larger macroeconomic variables. So we'll talk about the first E, that's effectiveness. And for any process to be effective, it should be fair and equitable for all the stakeholders. So in this paper, we'll analyze 8 broad areas of the code where we feel that some intervention is required. We'd like to state that this is not a data-driven paper, but we have analyzed the legal jurisprudence that has been emerged around these areas. So the first area that we are analyzing is the verification of claims in resolution versus liquidation. Before we go into the provisions, it is important to understand the importance of claims in the resolution process. If we see the first point, the committee of creditors is formed on the basis of list of creditors that is prepared by the resolution professional. And it is the committee only which decides the fate of the corporate debtor, whether to give it a new life or to let it die. Next is that information memorandum is also prepared on the basis of list of creditors and the claims that has been verified by the resolution professional. And information memorandum is one of the instruments to give information to the resolution applicants. And in one of the judgments, it was held that information memorandum and the resolution applicant must know exactly what has to be paid in order to take over the business of the corporate debtor. And that information can be provided by way of information memorandum. So it plays a very crucial role. Another important point to note is that resolution plan is prepared on the basis of list of claims that has been prepared by the resolution professional. And we know that the resolution plan is binding on all the stakeholders. So the claims that are not considered in the resolution plan gets extinguished, which shows that the list of claims and the verification plays a very crucial role. We are also aware of the objectives of the code, which is resolution, and liquidation is considered only as a last resort. But if we see the powers that have been granted to resolution professional versus what have been given to liquidator with respect to the claims, RP can only collate the claims, whereas liquidator can accept or reject the claims. It has been clarified by NCLAT and Apex Court time and again that role of RP is only administrative, and it has no domain to accept or reject the claims. While we also note that there is no practical difference between the role that IP or liquidator plays, but the only difficulty that we are facing is due to the lack of provision empowering the resolution professional to accept or reject the claim. And this leads to unnecessary delays in the entire process, because then the creditors file interim applications before the courts against the non-consideration of claims by the resolution professional. Now the question comes is, keeping in mind the objective of the code being resolution and liquidation considered as a last resort, is it fair to limit the powers of resolution professional to only collation of claims while giving the power to liquidator to admit or reject the claims? So what we have suggested in the paper is that RP should also be empowered to make quasi-judicial determination of claims in line with the powers that have been granted to the liquidator. And also there should be mandatory timelines for filing of appeals against the rejection of claims by the resolution professional. Our next broad area is powers and duties of Committee of Creditors. Under the code, the committee plays a very crucial role in the entire process. It's considered as a supreme decision-making authority, whether to decide the resolution or liquidation, or whether the replacement of resolution professional. It needs to exercise also the commercial wisdom to decide on the approval of resolution plans. So given the powers that have been granted to COC under the code, the objectivity of the COC in decision making and its ability to best serve the interest of the stakeholders is as important as the rescue of the corporate debtor itself. So when we bind the resolution professional by a well-defined code of conduct, and it is continuously regulated and monitored by the regulator, so why not COC, in the hands of which the ultimate goal lies, is not monitored or regulated? Also, the Apex Court has held in various judgments that the adjudicating authority cannot question the commercial wisdom of COC. The Bankruptcy Law Reforms Committee also noted that judicial intervention should be kept at its bare minimum. It was to reduce the judicial delays which were prevalent in the earlier laws. So in that case, a well-defined code of conduct for COC becomes even more important. What we have suggested in this area is that there should be an appropriate code of conduct for COC members, which may include principles such as transparency, prior due diligence, disqualification for misconduct, and to balance the interest of all the stakeholders. We also know that IBB has already released a discussion paper on the need for code of conduct. So our suggestion in this area supplements what has already been said in the discussion paper, and which has been highlighted by the Standing Committee on Finance. Our next broad area is resolution versus liquidation, what suits whom. So as we discussed that the decision of resolution or liquidation lies in the hands of COC, and COC can even decide for liquidation at the first day itself. If we see the process in the resolution versus liquidation, there is no set distribution order in the resolution, but when it comes to liquidation, there is a predefined order, which we call a waterfall, where we give priority to the secured creditors over other creditors. And the government dues rank last in that. So there can be certain situations where the creditors would prefer liquidation over resolution. For example, if the resolution value is very close to the liquidation value, so the secured creditors may want to push the company into liquidation, because in resolution, there is no standard order for distribution. The resolution value can be allocated among the creditors in any order. We also call insolvency professionals as one of the 4 pillars of the code, but the professional has no say in the entire resolution process, and no opinion of that professional matters. Only they have to study the resolution plans, confirm that it is within the requirements of the code, and place it before the Committee of Creditors. So the question that arises is, can we achieve the objectives of the code, which is resolution and which is to balance the interest of the stakeholders, by just relying on the commercial wisdom of COC? The only logical statement behind what we are suggesting is that we cannot expect a particular beneficiary of the process to think about all other beneficiaries and to think of their interest. So what we are suggesting it's very important to have an independent sight over the entire process. We can cast a duty on the resolution professional to oversee the entire process and to ensure the value maximization by securing the maximum resolution value and to ensure the equitable distribution among the creditors. Also, there is need of legal intervention in the code where the insolvency professional should form his opinion on the resolution plans before passing it on to COC, and that opinion should also be taken on record before the NCLT while approving the resolution plans. Our next broad area is the treatment of provident fund and other similar dues in liquidation versus resolution. So one of the core objectives of the code is to balance the interest of the stakeholders. And this area is with respect to workmen and employees as one of the key stakeholders of the process. The claims that are filed by the workmen and employees, that includes various components, which includes the salary component, gratuity, provident fund, pension fund. So what we'll be discussing here is the differential treatment of these kind of claims in liquidation versus resolution. And even within liquidation, there is no settled law. If we see the liquidation process, the ranking is clear in terms of where the workmen and employee dues stand, and also in terms of preservation of gratuity fund or pension fund by keeping it outside the pool of liquidation estate. But if we see some of the conflicting judgments by NCLT and NCLAT, in one of the judgments, it was said that if the funds have not been created by the corporate debtor in a separate account for pension fund or gratuity fund, even then, these dues are the assets of the workmen and employees and are outside the purview of the liquidation estate, because these are the third-party assets owned in the possession of the corporate debtor. Another judgment by NCLAT says that liquidator has no domain to deal with the assets of the corporate debtor, which are not part of the liquidation estate. So if the funds are not maintained in a separate account, liquidator has no power to keep the money aside. Unlike liquidation, there are no similar provisions in case of resolution. The claims of employee provident fund organizations can be considered as government dues according to one school of thought, which comes nowhere in the resolution plan as we have seen in most of the resolved cases. And then there is another view which says that dues should be paid in priority to all other dues, keeping in mind the welfare of workers and the Provident Act provisions, which says that the claims of employee provident fund organizations shall have the first charge over all other dues. Also, a recent judgment by NCLAT says that there is no conflict in the provisions of Provident Fund Act and IBC, and it also directed to pay the Provident Fund dues in full. So what we are trying to say here is that PF and other dues are social security schemes of the state, and these dues should have preference over all other dues. In one of the EPFO cases, it was said that workmen all through their life save some portion of their hard earnings for the later part of their life after retirement. If such sums are being interlinked on par with debts of the creditors of the company, secured or unsecured as the case may be, then it is nothing but diluting most valuable and alienable right of a person on par with a property right subordinate to right to life. So as we have set jurisprudence and set provisions under the Provident Fund Act, where the employee dues are given supreme importance, unfortunately, the same principle has not been followed in the code. Categorizing them as operational creditors attracts nothing but only the liquidation value, which is almost nil in most of the cases. So our suggestion is the hard-earned money of the workmen and employees, as is saved in liquidation, should also be saved in case of resolution. With this, I would like to hand over to my colleague, Mr. Vinay, for taking through the next slides. Thank you.
Thank you, Pooja. Our next issue is the fee of RP versus fee of liquidator. Section 530 of the IBC includes the fee of RP as a CRP cost and means that the fee shall be decided by the COC. However, the code does not provide any criteria for deciding that fee. There is a clause 25 of the Code of Conduct which says the fee should be reasonable. And in view of that, IBBI has issued a circular which provides what the criteria for deciding this reasonableness. On the contrary, the fee of liquidator is either decided by the COC or as per the matrix provided in the liquidation regulation. The matrix is derived in such a way that the maximum fee is provided for the allocation distribution of asset in the first 6 months. So this is a type of success fee for the liquidator. Now, can it be said justifiable that a liquidator is giving the fee on the basis of distribution of the asset, while in the fee of RP there is no concept of success fee, or we can say the fee of RP is not have any link with the resolution value provided in the resolution plan. This issue is more problematic because during CRP, the scope of work, that is verification of claims, preparation of IM, then evaluation of plans, the evaluation metrics, these all are very complex in nature and it is very difficult to quantify them. The second issue, the fee during this CRP is decided by the COC, and COC is not always consist of the commercial bank. There are instances where the COC is consist of the home buyers or the OCs or the or the FCs which are not institutionalized, so they are not enough mature enough to decide the quantum of the fee. And third and last most important aspect, the RP makes every possible effort to stripe the CD back into the resolution. So in our view, he should be more, means we should be more considerate while deciding his fee. So with this, our one suggestion is that there should be some sort of reward for the RP, or in the line of the liquidator, I mean there's some sort of success fee for the RP. The second issue is the extent of procedure fairness as well as judicial review involved. Now, any business activity of the CD normally comes under the purview of more than one law. So there is always a link, or there is always a connectivity between insolvency law and others law. Even this interrelationship among IBC and other law is being very well defined in the Insetral principle, which says, I am quoting unquote, the relationship between insolvency law and other law should be very clear, and where possible, references on the other law should be included in the insolvency law. Now, IBC is normally silent about this interrelationship, especially in context of the resolution plan submitted by the resolution applicant. So, what is happening? Resolution plans contain so many waivers or concession reliefs that are not even in the authority of NCLT to grant these relief. So the problem is more aggravating because different NCLT have different approaches regarding these waivers. Some NCLT granting this waiver, while some NCLT just passing the conditional plan that we are approving the plan, but we are not giving you these waivers. In this regard, there are two provisions under the code which deal with this interrelationship. First is section 32, which said that the plan should not in contravention of any other law for timing in force. And second, section 31.4, which says that after the approval of the plan, resolution applicant shall take approval of the approved authority within 1 year of the approval of the plan. So we have two considerations here. First, whether these waivers or these concessions can be granted, and if they granted, who should be the authority for granting these waivers. So even we have noticed that sometimes the applicant seeks waiver that are not even relevant for the operation of that CD. Recently, even NCLT Ahmedabad in the SBI versus Metal Ispat Limited has observed that we are, I am quoting the verbatim, the NCLT, we are however constrained to observe that many of the waivers, relief and concession outs are without any application of mine. These have been routinely observed in previous cases involving approval of resolution plan. Therefore, the IBBI may be think of issuing appropriate direction in this regard. So we have a three-way, we had offered in our paper a three-way solution for this issue. The first, we need to identify the waiver relevant for the operation of that particular CD. This can be done by the RP during the CRP, the introduction of a compliance audit in the line of the due diligence conducted in the M&A, where second, RP can vet all the contract entered by the CD so that he has the first-hand knowledge of the compliances need to be done under any other law, and thereon that compliances need to be passed out to the resolution applicant. Second, there is a Form H under the CRP regulation. That Form H may be amended to provide the list of compliances and approval needed to applicant, and there should be a time limit provided under the code for each authority under any other law for granting this approval, and there is and we need to introduce concept of deemed approval. Suppose that authority is not approving within timeline, then that should be need to be approved.
I think you need to conclude. Your time is up.
Just 1 minute. Okay, I will wrap it fast. We have just 2 more.
Just 1 minute to conclude.
Okay, so just to fast point.
Just finish in like 2-3 sentences.
Oh,
If possible.
okay, just 2 issues. We need one issue is to
Sure.
give in a time frame to A for approving the resolution plan because there is so much pendency on that part. And second, the last issue of our is there is a uniformity of judicial review in the code. Under the code, when the registration of any IPA or IU is not granted by IBBI, that can be challenged to NCLAT, but there is no such remedy available for IP. So just uniformity on this approach. Thank you.
Thank you, Poojan. Yeah, so thank you. That was a very good presentation. I think you've dealt with this paper seems to deal with a lot of issues, each of which I think can be its own paper and very interesting suggestions. One question I wanted to ask, because I think your title is about fairness and equity. And to me, all of them, and I just wanted to understand how are you defining or looking at fairness and equity, because some of the suggestions didn't exactly go to me into fairness and equity. For example, you're talking about the collation of claims and saying the RP, the suggestion you had there was about the RP being empowered to decide on the claim similar to a liquidator. So I just wanted to understand how does that go into fairness specifically, or are you looking at fairness and equity much more broadly than what I was saying?
So, ma'am, it is with respect to the powers that have been granted to resolution professional versus liquidator, because we have the core objective of the code as reorganization of the corporate debtor and not the liquidation, because it is considered as a last resort. So I think in resolution, the power should be extensive and not in the liquidation. We can have the same powers in case of liquidation also, but we think it should be fair in case of resolution also.
So you're sort of comparing the powers of liquidator versus resolution.
Yes.
And I have a comment that you have selected too many topics, and maybe you could not just make justice. At least some you could see outside what does UNCITRAL says, what does other jurisdiction have on these parameters. Otherwise, it just becomes your opinion sometimes. So, have some small issues, but go deep into it, that, or if you can expand even this present paper with some insights from practices abroad, that will be great help.
Sure, sir. We'll take that into account while finalizing the paper. Sir, in the paper we have written many things. It's just because it's in the slides were limited, so we couldn't present here.
No, sorry, can I? No, so I just 2 things. One, what Sumant mentioned, it's a smaller point, but very, very important point about this, which if IBBI can please take into account, because what it's doing is it's delaying the approval of the successful plan. So as they correctly say, if you have a grievance, please take it up sooner than later, and certainly not wait till approval of the plan. So that's a very good point. And unfortunately for you, your second last slide, which is again something which is a huge point, it's not a small point, is implementation. Ritesh ji, there are cases, obviously I can't take names, but they have a plan is approved, not implemented, so they are taking use of the assets of the company for 2 years without any payment. And we are talking thousands of crores, so the banks get no money, they get full benefit, and there's no implementation. And now that has become a nice model. So anyone who wants to do Hera Fairy says, let's follow this model. Free mein mil raha hai. So that second last slide was a very big one.
That was very important. Also that whole thing about approvals from different authorities, right? That's what that timeliness for that. So I think they're all very good recommendations. I do agree with Ritesh that, maybe you can focus on a few of these. I think one big one is this whole difference between liquidator and resolution professional. And there are lots of issues on that. And even just looking more deeply into that, looking at how it's done elsewhere, which I think you've done in your paper, could be a very effective paper. Yeah.
Not just a fair and equitable point, it also goes beyond this to seeing how it can reduce the workload of the NCLTs. Because today there is a lot of clogging of the matters because these claim issues go there because RP says I am only supposed to verify, I can't decide.
Yes.
So even small matters which hopefully the parties will accept his decision end up on the in the NCL.
So we have also proposed that there should be mandatory timelines for filing the appeal so that it doesn't delay the entire resolution process. We have suggested that.
Yes, sir. Actually, in SRSTL, Supreme Court has said that the power is not adjudicatory in nature. So, yes, sir.
Yes, success fee, you are proposing or opposing?
We are proposing.
You are proposing.
For RP.
For RP.
Actually, we are saying.
So, the fee structure is not there in the regulation. Do you support fee structure to be provided by IBBI? And if yes, in which format or structure? Like it should be related to a performance, like you till the stage of this admission, you will get this much, so that he will act faster, or he knows this much is the fees only is coming his way. So by delaying that, he will not get anything, he will lose. So what type of structure you have any thought?
Actually, sir, in liquidation, we have linked the fee with the success of the liquidator. If he's allocating the asset in the first 6 months, he will getting higher fee. So we may contemplate some such type of framework in CRP also. Because in CRP, time is more essential than in liquidation. I'm not saying in liquidation it's not essential, but in CRP, time has a more value compared to liquidation, sir.
Okay, we'll talk. I had other things, but we'll stop here. No problem.
Thank you.
It was really
Just
very
to have a very
interesting.
few quick comments. I think all points are absolutely good, but I think the point is that I would suggest that each area you can have one research. You can take a team, you can take a lead, and then do the research. I think that would be really fruitful.
We'll try to go deep into the major issues, sir.
And I think you have missed one point, that this law is a commercial law, not a socialistic law. So when you talk of equity and fairness, it should come from the commercial side. Like here, equity comes from section 53 or the waterfall, no? Not from like providing jobs or like the PF and all that. That should be kept in mind. So fairness equity has a different angle here.
Okay.
Thank you.
Thank you, ma'am. Thank you, sir.
The second presentation for this session deals with the topic Resolving Discoms under the IBC, a comparative law approach. It would be presented by Mr. Pratik Tata.
Yeah. Good afternoon, everyone. Thanks to the organizers, I'm Ahmedabad and IBI for having us all here. This presentation looks into one specific sector, which is the electricity sector, and I'll point out to the recent developments that kind of motivated this discussion. So before I get into that motivation part, let me just give a broad overview that may be relevant for the purposes of this discussion. So discom stress is one of the biggest problems facing India. This is a matter that is usually discussed in a separate group. So we probably as insolvency lawyers and policy thinkers do not talk about this, but so that's why this one slide. So in the electricity sector, there are essentially three parts, right? Someone generates the electricity or produces the electricity. The electricity is then transmitted over high voltage wires And finally, there's a step-down mechanism by way of which the high voltage is reduced to low voltage and transmitted to the end user, right? So there's the generation, there's the transmission, and there's the distribution. Now, when India got independence in 1947, after that, in 1948, we had our first Electricity Act. Obviously, pre-independence, there was another one in 1910, but the first Electricity Act was in 1948. Now, this Electricity Act brought both, all the three, generation, transmission, and distribution under the state electricity boards. So they were brought within the complete control of the state. Now, this situation continued till early 90s. In October 1990, generation of electricity was liberalized, although transmission and distribution remained within state control. Now, the situation as of today is that most discoms are basically the shortened version for electricity distribution companies. Most discoms are state-owned. 10% of distribution happens through private distribution licensees, whereas 47% of generation happens through private sector players, right? Now, discoms usually have monopolies in their area of functioning. This is a very unique attribute in this sector. And most of them, as I mentioned, are owned by the state, and therefore a lot of political economy pressures influence this sector, right? This is the reason being, as we know, increasing electricity rates will have huge political implications. And that's why this sector is riddled with a lot of political economy challenges. And this is the fundamental reason why you have stress in this sector. Right? Now, according to some estimates, the total discom losses for FY 2021 was around 0.9 trillion rupees, which is around 0.7% of the Indian GDP as of 2021. Right? And overdue payments to generators was 0.68 trillion, right? Because so that if the discoms are in stress, they are unable to pay to the generators who are producing the electricity, right? So it has a systemic issue also. So it is in this context that the question of what role can IBC play in resolution of this discom stress is something that we need to really ponder about. And the reason why we need to ponder about it at this point in time is because late last year, on November 8th, 2021, there were two developments that happened. First, the Madras High Court, in a judgment, gave the decision against the discom because it held that the IBC does not exempt any government company under Section 2, subsection 45 of Companies Act, including state-owned discom. Now, the position of law was pretty much clear. However, as far as the discoms are concerned, this was a clear judgment that clarified that, yeah, discoms are like any government company and therefore can be subjected to IBC proceedings. And the same day, the Union Power Ministry also clarified via letter after taking opinion from the Legal Affairs Department that discoms could be subjected to IBC. Now, this led to some thinking inside the government as well as outside about what will be the implication of putting discoms into IBC, right? I mean, will there be going concern sale? What happens if a discom gets liquidated, right? Who provides electricity? Suddenly your power goes off and then, it's a complete mess. So this paper is based in that context. It tries to, first inform the debate rather than coming up with any conclusive policy suggestions. So unlike most of the presentations that we have seen till now, I will be actually putting the questions to you rather than you putting the questions to me. Okay, sorry. So the methodology that I will follow is, I'll review the experience of insolvency resolution in the electricity sector in the US and the UK. I will highlight some of the idiosyncratic legal features that have arisen in these cases. And the aim, as I said, is to inform the discussion on discom resolution under IBC. Hopefully, this will trigger a policy discussion, and this paper is not going to make any conclusive policy suggestions. So USA, right? Okay, so the context in US, just a historical timeline. So during Great Depression, there were around 53 utility holding company bankruptcies in the US. Then they brought in an act, PURP Act, Public Utility Something Act of 1935, which substantially reduced the number of electricity holding companies. And after that, the energy demand increased during 1960s, so there were no further insolvencies after that. During 1970s, there was high inflation, high interest rate, and crude oil prices also went up, because of which electricity prices increased and consumption reduced. And just before that, there was a lot of, because energy demand was growing pretty healthily, a lot of investments went into nuclear power production in the US. Now, in the 1970s, because of all the other factors, when electricity demand started reducing, a lot of this nuclear power investors found themselves in trouble. So this was the first time, and as you know, the US bankruptcy court, new one came into effect in 1978. So the first test that happened of the code vis-a-vis the energy sector was vis-a-vis the nuclear power plants going going into restructuring. And that's when this issue of how do you allocate costs between the consumers and the investors in the electricity sector became an issue in the restructuring, right? Nowadays, however, utility bankruptcies are quite common, given the competition in generation and also climate change risks. Now, as far as the US law is concerned, there are very few special provisions specifically targeted at the electricity sector. So one, for example, is section 1129A6. This is basically the confirmation of the plan, the section which is like, in pari materia with, say, section 31 of the IBC. This provision basically says that any rate change provided for in a plan must be confirmed by the relevant regulatory commission after confirmation of the plan, right? The reason why this provision exists in the 1978 Act is because under the FPA, the Federal Powers Act of 1920, the FERC had jurisdiction over this issue, and there has been a lot of clashes between the bankruptcy courts pre-1978 and the FERC. So that's the reason why in 1978 they clarified this provision in the law itself. For all other practical purposes, utility insolvencies are pretty much treated just like any other insolvencies. However, there are some idiosyncratic issues, as I mentioned, and one that I'll be focusing on, which I consider to be the most important for the purpose of this audience, is the rejection of executory contracts like PPAs through bankruptcy. Moving on, I'll just again, this is something that was discussed yesterday by my colleague from Cyril Lamachand, Mr. Bisht, who had discussed the executive contracts in great detail. So I wouldn't go into that much of detail. I'll just give you a broad overview. So under 365A of the US Bankruptcy Code, what it says is that except in certain cases, the bankruptcy trustee, which is the equivalent of an insolvency professional or a resolution professional, subject to the court's approval, may assume or reject any executory contract of the corporate debtor, right? Now, in the US, there has been a lot of debate about what's an executory contract, what kind of contracts can be rejected, etc., etc. That debate is, we had a review of that debate yesterday. I'm not getting into that part here. So the main point that I'm making here is that under the US law, a corporate debtor, once it is inside the Chapter 11 proceeding, can reject any contract under which it has ongoing future obligations, right? Because it considers it to be very onerous. Now, those of you who are aware of the Bhushan Steel Plant's acquisition by Tata Steel, this is exactly what happened, and the NCLT allowed Tata Steel's resolution plan to terminate the PPA that Bhushan Steel had with Bhushan Energy, right? So it's a bit like that that happens in the American context. And this is exactly why distribution and generation companies in US have used 365A to terminate power purchase agreements when they are in a Chapter 11 proceeding. And that's one of the advantages that an energy company gets by triggering a Chapter 11. Now, what's the friction that is caused? The friction that is caused is that when you're terminating a power purchase agreement as a DISCOM, you are probably doing that because you can purchase energy for a lesser price from some other guy, right? That's the main reason. Now, the moment you do that, you are essentially changing the wholesale price of electricity without the FERC's approval, because FERC under the Act. Okay, let me just move to the next slide. So FERC gains its jurisdiction from the Federal Power Act of 1920, as I mentioned. The Federal Power Act's main purpose is to protect electricity consumers through orderly development of plentiful electricity supply at reasonable rates. More specifically, FERC has exclusive jurisdiction to determine the reasonableness of wholesale electricity rates. And therefore, every privately negotiated energy contract in the US must be filed with the FERC and certified as just and reasonable for it to be lawful under US laws. Now, this is called the filed rate doctrine. Essentially, it means that a utility's right to a reasonable rate under the FPA is the right to the rate which the FERC files or fixes, and these rates cannot be challenged before a court as unreasonable. So the question is, and no court can hear a challenge to these rates as unreasonable, how is it that the bankruptcy courts can come and nullify these contracts, right? So even the FERC actually cannot change these rates themselves. The only thing that it can do is it can change a file rate under certain circumstances. One is that if it may impair the financial ability of a public utility company to continue, or cast upon consumers an excessive burden, or is unduly discriminatory. So these are the three grounds on which FERC itself can change the rates. And therefore the question arises is that if neither the private parties nor the regulator can change the rate, who is the bankruptcy court to come and suddenly terminate the contract, right? So there are 4 cases that are important from this perspective that discuss this conflict. I won't discuss the first case because it's old and also it really does not squarely address the PPA issue. I'll be discussing the 3 other cases, the Mirant of 2004, Calpine 2006, and First Energy Solutions 2019. Hopefully this will give you some flavor of the actual disputes that kind of arise in this sector. Now, let's start with Mirant. Okay, so Mirant was a power producer and purchaser. It bought out the power generating facility from a public utility called PEPCO, plus the PPAs that PEPCO had with other producers, right? So other sellers of power in the wholesale market. However, some of PEPCO's contracts, some of those PPAs were non-assignable. So what PEPCO did was it entered into a contract with Mirant saying that, okay, I cannot assign you this PPAs. What I'm going to do is I'm going to buy this energy the way I used to do under the PPAs, and you enter under a contractual obligation that you are going to buy out this energy from me, right? So a new contract was entered into post this transaction. Now, what Mirant sought to do after a couple of years was to enter into Chapter 11 and nullify that contract, that obligation to purchase power from PEPCO under those non-assignable PPAs, right? And the court actually allowed this rejection. The reason was that the energy that Mirant was taking so long from PEPCO was no more necessary given Mirant's new business strategy. So that was the reason that we are changing our business strategy. We don't need this energy anymore, and therefore, allow us to terminate this contract. And the court allowed it. In Calpine Corporation 2006, this was a slightly different case where Calpine was a power generator. It entered into PPA to supply electricity. It took a huge amount of debt to build those power plants, but in the meantime, the natural gas prices went up, right? So the prices that were fixed under the PPAs were significantly lower. So it was in Calpine's interest to renegotiate the contracts and increase those prices. So what they did was to trigger a Chapter 11 in which the only reason that Calpine gave was that I'm happy to supply the electricity, but not at these prices, but at the market determined price. The court said no. What you could not have done without the consent of FERC, you cannot use the bankruptcy court to do the same thing, right? This is avoiding FERC. So the court refused granting this approval to terminate the PPA, right? So this was the exact opposite of what Mirant did. Now, then comes First Energy Solutions in 2019, and what happened in this case was that the DISCOM had 3 different businesses, which was to distribute to the retail, to some corporate affiliates, and to sell in the market, in the open market. Now, after some time, they decided to sell off the retail business. Now, the retail business in US at that time, when they were in the business, were required to purchase RECs, the Renewable Energy Credit, right? And because at that time, this was in 2003 to 2011, RECs were in extremely short supply, and therefore, FES, First Energy Solutions, entered into long-term PPAs to purchase RECs at a reasonable rate, right? Now, they purchased these RECs through PPAs because they were in the retail segment. Now, in 2011, the board took a decision that we don't want to be in the retail segment anymore, right? We want to sell off this business and get out. The question was, if you want to get out of this business, can you terminate these PPAs or not? And the court allowed this termination, saying that, you know, they don't need it because they are getting out of the business. So it seems that the US allows termination of PPAs through bankruptcy court if it is a part of a genuine restructuring of the business, not when they are trying to avoid the FERC's jurisdiction through the bankruptcy courts, right? This is one of the main uses of bankruptcy code in the electricity sector in the US. Now, coming to the UK context, I have like 3 minutes. 2 minutes, okay. So I'll quickly wrap this up. So in UK, okay, we know this, you know, Thatcher came, privatized everything, the electricity sector got privatized. So the Energy Act 2004 and 2011, there are two. They have actually a provision for failing energy supply companies. Ofgem, which is the energy regulator in UK, has three levels of strategies. So the first thing when an electricity company goes back, enters distress, is to try, where the regulator tries to get it into a private trade sale. If a private trade sale fails, then they try and revoke the company's license with 24 hours notice and appoint a SOLR, which is supplier of last resort. This is a bit like what happens in banking under the BR Act, where the company, a bank gets merged with a healthy bank under Section 45 of the BR Act. The third would be to revoke the company's license with 24-hour notice and apply to the court for a energy supply company administration order. This is a special regime that has been created under the Energy Act to deal with big energy companies. SOLR is for small companies. So under SOLR, the Ofgem asks its suppliers, competing suppliers to the failing business, if they are willing to be considered as a supplier of last resort, and what would be the terms of supply. And Ofgem also has the power to direct a supplier to act as SOLR. Once SOLR has been identified, Ofgem revokes the license of the failed company, and the supply is immediately placed with the new company, which is going to act as SOLR. The failed company is liquidated just like any other company under general insolvency law. The ESCA is slightly different because this is meant for, the blue moon, the like once in a blue moon kind of instances where big companies, like the first company that has gone under ESCA is Bulb. Last year, it went into ESCA. So the main differences are that here the duty is actually to balance the interests of the creditors as well as consumers, which is not a duty under general insolvency law. And the administrator is required to run the company till it is restructured, sold, or its customers are transferred to other suppliers. Some unique provisions in the ECA is that the Secretary of State may make grants or loans to the company into the administration. So it's like an interim finance being provided by the state, but there's a provision where it requires approval of the Treasury, which is the Finance Ministry, and the government funding is recovered through a levy on the industry. So these are some special provisions that's there in the in the special administration for energy companies. So ESC, as I said, was untested till now. It's only in 2021 that Bulb Energy, with 1.7 million customers, has gone into ESC. We are yet to see what's the result of that. So applications for India, areas to look out for. These are the questions that I have for you. Can DISCOMs undergoing CIRP cancel burdensome PPAs through NCLT? The second would be, can tariffs be altered through IBC if low tariffs is the reason for DISCOM stress? And the third would be, will a SOLR or a special CIRP regime for DISCOMs work in India? Thank you, ladies and gentlemen.
Thank you. We'll have a few questions. No, this
Sure.
is very interesting. I'd like to wish I could push you and ask you if you had any thoughts on, especially the first question, I think is very interesting. I mean, I think the larger question is whether we need a special regime for DISCOMs. But
Sure.
on the first one, what is your view? Do you think that if this were done specifically, would this greatly help the DISCOM resolution process?
So I'll give you my narrow perspective. I'm still forming an opinion on the subject, so I don't want to jump into this because electricity is a very complicated sector and I don't understand it fully. I am looking at it from the perspective of the insolvency law lens, and from that narrow perspective, what seems to have happened is States like Punjab, Gujarat, Rajasthan, Karnataka, and UP have all tried to cancel PPAs because, as I said, the discoms are owned by the state government, and the state government's incentive is to keep the prices low. Therefore, whenever they have any other alternative sources of cheaper energy, their incentive is to scrap all the earlier PPAs, right? So Andhra Pradesh passed an order sometime in 2019 doing the same, where they wanted to cancel the earlier PPAs. And the Andhra Pradesh High Court said that, no, you cannot do that, right? Now, there's a tension here. The governments want to move their sources to some cheaper source, but they can't, right? But there's a risk that sometimes they will act arbitrarily. They will, not respect contracts. The question is, can we create a legal framework to handle this tension, right? Now, IBC provides that platform to do that. Provided, there's a section 20, subsection 2, clause B, which empowers the RPs to amend or modify contracts entered pre-CIRP, right? Now, this is not yet tested in the context of PPAs. But I believe that if IBC could provide a platform for distressed discoms to come in and terminate PPAs, a lot of state governments would be interested in this. And, because they are clearly interested in cancelling PPAs, but the way they are doing it seems completely arbitrary, right? They are just using their legislative power to arbitrarily scrap PPAs. So the question, from this perspective, it seems quite legitimate if IBC allows for a platform for state governments and their discoms to come and renegotiate their PPAs, right? But again, we have to think through, like the US courts have done, under what circumstances could those powers be utilized? They cannot be utilized in the whims and fancies of the government, but only when it's a part of a genuine restructuring of a discom.
I have a comment to make. Basically, in electricity, there are three kinds of players. One is the discom that you have covered. One is generation. My worry is about this, the third aspect. Transmission as such is doing good. Discoms are doing good, doing bad because of their own inefficiency or own compulsions. But the generation companies somehow are affected by the policies, especially the thermal power ones, or and those are the ones which are in the private sector. So it worries that if such things happen, they will further go down, and their risk will further go up, going to insolvency or something, which in a sense can affect the country.
I agree. So as you correctly point out, whatever happens in discom is going to directly affect the producers of power, who are just generators. The question is, would they be better off than today? Today, arbitrarily state governments are cancelling PPAs. No one, therefore, except for the biggest players, would be interested in this coming into this sector in the generation. Even if they come, they will charge very high discount rates because of the risks, the policy risks, the sovereign risks involved, right? So the question is, how do we reduce those rates, right? How do we reduce the risk? Can we provide a legal framework through which PPAs can be renegotiated? The question is, can IBC provide that legal framework? Now, all that I'm saying is that I agree with you. It's a complex sector. There could be a lot of other implications. But as of today, there is nothing. So Punjab comes up with a law saying that all our earlier PPAs are cancelled. This is completely arbitrary. No one's going to invest in Punjab generation if the Punjab government can overnight cancel all the earlier PPAs. The question is, given this context, can IBC stabilize the ecosystem by providing a platform, by providing a jurisprudential basis for cancelling PPAs through IBC when a discom is under stress? And I believe that IBC holds potential given what we have seen in the US markets. IBC could hold potential if we can think of something like a special CRP regime for electricity companies. But again, those are slightly different. That would require a more holistic coordination between IBBI and the Power Ministry, probably, and CERC, etc.
My concern is that even if we give power to discoms to go through some process and terminate the PPA, it makes the other parties lesser interested. They would like to keep higher margins. So ultimately, it harms the sector. The sector is very complicated.
No, it's a complicated sector. That's why I said it's a very complicated sector, and these are just initial thoughts. Yeah.
Basically, what I see the problem here is the defaulter is not the CD, but the government, to whom you cannot take to IBC. Here, state governments are the defaulter.
No. The state government owns the defaulting company. So the defaulters are the
discom. Is a different entity Government is a different entity.
Yeah, so the defaulter is the company, not the government.
No, state government is defaulting but not paying to this company for the supplies.
No, okay, so that, yeah, so there are other chains. I agree, yeah,
The problem
yeah,
lies
yeah.
where the state government is not paying on time, leading this company
Yeah.
to default.
Yeah.
So even in the current model of IBC, you can take this company to IBC.
Yes, you
No
can,
issue.
yes.
Yes. So why not take them to IBC, and then there should be a provision to like renegotiate the PPS. So this power should not remain with the government.
No, it has to be through
should
IBC.
be
No,
with
no,
the
absolutely,
NCLT member,
absolutely.
that as per resolution plan, either they can forego with the PPS or renegotiate. That should
Absolutely.
be the power given to the resolution applicant.
Absolutely.
Okay, so that solves your problem.
Exactly.
Yeah.
That's the point that we are making.
You
yeah.
see that Tata Power in Gujarat.
Right.
So ultimately they waited to renegotiate with the government. And here
Right.
the problem, if the government goes back on contract, that is a breakage of rule of law. See, government cannot break the contract. No? Anybody else can be a defaulter,
Right.
not the government.
Right.
So that will be a very bad precedent for the country, that government backing out on the contract. On the other hand, the defaulter company can always be taken to IBC and resolved. And in resolution plan, one of the thing is PPA renegotiation or maybe termination.
Absolutely. So that's completely agree with that.
I think let me add. Yes, Pranava. I think Pratik, I think you have made a really absolutely good point, and I'm really cognizant about these issues. And I propose that from IBBI we'll take forward this issue through the forum of regulators, and we'll have a discussion with the experts panels. So I will take that lead. Second issue is which you are mentioning about the inter-se jurisdiction between the other act and IBC. But our IBC is a little bit clear, because section 32 says the RP resolution plan should be consistent with the other laws. So we, in our IBC, there is already a provisions which the USA introduced later on, but we have. So I think that takes a little bit care. But as far as this insolvency of the DISCOMs is concerned, what will happen? There is other provisions of the act says that once the utility is getting insolvent, but at the same time the license will also get cancelled. Because what will happen if he's defaulter in their utilities, then the license also they will default. And once the license is default, then automatically their rights of distributions will get revoked.
Right.
So what will happen? There could be two parallel process. And now if the resolution plan is getting submitting, then they have to. The another issue is that the resolution plan, who is the incumbent is there, he has to qualify those criteria. So RP should have to submit that. And there is a provision also that in our section 20 and I think 20 and 24 of the Electricity Act 2003, it provides the sale of utility. So our jurisdictions provide that how to sell of the utilities and sell of the transfers. So that takes care of this little bit. But what you are suggesting here is the no solutions. I think here are all questions. So look into those provisions and make some suggestions and some propositions. I have also some propositions in my mind.
Sure.
So we can deliberate on this issue.
Sure. Thank you for that, sir.
So just one last very small short point. So, so with regard to the recommendations made, I have a slightly differing opinion wherein if you read that Honorable Supreme Court's order of Gujarat Urja Vikas Limited, it has the NCLTs they're supposed to be very reticent when they are exercising their jurisdiction under clause section 60 subclause 5, which is like the fountainhead of all the litigations and all the powers that the NCLT has. So when we are actually requesting the NCLT to sort of surpass the competent authority and assume power of other authorities to resolve a DISCOM, I think generally everybody would be a little reticent when it comes to the Indian jurisdiction. Like,
No, that's a fair point. Fair point. I mean, that's why these are not recommendations. These are all questions. This is meant to inform the debate. That's all. Yeah. Thank you.
Thank you, sir.
Thank you.
This is a very interesting topic. Sorry, we didn't have enough time to actually go.
We are constrained for time, so I request the questioners to stick to a 5-minute time limit. The third presentation for today's session deals with the topic situating mediation within India's insolvency framework, an innovative and efficient intervention. The presenter is Ms. Akriti Tiwari.
Good afternoon, everyone. I'm Akriti. I'm a third-year BA LLB law student at Jindal Global Law School. So as mentioned, my topic is situating mediation within India's insolvency framework, an innovative and efficient intervention. Sorry, how do? Okay, thank you. Right. So essentially, the introduction and objective of this research is largely because, as we've seen over the last 2 days as well, there is a pressing need for certain reforms to be enacted in the IBC. Right. We're looking at a lot of time delays. And as I remember in yesterday's session, Mr. Shardul Shroff, in fact, mentioned about how natural justice tends to actually be detrimental at times when used with the IBC, right? It can cause several delays. There are several technicalities that actually waste time, right, with respect to the adversarial process. And so for that, the response that I wanted to formulate is something that's been a burgeoning topic among researchers in India, and that is introducing mediation to combat the same. So the existing issues in the enforcement of the IBC, of course, are through court delays. There's too little infrastructure to deal with the high number of insolvency cases, and that is why, of course, the suggestion is made. Right, so the aim of the research is, of course, to situate mediation within India's insolvency framework by borrowing from other jurisdictions as well. India very uniquely also has a lot of roadblocks that I intend to maneuver around. And I believe that is a sort of a newer intervention in this topic, because generally we stop at, it works in other jurisdictions and hence it'll work in India. Right, so of course, principal methodology is I relied on qualitative content analysis, which is secondary resources. Being an undergraduate student, I had to speak to some practitioners, so interviews, of course, the judgments of courts. So that has been essentially my approach. Now, I started with a cost-benefit analysis of mediation in Indian insolvency. And to begin with, the relevance is largely exacerbated by the COVID-19 pandemic, because what we're really seeing is a blurring of borders and a complexity in the nuances of insolvency disputes. That complexity that I will argue throughout my presentation is what prompts us to actually expedite the process towards moving towards alternatives, right? So mediation, I'm going to talk about first why mediation by talking a little bit about the process. So mediation can be understood to be a facilitated negotiation, right? There are four tenets of mediation. Of course, firstly, it's a confidential process, right? Secondly, it's a voluntary process. The parties volunteer typically to associate themselves with the process of mediation. They may choose not to engage anymore with mediation if it's not working out and they're not able to reach a settlement. The mediator must be neutral and impartial. He cannot be connected with the dispute, and hence facilitating that dispute is generally through a very fair means of mediation. Additionally, it's a process of self-determination. So the parties come to a settlement and it's not coaxed by the mediator in any way. We do have statutory basis for mediation in a domestic and international context. As I'll elaborate, in India, we have seen several legislations such as for MSMEs and RERA and many other statutes that have actually taken cognizance of mediation and done fairly well with them. In an international context, we can look at Article 4, for example, of the Hague Convention for the Peaceful Settlements of Disputes, which enshrines the aforementioned principles that I mentioned into law. So it touches on the mediator's role as a facilitator and bringing parties with opposing views to a settlement. Under Article 4, mediators diminish hostilities to ensure a negotiation is productive. Right? Now, mediation is not formal. There's an attitude of win-win versus win-lose. The most important word in a mediation is generally stakeholders. And that's a word that, not coincidentally, we've seen being brought up multiple times over the last 2 days, because insolvency, a good insolvency regime, at the end of the day, like I think some of my co-presenters also mentioned, is one that will keep in mind stakeholders and their interests. Mediation structurally is exactly that. Whereas in an adversarial process, we're still looking at a win-lose. So if we are able to measure out stakeholders and equate their interests, that's sort of not exactly a commonality, I would say. So benefit of all stakeholders, of course, well suited to insolvency. Insolvency processes are stakeholder driven and they're entirely based on mutual benefit of all parties, right? We reach a creative, mutually beneficial solution that is party driven. It's reflective of logic, interests in the best solution rather than application of law to facts. And this kind of brings us back to, again, natural law being a bit of a hindrance when it comes to perhaps arguments and going over in good technicalities in court that only delay the process. Again, win-win versus win-lose is where we really want to be. Now, mediation is less clinical and both parties do stand to gain. The IBC's unique ability is that it tends to balance the benefits and gains of all stakeholders, creditors and debtors. And this is why it's such a landmark legislation, as we've seen. And the success of the insolvency system, again, is of course in how you balance the interests of these stakeholders, which makes mediation most suited. Now, in a court or an arbitral tribunal, one party loses, another gains. This has its merits, and it's definitely premised in firm notions of justice and equality. However, business disputes often require that all stakeholders' interests be balanced, along with their obligations and assets in a fair and equitable manner. Because of adversarial systems, this has not necessarily been the case in practice in insolvency law. Now, the NCLT is the appropriate forum for all matters currently pertaining to corporate insolvency. Jurisdiction of any other forum is ousted, as per, of course, the judgment in Dhulabai versus State of Madhya Pradesh, which places, of course, an express or implied bar upon the same. And this greatly increases the burden on an already overburdened system to hear, decide, and dispose of matters within record time. 270 days ensures that goal of time-bound resolution entirely bypassed. Even extending it, as in the case of SR Steel, to 330 days does not seem to have made much of a difference. And of course, time-bound resolution being an integral part of the code makes this a slightly troubling predicament we find ourselves in. And we've seen that litigating insolvency disputes is one of the most time-consuming aspects of the process, right? So provisos to section 12(3) of the IBC extended the 270-day limit to 330 days, an equally unfeasible limit as stated. Concerns materialized, for example, in SR Steel versus SK Gupta, and the court, essentially said that proposing a mandatory sealing could contravene fundamental rights through Article 19(1) of the Constitution. So the term mandatorily, essentially, when we look at mandatory mediation, we look at mandatory adjudication. While, of course, we do understand that the implications for this may come off as contradictory, what we're really trying to do is to get parties to essentially flesh out and resolve their disputes at its core. We're not necessarily losing ourselves in the technicalities of the matter anymore. And then, and yes, so I'll just move my screen. Right. So now, when we move to looking at mediation in an insolvency in an international framework, what we really are trying to do is look at how it's been a wild success in other jurisdictions and why that may or may not be replicated here. I'll argue that the models, though being different, rather than being different models, they essentially have the merits and they keep those the same. So in the application of mediation in insolvency in an international context, we've seen a growing interest as a mainstream means of dispute resolution, right? So we've looked at, in the case of MSMEs, there's been a routine simplification of the process, especially post-COVID. When we look at Australia, the UK, and the US, and World Bank and UNCITRAL as well have tried extremely hard to essentially bridge the gap between mediation and insolvency, right? So while mediation, of course, hasn't been explored as a means to resolve disputes in India, it has been, insolvency disputes in India, it's been extensively utilized in a foreign context. So nations such as the US, France, Singapore, Italy, and others have made mediation an integral part of how their insolvency frameworks operate. That being said, there has been a clear shift internationally towards insolvency as stated in a post-COVID world. Now, in an attempt to streamline the insolvency process, a great deal of deliberation has been made on moving towards a less formal and simplified resolution for insolvent MSMEs on an international forum. And this evolution has prompted foreign interest in mediation and insolvency. And the Singapore Convention Week, in fact, of 2020, held a panel discussion specifically on the use of mediation and insolvency. In Singapore, Australia, the UK, and the US, of course, we've seen the desire for simplification here as well. In 2021, in the recommendation B4 of the World Bank's Principle for Effective Insolvency and Creditor-Debtor Regimes have yielded strong support to mediation as a solution for insolvency processes globally. Additionally, the UNCITRAL legislative recommendation on the insolvency of micro and small enterprises have officially recognized mediation to ensure greater accessibility to insolvency regimes. Moving on as well, the UNCITRAL model law on cross-border insolvency, Article 27A, mandates the use of mediation for insolvency disputes. Again, the UN Convention on International Settlement Agreements resulting from mediation, or the Singapore Convention, has laid out framework for enforcement of mediation settlement across borders. What this means is that the international arena has fully taken cognizance of the merits of mediation, and more specifically, the merits of mediation in insolvency disputes. And it appears clearly from looking at the case studies that we will be examining in the EU and the US, that it's been clearly a success and something that perhaps we could be inspired from to solve our own predicaments. So, for example, in the EU, which is our first case study, now we observe mediation in insolvency disputes in Germany, France, Italy, to name a few. And there's no formalized codified system of mediation within the insolvency process in the EU, but it's gradually adopted mediation through jurisprudence and case law. And the EU's primary objective is to rescue the corporate debtor. It's a debtor in possession model, of course. And the insolvency plan in Germany, for example, allows for debtors and creditors to arrive at a settlement via facilitated negotiation. Right. Moving on to France, two procedures allow for the mediation of insolvency disputes: the ad hoc mandate and conciliation. However, the Italian model is perhaps the most detailed and inclusive towards mediation in insolvency. Now, three procedures exist in Italy to resolve insolvency disputes through mediation. Firstly is a recovery plan. And the informal proceeds are commenced by the debtor. The debtor submits a plan, which is sort of certified by a qualified professional. And then for debt recovery, and then of course balancing stakeholders, they are able to negotiate that with the creditors. And if the creditors accept, then that is exactly what happens, right? It's an entirely confidential process, but it is a process that is underway in Italy right now. Now, only the assent of creditors is required on whom it is binding, and the courts are not required in any form. Now, a hybrid model, of course, is also there in Italy, where mediation takes place, binding on creditors, of course, participating in the negotiation, and the court takes a merely supervisory role to ensure that everything is legal and due process is complied with. Lastly, there's a preventive arrangement with creditors that is certified by a professional, which can be arrived at, which is largely a court-monitored process. So the negotiation itself will be facilitated by a judge as well as a judicial commissioner. So we see a lot of variation in even the basic interpretation of mediation as a process, which gives us a lot of flexibility with which to operate. Now, having a look at the United States, which is perhaps the best way of assessing how mediation has absolutely been a success, which is the US method of insolvency, which is the Chapter 11 insolvency, is a debtor in possession model. It greatly depends on the process of mediation to resolve insolvency disputes. So since 1986, the Bankruptcy Court of Southern District of California has established a mediation program. It's seen cases where we've had thousands and thousands of creditors being resolved, having their disputes resolved through mediation in a very, very satisfactory and an expedited process. So these issues have clearly been able to be worked through at a lightning process compared to what would otherwise take years and years and years in court and perhaps not be beneficial to everyone involved. Now, through mediation, we've also seen the Lehman Brothers insolvency being handled, wherein we had multiple jurisdictions. There were very, very conflicting judgments in courts to the point where a proper solution was unable to be arrived at. Through mediation, I think around 77 of the disputes were mediated, which is almost all of them, and they reached a satisfactory conclusion in record time. Now, this is unimaginable in a courtroom in such a fractional amount of time. Coming to India, just to briefly go over a few of the roadblocks that I see. Now, we've seen in numerous cases that insolvency disputes are disputes in rem. This represents perhaps the most significant roadblock to mediation being accepted as an insolvency resolution mechanism, because a dispute in rem cannot be taken to ADR in any way or form. And that is a roadblock that, frankly, to bypass will be a perhaps difficult endeavor, but an endeavor that I think is certainly worth looking at and deliberating upon. Now, we have Vidyadrolya, Pioneer Infrastructure, Haryana Telecom that tell us that this cannot be done. And then, of course, we have the mediation bill, however, is a hope for a consolidated legislation in India on mediation. And of course, this is very, very seminal and important. But at the same time, Schedule 2 of the mediation bill shows a lot of, a lot of focus on certain disputes being barred, like family, industrial mechanisms. And that, at this stage, appears to be something that may be a bit of a challenge in terms of the scope of how we view mediation, because if disputes are constrained from being mediated, such as family disputes, then perhaps our conception of it is not as accurate or quite where we want it to be just yet. Right. So, and of course, so essentially, yes. Now, the proposal, just to quickly wrap up, because I think my time is running out, it's proposed that multi-party mediation be included within Section 12A of the IBC and Regulation 30A of the BBI, which deal with withdrawal of application. Now, while I think this is the first step, and not necessarily a complete discussion of how I think step-by-step mediation should be incorporated, I definitely think it's something worth looking into, because it's an ideal procedural time to mandate negotiation or mediation as parties are willing to reach a settlement to withdraw application. Why we have to tiptoe around this is because India is a creditor-driven system. It is not a debtor-in-possession model. That means that the two systems, whether we compare the US or the EU to India, are not analogous to each other. So we can't draw that comparison so easily. There has to be much more deliberation that goes into it. So, of course, they're in the space where we want to withdraw the application and a settlement has to be reached. I think I would argue that that's the prime time for parties to actually to work on emboldening themselves to reaching a settlement. Secondly, the balance of power between the COC and the promoters or directors would make it ideal for parties to enter into mediation, because at this stage, of course, while the process is creditor driven as it is with the COC having to approve the plan, it's also a time when the parties have to still reach a settlement that largely works for them. For a solution to be actually addressed to the COC, it of course has to be something that is feasible and that can be done. And therefore, I think that this would perhaps mandate a fair amount of thought into being a good point in which mediation could be inserted. Recent judgments show possibility of courts to overrule the wisdom of the COC as supreme, such as in Shiva Industries. Of course, while the COC is very much still held supreme and their wisdom is of course held above all. That being said, judgments such as Shiva Industries show us that the courts can actually look beyond that and perhaps think a little outside the box. And it's this outside the box thinking that we really want to use to inculcate mediation within the Indian regime. And the ability of the application to be withdrawn both before and after constitution of the COC lends flexibility to bring mediating parties to a settlement, especially the COC has not yet been formed, because right now, of course, the committee of creditors does not exist. There's less formalization in that sense, and so it might be an opportune time to introduce mediation in that context. Just to quickly conclude, this paper has strongly argued for the inclusion of mediation within the Indian insolvency framework. Of course, while this is outside the scope of the paper and I don't have enough time to delve into this, it also gives us a lot of opportunity for reflection on whether the creditor-controlled model is truly where we want to be in terms of envisioning the Indian insolvency regime, right? And of course, mediation's relevance has grown by leaps and bounds because geographical borders are blurring. And as I've pointed out through numerous examples and legislations, the international arena has already taken cognizance of this. And I believe that it's time that we do as well. This produces several opportunities for critique and reform of the current code. And of course, our insolvency process might have an opportunity to grow even further than it already has. Thank you. I think that's it.
Yeah, basically you mentioned that confidentiality is an essential feature of this mediation.
Yeah.
But how does that work in insolvency? First of all, it goes to educating authority and then it starts. So once it's reaches the NCLT, it cannot remain confidential as such. And second point is, how does it help if I have defaulted on 10 creditors and I am having mediation with 10 creditors? Okay. It has to be a combined or a non-confidential process.
Right. I think, yeah, I mean, with respect to confidentiality, again, I think largely the process in itself is confidential. So I think what we're dealing with largely is the deliberations between the parties being confidential. Because even with the Lehman Brothers and other such examples, of course, it's a confidential process. We don't know what transpires on the table, but of course, we know that it happened. So I think that would be how I would approach the whole confidentiality aspect of it. Whereas with respect to the second part, we've actually seen that with multiple creditors abroad, there have been areas where we've been able to reach very successful solutions. So I think if we were to actually, maybe the IBBI and a lot of different governing bodies could understand, how we could include that and maybe perhaps give some, recommendations to that effect, I think for sure we could see a lot of progress made, even if it's multi-party mediation, even if it's, I mean, in the case of Thompson Greyhound Lines, we saw thousands of creditors very, very successfully reach mediated settlement. So I think that there should be scope there. Yeah.
So I think everyone's quite clear that mediation would be very useful to have in the insolvency process. I think what would be helpful in terms of your paper is when you're analyzing these other jurisdictions, how did they deal with multi-party mediation and whether how much of it was actually incorporated into the law? Because I am also wondering about that, because I think the point of mediation is that it should be quite a flexible process and it should probably be permitted at different stages of insolvency. Both, of course, pre-IBC, that's completely up to the parties, but also post-IBC at different admission at different stages. So I think it'll be interesting, to add quite a bit to your paper if you did a little bit of analysis on specific case studies in other jurisdictions and how much the mediation is actually incorporated into the law in terms of the process versus being more flexible about it and market driven.
I think I'll definitely look into that. I think to that effect also, when reading about the EU, for example, we notice it's not codified in law. and it's just a precedent, and perhaps it's almost like a legal tradition of sorts that's passed down, and hence that's how the framework has developed. I'll definitely look into it and I'll include it for sure. Thank you very much. Okay.
During the mediation, the law is that parties are not bound by what they say
in the mediation,
or what is recorded during the mediation.
Yeah.
So if supposingly I admit a debt of 20 lakhs there,
Yeah.
but I'm disputing the other debt, then the other party can't, and if the mediation is unsuccessful, the other party can't go to the court and say, look, 20 lakh was
Yeah.
admitted during the
Yeah.
mediation.
Yeah.
And therefore, I think to that extent, you read confidentiality from that point of view. Not that
Yeah.
confidential means the other can't see, but the fact is that those proceedings cannot be used against you in the event the
Right.
mediation doesn't work out.
Right.
And there is a judgment of NCLET also recently on
Okay,
that. I think you should focus on that aspect as well,
Hmm.
because that would be the tricky part. Because we are
Right.
if you are incorporating it as a part or a process which is sanctioned by law,
Yeah.
then can you wriggle out of it by saying, look, I
Right.
said this during the proceedings,
Hmm.
but I'm backing out by that.
Yeah.
So and that's the point also which was being made here
Yeah,
by
yeah.
your panel.
Right. I'll definitely look into that.
Because mediation, we understand that it is to resolve a dispute
Yeah.
between two parties or maybe 3 or 4 parties.
Yeah.
So here the already default has happened. So in you propose mediation at the stage of resolution of the
Yeah.
resolution
Yeah.
process.
Yes. Yes.
At that stage.
Yeah.
So
Good one.
at that stage, do you see any involvement of resolution applicant, because he is not there in the picture?
Yeah.
So only the stakeholders other than resolution
Yeah.
applicant.
The creditor.
So how much time you see that it will take that mediation? And they will do some like जैसे बोलते हैं आपस में बांटने वाला.
Yeah, yeah.
That is what you are proposing?
No, I don't think.
मतलब जो है बांटने. This is what we are proposing by
I
way
think-
of
yeah.
mediation.
I think no. I think that would be a very, very rational concern in a negotiation. In a mediation, I think I would want to believe that if it's facilitated, it would be a more organized process in that sense. And in terms of stakeholders, I actually think at that point it would mainly be between the several creditors and the debtors. It would not probably go beyond that in that case to introduce more stakeholders. But yeah, definitely.
Will it not be a good idea to have a pre-mediation requirement before filing Section 7 application?
I
So
think
at least
definitely would.
there should not be a need for this filing this Section 7.
For sure.
A
Yeah.
mandatory
yeah.
condition. Right?
Yeah. Mediation. Right, right. Yeah. 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 Mediation. Mm-hmm. Yeah, yeah. Yeah, yeah. Yeah. Yeah, I think that would actually be the best alternative if we had to have an option, but yeah. Yeah, yeah. True.
Basically, what I see from presentation is there are two levels of mediation here.
Yeah.
One is pre-admission, one
Yeah,
is
and one is
post-admission.
post, yeah.
So pre-admission, of course, will happen between the applicant,
Yeah.
resolution applicant,
Yeah.
and the party, like
Yeah, it could
default
be, yeah,
party.
totally, yes.
Okay, that can be kept confidential.
Right.
And as Mr. Batra said,
Post
the,
printer, yeah.
the settlement here, should it be filed before the court or not? That is a moot question of law.
Yeah, yeah.
Because
yeah.
see, in a default situation, there is
Hmm.
always a continuous tension
Yeah.
between the creditor and a debtor.
Right.
What the creditor wants is an immediate payment,
Right.
like
right.
bank.
Yeah,
Okay.
yeah, yeah.
And what debtor wants? He wants a delay in the payment.
Right,
That is the
right.
continuous tension.
Yeah,
So the mediation or a settlement happens when these two comes together. So
right.
he gives a timeline. Okay, I'll pay you, say not today, maybe in 12 months. Some
Yeah.
agreement is reached.
Yeah.
Unless you give this agreement, file it in the court.
Right.
Except as per a mediation, we have reached this conclusion.
Right.
So now this is filed, I withdraw my application. Because tomorrow this gentleman backs out of this agreement, then I
Yeah.
have a right
You
to
have a right to
restart my
enforce it. Yeah.
initiation
Yeah.
application.
Yeah.
That should be there, that will add value here.
Yeah.
And as regard the post admission, so now this comes to COC under section 12.
Yeah.
COC has to decide. So automatically there is a kind of process where there, in the CD or
Yeah.
the promoter sits with the COC
Right.
because he has to gather 90% of the votes
Votes
here.
of the COC.
So unless 90% agree, that cannot
You
happen.
can't have-
So that's already given in the law. So we cannot add anything to that.
Right.
Thank you.
I'll definitely read into that. Thank you.
We have the last presentation for this session. The topic is From Lubrisol to Qimonda, Treatment of IP Licenses in American, Indian and Cross-Border Insolvency Regimes. The presenters would be Mr. Aditya Gupta and Professor M.P. Ram Mohan.
Okay, so good afternoon, everybody. Greetings to everybody on the panel, and a very good afternoon to everybody in the audience. Thank you for coalescing in this very hot afternoon and making our paper discussions worthwhile. Professor Mohan is busy with the conference, so I'll be taking the lead on the paper. The paper that we're presenting today studies the relevance and treatment of intellectual property licenses within a cross-border insolvency context. Now, the canonical text and the so-called template for adoption of cross-border insolvency regulations has come out to be the UNCITRAL model law on cross-border insolvency. And through Article 8, this particular text clearly states that in interpreting this law, regard is to be had to its international origin and the need to promote uniformity across jurisdictions. Now, this particular paper attempts to study and import guidelines which have developed in different jurisdictions and then import it within the Indian insolvency context. This should go ahead, yes. Okay, so coming to the Indian law on the subject, while the IBC has been heralded as one of the most progressive financial reforms this country has ever seen, it does not regulate cross-border insolvency. The Bankruptcy Law Reforms Committee, which drafted the code, explicitly noted that our recommendations are limited to bankruptcy being a purely domestic issue. So, when this recommendation was put forth, the Joint Parliamentary Committee, they disagreed. And hence 234 and 235 found their way into the code. 234 allows the central government to get into bilateral agreements, and 235 allows an insolvency professional to approach the NCLT and seek assistance in case assets and evidence are located outside the country, in a foreign jurisdiction, so to say. Now, the reliance on bilateral agreements to regulate cross-border insolvency is objectively problematic. Primarily, negotiating these agreements is a very time-consuming process. Every country will want its set of provisions, and we will end up fragmenting the cross-border insolvency regime, so to say. And even if it's not, like, since 2016, ever since we brought the code into existence, no bilateral agreements have been entered into. And while this is more of a theoretical argument, but even the practical side of it, we've seen in the Jet Airways case, the NCLT went ahead and said that the Dutch proceedings are a nullity in the eyes of the law. Although the NCLAT then entered into cross-border insolvency protocol. But still, these protocols and all of this judicial guidance without statutory direction is a very problematic precedent to deal with. Now, IP licenses intellectual property licenses pose a very unique problem in cases of domestic and cross-border insolvency, singularly because of the nature of intellectual property. The best example of this intersection is the American bankruptcy regime. Mr. Datta took us through section 365, but I'm coming in from a different angle, so please bear with me. Now, section 365 is the primary node of intersection when we talk about treatment of intellectual property licenses and bankruptcy regimes. The provision allows a bankruptcy debtor to reject contracts and agreements which posit a net obligation to the estate. Now, what does rejection mean? It does not assume a contract law analog. It has not been defined in the American Bankruptcy Code. The American bankruptcy courts have been dealing with it for a very long time. Specifically in the context of intellectual property licenses, in 1985, an American appellate court confused the term rejection with rescission and eventually ended up telling everybody that as soon as your IP license is rejected, your right to use the licensed intellectual property is extinguished there and then. So they've created a very problematic interpretation of rejection. So much so that in 1988, the American Congress had to step in. They brought in IPBPA, the Intellectual Property Bankruptcy Protection Act, and said that we will denude this judgment of its precedential authority. They introduced Section 365N, and Section 365N provides the licensees with a veto option, wherein he can say, no, I'm going to retain my rights. So that's how the IPBPA came into picture. Go ahead. So let's come back to cross-border insolvency. How has it been incorporated within the American Bankruptcy Code? So they adopted Chapter 15 in 2005. The important provisions that I'm going to discuss today are 1506, 1515, 1521, and 1522. 1506, public policy exception. If anything is contrary to your public policy, don't pass that order in favor. 1515, a foreign insolvency professional can come to an American Bankruptcy Court, ask for relief. 1521 is discretionary relief. These are reliefs that can be granted on discretion of the American Bankruptcy Court. And 1522 is kind of a balancing approach wherein if the interests of your creditors are being hampered, don't grant the relief. As simple as that. Right? So this is the, okay. Yeah. So this case is the primary reason we started this research. There are a lot of judgments here. The only two that we're concerned with today are the November judgment and the November 2009 judgment and the September 2013 judgment. Now what happened here was, Qimonda is a semiconductor manufacturer, and this industry works in a patent thicket. There are millions of patents here, all of which are cross-licensed, and as soon as nobody knows whose patents are they infringing. So most of the patents are cross-licensed. Qimonda files for bankruptcy in Germany, comes to the American Bankruptcy Court, says that recognize our proceedings, and says that let us administer the 4,000 American patents that have been registered. The court says that's not how it's going to work. The German law does not provide a protection as concomitant to 365N. So you subject your law to 365N, only then will we give you the administration rights. So this was kind of the primary issue before the court. Okay, we have to go back. Yeah. So the primary, why this judgment assumes important in a cross-border insolvency context is because they interpreted Article 21, 22 and Article 6. How they interpreted 21 was, 21 inherently calls for a balancing test. Obviously, the interests of the creditors and debtors are going to be antithetical. Keep them that way. That's what the court said. You will have to balance these interests, then come to a decision. 1506, this was a bankruptcy court interpretation. They said that IPBPA constitutes fundamental United States public policy. Their fundamental policy of quote unquote promoting technological innovation, whatever that's supposed to be. So both of these decisions tell us one thing, that as far as domestic insolvency courts are concerned, they will interpret these provisions in line with their doctrinal interpretations, expectations. And if that happens, we are fragmenting our cross-border insolvency regime. The point of moving towards modified universalism is kind of defeated. Right. Now, in 2018, our Insolvency Law Committee has given us a very beautiful draft wherein they've incorporated the model law, how their interpretation of it, how it should work in our country. Now, we suggest that the interpretation of this law, as has been applied in other jurisdictions, will affect our interpretation as well. Now, while this may be a hypothesis, but even the Insolvency Law Committee has cited the Qimonda dispute twice, both the bankruptcy court opinion and the Court of Appeals decision, in interpreting the public policy exception. Why have they not cited it in relevance of 21 and 22? We are not quite sure of that. Moving ahead. So this is what we are trying to study throughout the research. What happens when American Bankruptcy Court interacted with German insolvency law? We know what happened in Qimonda. What happens if American insolvency law interacts with our IBC in the context of intellectual property licenses? Now, we went through the code and the regulation attested with it. And we have divided this into two, liquidation and CIRP. Starting off with CIRP, avoidance transactions, as was also discussed in the panel, this is an area which does not have a lot of judicial interpretation or academic commentary, but still, there can be situations where avoidance transactions might intercept IP licenses, but that's not what they're for. Avoidance transactions try to intercept fraudulent and wrongful trading. So some licenses may be captured in that realm, but largely that's not going to be the issue, because these provisions are not catered to recalibrate business decisions. Apart from avoidance powers, there are residuary powers. Now, this is where I disagree with Mr. Datta, who's again not here. But Section 22B read with 23.2 allows an RP or an IRP, interim resolution professional or a resolution professional, to amend or modify contracts. Now, the NCLT Hyderabad and NCLT Mumbai has interpreted these provisions, and they've said that you cannot exercise these unilaterally. You have to consult with the creditor, only then can you exercise these. So if that is the interpretation, during CIRP, we can't interfere with pre-petition contracts. Good enough. We move on to liquidation. Liquidation has disclaimer. Disclaimer allows you to reject onerous property, reject performance of onerous property. Onerous property's definition includes unprofitable contracts. Good. But again, lack of any interpretive guidance, no case laws, no substantive case laws dealing with this. So we had to move to the UK jurisdiction from where we've adopted the idea of disclaimer, the provision of disclaimer. So in the case of Hindcastle versus Barbara, the court has explicitly said that disclaimers should affect the rights of third parties as little as possible. And the only point of including them within the statute is to freed the corporate debtor from their set of liabilities. This is the structure of IBC in reference to interfering with pre-petition contracts. Now, while we have conducted this analysis, even we admit that as far as our conclusions are concerned, they're relatively fragile, because all of our conclusions they're largely speculation that this is probably how they're interpreted. If that is the case, like for example, what will happen if a IP licensing agreement includes an exclusivity covenant? If you have an exclusivity covenant in your IP license, that will be an imposing obligation even after disclaimer. So will that exclusivity requirement be extinguished by a disclaimer? We don't know. So we're suggesting that before we interact with a different insolvency regime and fall into a kimonda of our own, form an administrative inquiry, study this issue, and at the same time, like what Mr. Bisht presented yesterday in seminar hall 2, I suppose, even he was saying that when it comes to pre-petition agreements, we have to look into whether or not it is necessary that we regulate them. So while you're doing this inquiry, maybe also look into that. Also, even the UNCITRAL has time and again said that we want to study this issue. In July 2013, they came out with a report. In July 2015, they came out with a report again. But they've never put the proverbial pen to paper. So we say that with these three issues, with these three conclusions, you can probably be prepared for a dispute like this. Now, I've wrapped up the presentation early because I know we're over time. So if I have any questions, please.
Yeah, so no, thank you. And I think this is very interesting because I think there's been very little work done in this area generally, right? So just one small point before I ask a larger question. So when you're talking about the section 22, you're right that the RP cannot unilaterally amend the pre-petition contracts, but they can with the consent of the COC.
Ma'am, the NCLT Mumbai decision 2018, DGM versus Geotechnics, I will mail it to you, obviously. In there, the Mumbai court has said, even with the consent of COC, you cannot unilaterally do this. You have to bring in the creditor.
The credit, you mean the other opposite parties?
Yeah, the opposite party.
Okay.
Because if that starts to happen,
because you can't, I mean, otherwise you can run. So, I mean, I think couple of things. One is, first of all, I guess there's not much clarity on dealing with pre-petition contracts under the IBC generally, right? Even in the domestic context, even before going to the cross-border context, I think IP licenses itself, presents its own set of issues. So given that, I would think you'd first have to look into those questions. Maybe the way it's dealt with elsewhere can inform that.
So, ma'am, we
But,
studied
yeah.
this. We
Yeah.
have published on this. We studied US and UK.
Yeah.
But the problem continues. We are following the UK model. And when it comes to disclaimer, there is no litigation there.
Mhm.
How do we interpret it? And even if we don't want to engage with, or even if we don't want to interfere with pre-petition contracts, there is a lot of literature, there's a lot of international guidance on why is it necessary. So whatever academicians suggest, there needs to be some kind of administrative inquiry into this. There needs to be some kind of legislative decision making of sorts.
I think there should be, and I'm sure there have been. I mean, there are IP licenses, so I think there should have been. This issue should have, or
That's
maybe it
something-
hasn't
There's
come
something
up
very
in that
peculiar about
sense.
IP in this country. We focus on temporary injunctions and we
No,
do not take
on-
things
yeah.
to court.
Fair enough. No. Agreed. But I think so. I think before even going to the, I mean, at least that's how I felt, because the public policy was one issue, but that I think is a slightly separate issue from how to deal with IP licenses generally. Of course, in a cross-border dispute, it'll get even more complicated. So, yeah, no, but I mean,
We're just using
interesting
this
topic,
dispute to
but
like say ki there is a problem here.
Yeah.
And have we identified it? If
No,
we
I
have, then
think-
look into it. If we haven't, tell us that we're wrong.
No, I think there is definitely an issue here. I think maybe the way to approach it is to first dealing with it in a purely domestic situation before going to the cross-border angle, though of course that's also eventually will be relevant, hopefully, when the cross-border law comes in.
Now
But
we will take this into
Covered everything.
Mhm.
We have to look at this is a serious policy issue, and we have to consider it at least for the domestic point of view. First,
It's a connected problem, sir. As soon as we give some direction in the domestic issue, we will avoid Kimonda in India. Because if there's clarity on how we're treating our licenses, the courts will not have to subject our proceedings to their law.
no, that's exactly the point. If there's clarity here, then if there's any, I mean, we can say that, well, I mean, depending on which law applies, we'll have to deal. But if there is no clarity in the domestic context, I think that's what
And bankruptcy in itself is a meta law, right? It affects everything from here to there.
we take some homework for us.
Sorry?
The asset of the company?
It may be.
Maybe, or actually is an asset of the company.
Sorry?
IP licenses, where the company owns these licenses, it is an asset of the company?
It can be an asset, it can be a liability. Imagine if you are the licensor and you are licensing your intellectual property, there might come a situation where the contract is becoming very onerous for you. You're not gaining any money out of it, but the money is being drained from your estate. At that point, it should become a liability.
And if it is a liability, it is a contingent liability during the CRP period?
I'm not particularly sure of
And
that.
if it is an asset, I can sell it with a bundle of the asset because it has a potential to sell it. And if it is a liability, it's a contingent liability, or it will be treated as all the contingent liability, the way other contingent liabilities are being treated. So where is the problem I am actually looking at?
No, so we're dealing with liquidation and CIRP.
Liquidation, we have a right that onerous property, if there is, you can terminate the
No,
contract.
but what does that termination mean? Like, will the
If it is
license...
no, every contract cannot be terminated during the liquidation. It has to be onerous. That is very difficult for the company that it cannot be continued. Right? Just because say you have a power to terminate the contract during the liquidation, you cannot go it. Even as you said that during the CRP period, educating authority asked that. Talk with the creditors because you have to be justified and reasonable why you are doing this.
Okay.
I am looking at the problem. I'm not able to see where is the problem actually.
So, as soon as we come here, 1521, Article 2122, The court, like any foreign court, when they're giving us their assets, when they're allowing us to administer our proceedings to administer their assets, they will have to see how we are going to deal with those assets. Can we or can we not reject? If we can reject, what is the meaning of that rejection? And what we're saying is we have no idea what the meaning of rejection
This is a cross-border issue right now.
Precisely.
Is it an IP issue or is it a cross-border
I
issue?
think the point here is that it's both. I mean, it eventually will come up in a cross-border issue specifically. But before we even go into the cross-border issue, we'll have to figure out how it's dealt with domestically. Because that will be relevant to, in a cross-border case, how the court will actually think of dealing with it. How does India look at these kind of contracts, right? I think that's what you're saying.
Yeah, I have got one question. In one of your slides, you are mentioning about India IBC adopting cross-border, in which you had mentioned that it is on a reciprocatory basis.
Yes.
And as you also mentioned, you have studied US and UK and all, where they don't work on reciprocatory basis.
Yeah.
How far this will be successful?
So this is beyond the scope of my study. I have not. I know that they are applying it on a reciprocal basis. Equipped to make it here. That's all. Thank you.
Thank you, everyone. Now we can break for tea and coffee, which would be served outside. Thank you, everyone, for all your pertinent questions and for listening to the paper presentations carefully. Thank you to the panelists as well. Thanks a lot. Welcome to the final session for today's conference. The panelists for today's session are Shri Amit Pradhan. He's the Executive Director of IBBI. And we have Dr. Kokila Jairam. She's DGM at IBBI. Just to set the rules of how things would be happening, we have 3 paper presentations for today. Each paper would be presented for 17 minutes, following which the judges can ask questions for 5 minutes. The first set of presenters that we have today would be presenting a paper titled A Recursive PLS-SEM Approach to Determine Causal Factors of Corporate Bankruptcy in India. It would be presented by Abhishek Haldar, Pratik Nahar, and Shashank Prakash.
Good afternoon to one and all present here. So our study is a recursive PLS-SEM approach to determine what are the causal factors behind the corporate bankruptcy trend in India. For the last 5 years, we have seen the IBC has been implemented. And I first explain what has been the motivation and the context behind this study. So we started from corporate distress. So we have a study based in 2015 from the Vienna University and the Swiss Finance Institute, which talks about the extent of corporate distress being defined by 3 factors, which are the macroprudential regulation on bank lending, the microprudential policies of credit quality, and the debtor-specific characteristics. So these 3 are very important from a point of view of the financial stability, and as we talk in finance about the systematic risk and the idiosyncratic risk of the firm as well. And there is a IMF 2010 paper. It is a staff position note which tells that insolvency related legal processes are necessary for the entire bankruptcy regulation in India, but it is not the only thing, and it is not sufficient. The legal processes are not sufficient. So we moved on to investigate about the determinants of corporate bankruptcy, and when you type the word of corporate bankruptcy in the Scopus database, around 1500 articles appear, and we looked into, we did a bibliometric analysis of those as well, and we found based on the citation scores, normalized citation scores, we found which are those influential sources, the author affiliated countries, and the articles which talk about corporate bankruptcy. Also, there is this financial stability report of 2021, which tells that the longer time the bad loans spend on the balance sheet of a company is inversely related to the proportion that is recovered by the banks. Also, there is a study by Devi Prasad Rath and Sujesh Kumar. It is an RBI paper. It tells about the leverage investment nonlinear relationship. So it basically investigates what is the investment dynamics that is evolving in India, and it gains new insights into this. So it finds that financial variables play a critical role for the investment dynamics, in addition to 2 variables. One is the business expectations, and another is the EPU, which is the economic policy uncertainty. Now, coming to the economic policy uncertainty, this is an index which was designed by Baker et al. In 2016, and they came up with an index. So on the basis of that India's score was 76, around 76 in 2016, and at present, as of March 2022, it is 125. So generally, one would think that the economic scenario is more certain now with respect to what it was in 2016. But if you see the gross NPA to gross advances data from RBI, the NPAs have increased a lot. So this ratio has increased from 2.3 to 7.3 in the last decade. So this was basically what motivated us to study what are the causal factors. We were curious to know the factors behind the corporate bankruptcy trend. So we formulated our research objectives accordingly. So we had gone through various literature, and we found literature which classifies bankruptcy regimes around the world on the basis of pro-liquidation and pro-reorganization regimes. There were also studies which focus on strength of the banks, strength of the economy, and explain it through a game theoretic models. Also, there were studies on creditor rights. For example, the La Porta 1997-1998, which was extended by Jankov 2007-2008. So they explain what is the role of creditor rights in the debt market development, and as well as the defining the bankruptcy in a country. And so they had come up with an index as well. So we also looked into that. And as I said about the bibliometric analysis, so these are the top 5 sources of information on corporate bankruptcy. And, and those are the 5 author-affiliated countries which are producing publications on corporate bankruptcy. So regarding data collection, our sampling technique was purposive sampling, in which we took data from IBBI website. We collected a sample of initially 2,265 firms, which were categorized into 4 components. The first one was CIRP, which was yielding into resolution plans. The second was CIRP ending with liquidation, and the other 2 were liquidation and voluntary liquidation, which ended with dissolution. So apart from the firms which were recovered, we defined bankruptcy on the basis of these 3, and our total sample size was 1,844 firms, and the study period was 2017 to 2021, and these are the various data sources which are credible sources of information. So regarding the variables which were used, so we have the dependent variable construct as the bankruptcy trend, which was defined by the indicator variables of the 3 which I mentioned. Then there were the independent variable constructs, which were captured by various variables on which data were available. Also from the debt market dynamic point of view, we tried to capture the public debt as well as the private debt. So the public debt, issues of corporate debt, as well as the corporate bonds and NCDs data was also captured from the SBI database. Next, about the methodology, my colleague Shashank will explain.
Thank you, Abhishek. So when we have identified our variables, we ran forward to explore what are the factors that are contributing to the model. And running exploratory factor analysis using PCA, that is principal component analysis method, we came that 4 variables were contributing mainly to the model. As you can see on the diagram, the scree plot, and also confirmed by the total variance explained. The 4 components were held more contributing to the model, and the first component was solely explaining 49% of the variance in the model, and in taking all the 4 components collectively, more than 85% of the variance was explained. In the latter part, looking at the rotated component matrix table, in the first component, gross advances, CPI, GST collection, external sector debt, forex reserve, private placement of corporate bond, and outstanding corporate bonds were the variables that were included in the first component. In the second component, GDP growth, GST collection, net FDI. In the third component, credit to deposit ratio, trading amount of corporate bonds. And in the fourth component, GST collection and public issue of corporate debt was included. As you can see, it was very difficult to club these variables into one component and provide a particular justifying nomenclature to the component. We went a step ahead to perform the PLS SEM. We went perform PLS SEM to know what are the really contributing factor to the model. Because in the PCA we were not able to club our variables into one construct. We use PLS-SEM. The question arises why we use PLS-SEM. So as per here 2015 and 2019, PLS-SEM is a good technique when we have secondary data or when we have financial ratios in the model. So we went to perform PLS-SEM, and why we are calling is recursive. It is having because our path analysis is showing a one-directional or unidirectional causality. So the unidirectional causality of path analysis is termed as recursive, as reported by Latan and Ramli 2014. Therefore, we are calling it a recursive PLS-based model. So we ran the PLS-based model in three different hierarchy. Our initial model was having all the 20 independent variables measured in three different constructs, and one dependent variable measured by three different variables. First order model showed that the debt market dynamics is not contributing significantly to the model, therefore we have to remove it. In the second order model, again we found that there is still some covariances which are less than 0.5, so again we have to remove it. And finally in the third model, the model was, as you can see on the screen, this model came as our final model. So condition of banking sector was solely explained by credit to deposit ratio. Economic condition was explained by GST collection and external sector debt, and bankruptcy trend was explained by total admitted claims during CIRP, ending with the order of resolution. Now coming to the model fit indices of this model, we had adjusted R square of more than 52% and R square of more than 60%. SRMR value was less than 0.8. Citing Hugh and Butler 1999 and Bentler and Bonnet 1980. So when it is less than 0.08, it is a good fit, and NFI, that is non-fit indices, it should be again, it is like a correlation matrix. So as close it is 1, the better it is. Coming to the construct reliability and validity, which is measured by Cronbach alpha, composite reliability, and AVE. Cronbach alpha should be 0.7 or above, which is confirming in our model. Composite reliability should be again 0.7 and above, confirming in our model. And AVE should be 0.5 and above, confirming in our model. Coming to the discriminant validity, which is a measure of external consistency, it can be measured by two criteria. One is Fauner and Larker criterion, and other STMT. But STMT we have reported here. We have reported Fauner and Larker in our paper, but STMT ratio is considered above and better than Fauner and Larker, as reported by Hensler and Sarstedt in 2015. So STMT ratio should be less than 0.8, and our model is confirming that also. So we have also reported AVE for issue of multicollinearity in our paper, but due to some constraint, we have not included it in our PPT. So the result will be again explained by Abhishek. Thank you.
So as we see from the slide that our study proves that the bankruptcy trend is significantly caused by three factors, which are the credit deposit ratio, the external debt, and the GST collection. So a higher credit deposit ratio means that the balance sheet is overstretched, and therefore there are certain capital adequacy issues in the bank. And also with regard to the external debt, our results support a previous study which was done by Schwartz and Martin, which also came up with the same result, that a higher level of external debt contributes to a higher bankruptcy risk. With respect to the tax avoidance, our study actually extends a study of Richardson of 2017, which tells that a higher level of financial distress is caused by the tax avoidance history. And our study proves that tax avoidance history also contributes to a higher bankruptcy that is defined. So coming to the implications, we explored the macroeconomic factors in terms of an uncertain economic environment. And as we know from the various discussions in this conference, that generally in the past 5 years of IBC implementation, value destruction has happened in a pro-liquidation firm because of the capital in control. However, there is a study of Aditya Kaushik of Niti Aayog, which proves, which says that In terms of the value of the assets, the rescued firms is the value is 4 times more than the value of the liquidated firms. Also, this has implications in terms of reducing the congestion in the bankruptcy courts, the NCLTs, and also it provides insights for regulations in future. Coming to the limitations of our study, so a more granular data would have revealed more insights into this. Also, the data unavailability with respect to certain variables made us exclude those variables from the study. Also, in terms of the future scope of the study, it can be studied with respect to exogenous shocks. For example, the pandemic which occurred, it was a once in a century phenomenon. So those are certain exogenous shocks which can be considered, and also with respect to the recent initiatives that are being taken by the present government in terms of the bad bank, also the same committee report on ARCs which has been submitted. So these are future areas to study. Coming to the conclusion, our study has found a unidirectional causal relationship between the bankruptcy trend and the 3 variables. So our study is unique in 3 ways. So first is this unidirectional causal relationship which has been established for bankruptcy trend, and also with respect to the temporal significance. So we stand at a 5-year period of implementation. So future researchers could look at how other insolvency regimes in the world, what was their position after 5 years of implementation. So this can be looked after by future researchers. Also, in terms of the regulation, our study could help to improve the regulatory reforms in the bankruptcy regimes in India in future. Thank you.
Any questions from the house?
Not 468. The sample was 1844 firms which have been liquidated. So it is directly from the IBBI website.
So, sir, this is a bibliometric analysis? Or?
Sorry?
This is
No. The literature review part was a bibliometric analysis, yeah.
And what software did you use?
Viewer, yeah.
For me, it's not exactly a question, but kind of clarification. 2016 onwards, that's your data period. You would see that Indian private banks had much higher credit deposit ratio than Indian public sector banks. So on an average, Indian public sector banks had around 56 to 60% credit deposit ratio, whereas Indian private banks had 75 to 80%. But your results suggest almost opposite. Private banks actually, bankruptcy trend is much lower than the public sector.
Yeah. So I would like to answer that. So you are talking about a period 2016. Okay. So because I came across a data of RBI regarding non-food credit. So in that, so while I was studying this, so the period before the financial crisis of 2008, that was a private corporate debt-driven growth story. There's a paper on it. And also, so the period after that has shown a subdued credit growth. So I was seeing at the data. So the RBI data of non-food credit suggests that the trend has been up and down. So so actually it went up, it dropped just after the crisis, and then again it went up around 2015 and 16, and from then it has been dropping till 2020. And further after 20, I didn't see, because after 20 there was an pandemic situation, so obviously abnormality will be there. So yeah, so that I wanted to say.
Okay, so I have few observations, the first thing is that what I feel is you have focused too much on the, techniques, statistical techniques, like you have used bibliometric analysis, EFA, PLSM. I think more time should have been given to model definition or preparing the conceptual model for this. You are using EFA, but I do not see any need for using EFA because you already have fixed variables which you have identified. EFA is used to identify the variables, but you have already identified it. And you only have to confirm whether your model confirms to these variables or not. And coming to your implications, like you said, it has some insights for regulators. So what are those insights? Can you elaborate on that, please?
Yeah. So in terms of following yesterday's discussion which we had during the inaugural address, so there are certain areas which they are looking at the IBBI. So one is that in fact, the chairperson himself said that it takes a lot of time for a case to come to under IBC. So that was one of the points which was mentioned. So invariably, the time to resolve, the time period with respect to the law will not be followed if it enters late, like it is admitted late. So because it gets admitted late, so that's why this study can help in improving that time period. So suppose there is an NPA situation in a bank, and further it worsens, and then the company goes into is admitted into the CIRP process. So our study could help in controlling it just at the NPA stage. So that the financial distress situation is not worsened enough so that the companies go into the CIRP process. So there is Banking Regulations Act, and there is a bankruptcy reform, that is the IBC, which is there. So the congruence between the two should be there. So suppose we have the PCA framework or a prompt corrective action. So how that would help to control the number of companies going into CIR?
Okay. Abhishek, I think on those slides you said tax avoidance.
Yes, sir.
Is a marker for distress or about to become distress.
So tax avoidance history, yeah. So the companies having higher level of financial distress the previous studies have shown that they have a tax avoidance history.
So did you do that study in the IBC itself?
No. My study was different, ownership structure.
Okay,
yeah.
that was a literature review you were referring to.
Yeah. So it is Richardson 2017.
And was it surprising that it could be leading to distress?
It was surprising because we didn't think initially about the tax aspect of it.
But I thought it was understandable.
Yeah.
That's fine. Thank
you. Any more questions?
Just one short question. Some of these variables, of course, you mentioned that you established causality, but being an outsider, for example, even tax avoidance, what causes what? I'm kind of puzzled, right? Does distress cause one to avoid tax, or tax avoidance leads to distress? Of course, I think you addressed it methodologically. I think
continued tax avoidance could lead to financial distress.
Because theoretically, I can justify the other way around, right? I can see that someone going through distress will go and avoid tax, right?
Yeah, I said higher level of financial distress. Okay. So, yeah.
Hi, I have just one small question. In your research implications, you have written value destruction in pro-liquidation regime. How have you arrived at that implication?
So my previous study is on value creation. It has been published. So it is on value creation with respect to M&A. So there is evidence in which companies go for acquisitions to reduce the bankruptcy risk. Also, there are literature on companies diversify their firms to reduce the bankruptcy risk. So when a company goes into liquidation, definitely the company is dissolved and its assets are sold. So, so the value of the company in terms of the valuation, I feel like in the liquidation, the value is getting diluted, right? So in case the company is resolved, like the rescued, so that time the company is a going concern. So I also mentioned during the PPT in terms of the value of the asset, there is a Niti Aayog study which tells that the rescued firms contribute to 4 times the value of the liquidation.
Sir, ma'am, actually I have one point. Sir, as you said that in 2008 and 9, like as economic crisis took place at that time, so NPA's trend was not there. Actually, that was in growth, but after that, that was lead to growth. And in 2015-16, as you mentioned, that it was like slow down. But I saw on the reports and this trend and progress of RBI, so that was increasing at that time. So
No,
I
I
just
said-
little doubt about that, whether what exactly.
Yeah, I said post the crisis, just for few years, there was subdued credit growth.
Thank you.
The second paper for today deals with the conundrum of claims in corporate insolvency resolution process. The presenters are Anshul Agarwal, Akash Chandra, and Raghavi R.
Good afternoon to everybody present here. The paper is written on the conundrum of claims under the CIRP. We believe that the concept of claims under the code warrants a deeper understanding so that an effective CIRP may be ensured. Claims are central to all insolvency jurisdictions. They give participatory right to creditors in insolvency, and ensuring a due process for claims for such stakeholders is very essential. The understanding of claims is also very important because on the successful approval of a resolution plan under the code, the impact on claims is such that they stand extinguished. Therefore, it becomes imperative to know what a claim encompasses and how they need to be treated under the code. Additionally, the understanding of claims also becomes relevant for the IRP under section 21 of the code, where he would be determining the financial position of the corporate debtor. There has been divergent and varied views by various courts with respect to the conundrum of claims. We, as authors, we seek to find a solution in this conundrum that would correspond to the scheme of the code. So that's what we seek to present today. Therefore, in this background, we seek to present a legal perspective on what claims are and how they may be treated under the code. Various tests have been used in varied jurisdictions to determine the trigger point of insolvency. Some of these include balance sheet test, cash flow test, among others. In India also, earlier we had the test or the concept of inability to pay debts. However, currently, the legislative intent has shifted to the default test, which is more of an objective test. Default under the code has been defined as the non-payment of debt, which has become due and payable. Debt is also defined under the code to mean a liability or an obligation in respect of a claim, which is due. A creditor is any person to whom a debt is owed. Existence of default and debt leads to a trigger of CIRP under the code. There might be a number of defaults that the corporate debtor would have committed during his business, but it so happens that one of them leads to the triggering of CIRP under the code. On the other hand, claims are of a wider connotation and they are wider in ambit. Claims become relevant once a CIRP is triggered. All claimants need not be creditors under the code. Claims are denoted by a right to payment, and it does not necessarily require any other factor such as an obligation or a debt being due or payable or otherwise. The only requirement is that there should be a right to payment. Therefore, a CIRP stands on the fundamental concepts of debt, default, and claims. We have attempted to draw an inference on how debt, default, and claims are interconnected. So what we have come across during the scope of our research is that in practice, The legal difference between a claim and a debt is becoming diluted, and claims are mostly understood in the context of liability or an obligation which is due. However, it may be seen that all debts are claimed in the first place, but not all claims would qualify as a debt within the definition of debt provided under the code. Therefore, the concept of debt, default, and claims are definitely interconnected in nature, with claims among them being the widest in amplitude, and it becomes imperative that this widest amplitude claims should be explored further. IBC has been inspired from the English law. The role of the RP can be roughly equated to that of an administrator in the UK. The IBC was drafted by BLRC, and they refer to various jurisdictions for making the best suitable legislation in the Indian context. We found that the definitions of debt and claim under the IBC are similar to the ones used in the US bankruptcy code. In earlier statutes, only certain or absolute debts were provable in bankruptcy, but over time, what we saw happened was the class of provable debts itself have enlarged in scope, and it lead to the two concepts, provable debts and non-provable debts. In the Indian context, the understanding of claims was present in the company law regime and the personal insolvency laws, wherein the claims are to be supported with proof. A broad category of debts as well as liabilities encompassed debts provable in insolvency, and the manner in which they may be proved was known as proof of debt. Although the concept of debts provable or non-provable in insolvency was not extended under the code, the inclusion of a wide definition of claim suggests that the legislative intent was to allow the submission and treatment of all kinds of liabilities and obligations that arise against the CD during the CARP. This idea was also highlighted in the BLRC report in 2015. Now we move on to interpreting the definition of claims under the code. The definition of claims is provided under section 3(6) of the code, and it covers two broad rights. A being the right to payment, B being right to remedy for breach of contract where such a breach gives rise to a right to payment. We understand that the claim only requires the right to payment to exist, and the use of the phrase whether or not in the definition implies that the right to payment may or may not be fixed or subject to a judgment, matured, unmatured, secured, unsecured, or otherwise. This further implies that it also covers debts such as contingent debts, future debts, and other claims from where a right to payment can emerge. The definition of claims also recognizes that claims can be determinable and indeterminable in nature. In the event of an indeterminable claim, the code also provides for the best estimate to be done of such claims. This definition of claim ensures that all the creditors are given due consideration during the CARP, and it helps the RP to ascertain the financial position of the CD. It is for the benefit of the resolution applicant that this is to be ensured, and it also lastly establishes the voting rights of the financial creditors. RP would be taking over the management and the control of the CD, and he is to be well informed about anyone and everyone who has a right to payment against the CD. Not all claimants may be creditors. However, that does not mean that such claimants need not submit their claims to RP and participate in the CARP. This is essential because the effect of the code is such that all claims and not just debts are extinguished on an approval of a resolution plan. Therefore, we believe that this scope of claims under the code should be focused upon, and it should be advocated better for the benefit of all the stakeholders. Now that an understanding of what claims are have been addressed, we seek to highlight the process as to how such claims may be considered and treated during a CARP. The IRP or the RP is required to receive and collate the claims under the code. The regulations also supplement this role of the IRP and RP by providing that they must verify each and every claim and determine such claims whose value may not be determinable due to them being contingent or unliquidated or otherwise. Such claims are valued, they are to be valued based on the basis of best estimate practice. Here, the role of the RP as a professional becomes very essential. In exercise of this professional wisdom, he has to examine the claims, compare it with the documents available on record, and determine the financial position of the corporate debtor. He acts as the facilitator of the corporate insolvency resolution process, and his role is definitely administrative in nature. This role has been clearly recognized under the code and the regulations, and it has also been upheld by the judiciary. This role becomes even more important as the approval of a resolution plan by the COC in exercise of their commercial wisdom extinguishes all claims. Therefore, the administrative role envisaged, it does not entail that the role of the RP is devoid of any application of mind at all. Rather, he is expected to act with utmost diligence and due care while dealing with claims. He is not expected to exercise adjudicatory function in respect of a claim. He is not to sit as a judge and determine the rights and liabilities of each claimant. It is for this reason that no appeal has been provided against such action of the RP under the code, because in the first place, there is no adjudicatory decision based on which there could be an appeal. Therefore, the office of the liquidator is differentiated from the office of an RP in this regard. We have observed in our research that there are many applications that are filed as challenges to the decision of the RP on a claim. The AAs are also adjudicating on such claims, and they are determining the rights and liabilities in respect of such claims. We believe that Section 60 Clause 5 provides fresh jurisdiction to the adjudicating authority to deal with claims, and the first consideration before the AA should be to see if the RP has acted with prudence and reasonable diligence while dealing with claims during a CARP. If the same is shown before the AA, AAs may restrain from determining the claims afresh. If a fresh consideration of all claims are permitted under the code, under Section 60 Clause 5, it would defeat the very objective of time-bound resolution under the code. On that note, we seek to throw light on how the treatment of claims during CARP in India may be differentiated from the processes under the UK and US jurisdictions, and there are certain learnings that we can take from such jurisdictions in the context of valuation of claims. As said earlier, the definition of claims under IBC is similar to that under the US bankruptcy law. However, the approach in treating claims have always been judicial and equitable in the US, as it is the courts in the US that facilitate the whole process and adjudicate the claims. Similar is in the case with UK, where the administrator is to give reasons for admission and rejection of claims which are applicable to the court. In the UK, the role of an administrator and liquidator are equated with respect to claims. However, the role of RP and liquidator is very different in India. This approach is not suited to India, as under IBC, the role of IRP and RP is clearly drawn, and the CARP is a time-bound process with minimal court intervention. This is why, though the broader framework of the insolvency law in India is comparable to that of the UK and the claims under US, the process of treatment and the adjudication of such claims is very different in India under IBC. For consideration of claims during liquidation, a corollary might be drawn to US or UK, but the same may not be suitable for a CARP. That being said, we found that there are certain rules and practices present in the UK and US regarding the treatment and valuation of certain types of claims. For example, we have trade discounts in UK, where all trade and other discounts would have been available to the debtor, but for the insolvency proceedings must be deducted from the claim. And there is also a practice in UK where contingent claims are valued based on genuine and fair assessment test, based on the chances of the liability occurring. The court sees if any other reasonable prudent liquidator would have come to the same conclusion. And there are certain other rules relating to the treatment of periodical claims, interest amounts, mutual set-off, and counterclaims. We believe that adoption of similar rules in India could enable the IRP and RP to effectively determine and value the claims, and it would also determine AS to check the action of the IRP and RP in treatment of such claims. Similar rules were also found in the Provincial Insolvency Act, which is not present under IBC. These rules and practice would guide the RP and facilitate him to deal with claims in a systematic and a uniform manner, and it would enable him to complete the claims with keeping in mind the time-bound obligation under CRP. With this, we conclude that the advocacy of the legal concept of claims is necessary for enabling all the stakeholders to file their claims, considering the aspect of extinguishment of claims. The administrative role of the RP and IRP during the CRP with respect to claims need to be understood, and the AA would sit to review such administrative action taken by the RP and IRP. This will ensure limited intervention of the AA in determination of claims during CRP stage. Finally, for indeterminable claims, we propose that, such as contingent claims, rules available in jurisdictions such as US and UK may be referred for adoption in context of India, which would act as a starting point for effective claim management. We conclude by saying that such reforms may be useful as CRP accelerates timelines of claims and they get extinguished on approval of resolution plan. Thank you.
Anshul, can you sum up in 2-3 lines your problem statement and what you are proposing?
So there
Because most of the time some provisions under the code was explained, and that resolution, once it is finalized by the authority adjudicating, so there is a freeze for the pending claims. So that is finally, even act has been amended. So I don't see any problem, which is
so
only thing advocacy is required for this purpose. People should file claims quickly, something like that. Is it your problem statement?
So there are 3 aspects that we have tried to cover in this paper. One is that of the understanding of the claims. So we are saying that what is happening is that the understanding of claims is getting confused with the understanding of the debt. The claim is much wider in nature, and because of the claims, the RP under section 21 is actually bound to determine the financial position of the CD and then constitute committee of creditors. So therefore, this understanding of claims is very important, and every right to payment, whether or not such right has been reduced to judgment, matured, unmatured, should be given, should be coming up before the RP when he calls for the claim. That is one aspect. There are no restrictions as such. How? No, the problem what we have faced, like through reading of the NCLT judgments and also the practice which has been happening. So we have found that only people who are having a debt claim against the CDs are filing their claim. But therefore, there is a limitation on the RP's part to determine the kind of a financial position of the CD. So therefore, we want to advocate this point that the understanding of the claim should be explored. Second aspect of the paper is that the role of the RP in determination of the claim, that has to be understood, and that has to be distinguished from the role of a liquidator in a liquidation proceeding. What is happening is that what we have seen, and also there are many judgment, different opinions coming from the NCLTs, and also the practices which are followed by the RP, that they are ending up being determining the rights and liabilities of the claimants. But that is not the purpose. The RP is supposed to collate the claims. He has to use his best diligence on the basis of the proof which has been given to him. And then only he will determine a particular value to that claim. That does not mean that he has to pass a reasoned order after hearing both the parties, and then that kind of an approach of that of a liquidator. So therefore, we say that office of RP is different from office of a liquidator, and that difference has to be appreciated. So these are the broad 2 points. And the third point, which is what practices from UK and US we can take on the assessment of a claim. We have seen that in US and UK, the broad approach on understanding of the claim is actually based by the equitable jurisdiction and also by the interpretation by the courts. So therefore, on our first 2 understanding, we cannot adopt that kind of an approach. Here we are saying that on the best estimation case, which is also provided under the code and the CIRP regulations, some principles or some rules on how the best estimation can be done can be adopted from that context, from US and UK context. And that is what she has highlighted, that these are the principles that we can adopt in Indian context so as to help the RPs to make a better determination of the claim.
Anshul, while you have spoken about the conundrum in respect of the verification of claim, I am talking from the point of view of the IP or the RP, those who have to do all this complete exercise, which is a very complex exercise, as well as the lengthy one also. Imagine the time given is 7 days after the submission of the claim. And the claims vary from, say, hundreds to thousands of the claims are there. One is this period of 7 days. Don't you feel that there is a requirement of some flexibility in this period? Second is, what about taking, because the whole responsibility is of the RP, even though he may be taking some support from the other staff and all in verification of the claim, which most of the RPs do that, but the ultimate responsibility remains with the RP himself, and he cannot pass it on to the others. And there have been in the past many cases where the RPs have been admonished on these things. So have you assessed or examined from this point of view that this period of 7 days for the verification of the claim, there should be some flexibility depending upon the magnitude of the case, magnitude of the claims? Thank you.
So I see there are two aspects of your question. So dealing with the first aspect, we have seen that, the CIRP regulations, they provide that in case the claims are not filed in the T+7 days, then an extension of 90-day period is there. And therefore the determination. Exactly. So exactly, we have not covered as to whether that 7-day period should be extended or not. But we have tried to understand what should be the role of the RP under the when he deals with the claims. So then we have said that what is the duty expected of the RP? The duty which is expected of the RP is to see what is the proof given. He is not to adjudicate, and that is how he has to look at the other documents which are available from the city and come up with a value. Apart from that, there's nothing more expected of the RP in a CRP process. Therefore, we believe that scenario can be covered in that aspect.
One question, please.
From the practical point of view, theoretically everybody would be doing that 8% of all. But practically, many times where we have a it is not so 70 is
always extended. So on a particular date, on a 30th day, when I have to file a claim, whatever claims received, that becomes a COC. It doesn't stop claimant not to file the claim later on. If a verification 30 days are over and somebody files a claim after say 2 months, then the claim also again has to be verified and admitted.
I think we are slightly discussing a different aspect here. Of course, 7 days can be restricting if an IP has to, go through a lot of documents for proof and everything. But in most cases, we have seen IPs try and get it done by the 7th day so that they can inform the claimant about the credit. But that 7 days in particular, of course, where it's difficult, then everybody else also understands it's very difficult to come up with a result in 7 days. So I think a market has developed its practice in kind of meeting that timeline, and where it's necessary, it is extended, and I think the claimants also understand. And while RPs update the claim forms in the IBBI website, we see that RPs generally do it on a fortnightly basis. So it seems to be working fine, though there are some difficulties for RPs.
One question, please. Please.
Governance point, which for all RPs, which we actually do it, we take up the balance sheet and we go out of the way to write to the creditors who are shown in the balance sheet. We don't wait, because there are a lot of operational creditors, a lot of MSMEs who probably might miss out the advertisement. So we make it a point that we write to the creditor as a part of a corporate governance. Whoever is appearing as a creditor in the balance sheet, last balance sheet, whatever is available to us, we will write to them, we will send them this claim form to fill up and submit the claims. I think that should be done by almost every IP.
Thank you, sir.
Yes.
Sir, one of the gray area which still surmounts is about the disputed tax liabilities and other contingent claims. So based on your research from US and UK model, do you have any better alternative? Because Supreme Court judgment suggests giving a notional value of 1 rupee to those contingent claims. So do you have in your research any better idea, proposition towards those contingent claims?
So with respect to contingent claims, we have found that in the UK legislation, they have come up with this best and fair assessment, in which the test which has been laid down is that if a similarly placed resolution professional would have come at a similar kind of a calculation of contingent liability. And that is the only test which is to be made by the judiciary while determining while adjudicating on a contingent claim. And the RP also, and the base of facts and circumstances, has to come up with a particular value on that contingent claim. As such, there are no strict principles on how a contingent claim. Thank you.
The final presentation for today's session revolves around the topic, the need to improve insolvency governance for committee of creditors and resolution professionals to safeguard the goal of corporate rescue. It would be presented by Professor Priya Garg, Ms. Trusha Modi, and Ms. Bala Pragata M.
Thank you. First of all, despite it being an honor to speak here, it is quite overwhelming to speak physically before an actual audience, I think after about 3 to 4 years. So first of all, I would like to thank IIM Ahmedabad and IPBI to organize a conference in a physical format after COVID. Now it's also a very proud moment for me because today the paper that we are presenting is something that the idea for which came to me during my master's, and actually my students, Bala, Pragita and Trusha, sort of took a lead on developing the paper and refining the arguments. And this is the reason in our presentation, while I'll be presenting the introduction to the idea which came to me and the conclusion, Bala, Pragita and Trusha would be respectively discussing the detailed part of the paper. So the topic of our paper is the need to improve governance standards for committee of creditors and resolution professionals to safeguard the goal of corporate rescue. Now, actually, this term, which is insolvency governance, is something that is very intriguing because there was a time in company law around 1990s when all we cared about was profits of the company. We really didn't care about how those profits were arrived at. So we really didn't care about how the decisions were taken in the board meetings and in the shareholders meeting. But then in India, as well as abroad, we got a lot of scams, right? So in India, we got Satyam scandal, for instance. And because of all of that, there were a lot of corporate governance reforms that were introduced to the field of company law. And even today, the Companies Act 2013 that we have is very high on governance standards. Now, I sort of drew idea from there and transported it to the field of insolvency law, which is currently, in terms of its scholarship and jurisprudence, very much confined to the principles of economics, property, and so on and so forth, but not so much on the principle of governance, which means the focus on the fact that once insolvency process has begun, be it the resolution process or the liquidation process, how exactly the decisions are taken, who are the actors who are participating, what is their eligibility criteria, how the decisions are actually arrived at, basically focusing on the how aspect and not just the end goal aspect is the whole idea behind the conceptualization of discussion on insolvency governance. Now today in this paper, while there could be various ways of improving insolvency governance, we'll be focusing on two institutions. One is COC, which is Committee of Creditors, and one is RP, which is Resolution Professional. One of my students will be presenting on how the institution of COC can be made to function in a more transparent manner. And likewise, the other of my student is going to present that how RP's institution and eligibility criteria can be made more streamlined so that there is more element of accountability, basically focusing on the how aspect of the result as well and not just the end result of maximizing the pie. Thank you so much.
Good evening, everybody. I will be right now talking about the issues with the constitution and conduct of COC. Like Professor has mentioned, there are multiple issues with the functions of COC, and it has been identified by the Standing Committee and IBBI discussion paper. But right now, for the purpose of the presentation, we are focusing on three specific issues with respect to the constitution and conduct of the COC, which directly affects the goal of corporate rescue. So we are amplifying on the goal of corporate rescue, and we'll be discussing how these three main issues of the COC affects that particular goal. So firstly, under the constitution of COC, I'll be discussing the issues with participation of the related party in the COC process. As we know, related parties cannot be part of the COC decision making process, and this is particularly provided in section 21 and section 43 of the code. However, there are multiple circumstances where, due to certain lacuna in the law, related party tend to participate in the COC's decision-making process. And as a result, it could potentially result in avoidance transactions, and which subsequently could erode the value of the company, and this directly relates to the goal of corporate rescue. So in the paper, we have discussed how these avoidance transactions could result in ridiculing the goal of corporate rescue. And specifically, we have discussed multiple cases which deal with the issue of related party transaction. Specifically in Fortune Pharma Private Limited, one of the corporate debtors, they signed the corporate debtors was the director of the company, and the director of the company, through an assignment agreement, assigned the debt to a third party. Now that non-related party was part of the COC decision-making process, and SBI was one of the other corporate debtors. Now, because of this assignment, the voting share of SBI reduced drastically. And because of this, they were able to control the decision-making process indirectly as well. This was considered to be a sham transaction, and something that NCLT also has noted that shouldn't be allowed. However, as the provision, the code does not specifically state that past debtors, any relation with the past debtors should also be, should be brought under the purview of related party transaction. There are scope to involve such related party in the decision-making process, and this has been discussed in the Supreme Court's case of Phoenix Arc as well, where the court has said that any sort of sham transaction should be avoided. However, we are of opinion that given that it's not specifically mentioned in the code whether a past debtor can be part of the resolution, the COC's decision-making process or not, and there is a lack of explanation about that, there is still certain confusion that revolves around this particular issue. Secondly, with respect to conduct of the COC, we are now going to discuss two main issues. We have discussed other issues in our paper. However, we'll be focusing on two main issues. One, the participation of inadequately authorized representatives in the COC process. So in multiple circumstances, what happens is the CD nominates a representative. However, this representative does not, they don't have the sufficient authority to make any final decision. So they are merely listeners and note makers, and later they have to relay this information to their senior authorities, and then a final decision will be taken. This clearly results in delay in the decision-making process, and throughout the conference, we have heard how delay is the main issue that's facing, that has to be changed in the IBC regime right now. So regarding this, IBBI had actually issued a circular stating that only authorized personnel should be taking part in the COC decision-making process. However, what happened in the IBBI circular is it puts the onus on the RP to ensure that only authorized person can take part in the decision making. However, we believe that it's more important to place that onus on the COC to state that only they can only send an authorized representative to the COC meetings. Thirdly, secondly, under the conduct of COC, this issue has been widely discussed and has been addressed at multiple times during the conference as well. The issue with wide discretion of COC. I don't want to get into what are the consequences of this wide discretion and the multiple instances where it has been misused. We have listed few cases which discuss this and which amplify on the issue about this. However, we want to focus on the code of conduct which has been circulated by IBBI in response to this wide discretion given, and the idea behind the code of conduct was to regulate the unregulated environment of COC's decision-making process. So we believe that it's a very welcome move. However, we have certain critique about the code of conduct. Firstly, we believe that there are certain terms in the code of conduct which are very uncertain and ambiguous. For instance, the code of conduct states that the COC has to maintain integrity and maintain objectivity while making decisions. However, what is the standard for evaluating integrity or objectivity is not provided. Now, if we were to introduce this code of conduct in the present form and attach it to the IBC code or any other parallel regulation, what could happen is, now this code of conduct could be considered as a law. And if we were to consider it as a law, then the court again can come in and interpret what each of these terms mean, which will again result in more judicial scrutiny, which has been widely accepted that it should not be the commercial wisdom of COC should not be scrutinized. Therefore, we believe in our recommendation, especially with regards to the code of conduct, that instead of making it a specific law or attach it to the code of conduct, the existing regulations, for instance, the regulation by SEBI or RBI, should be extended to the creditors as well. And this also promotes the inter-regulatory aspect that MCA wants to promote. Therefore, just extending this regulation could be a better approach rather than introducing the code of conduct as a law. And we have also listed few other recommendations. Firstly, with regards to related party transaction, we believe that written compliance should be taken from the COC, that only authorized person will be sent to the COC decision-making process. And secondly, with regards to the haircuts given, we believe that a higher upper limit of haircuts that could be potentially given could also be included in the regulation, so that the COC have some standard while issuing haircuts in the process. So this is the overview of what we have discussed in our paper with regards to issues with COC. Now I would like to invite Tushar to talk about the RP issues with RP.
So the governance issues with the institution of RP would be elaborated in three parts. Firstly, there is a lack of independent standard between the resolution professional and the committee of creditors. Secondly, there exists also a lack of independence between the RP and the resolution applicant. And thirdly, there is an overemphasis on the independence between the RP and the corporate debtor. So for the first part, as we all know, as soon as the CRP process starts, the resolution professional is handed over the management and the day-to-day operations of the company. So his role becomes important for the efficient operation of the CIRP process. However, the powers given to the RP is limited and subject to the authority of the Committee of Creditors, due to which the Committee of Creditors have an external influence on the decisions of the RP. And because of such external influence, the independence between the two is important to have a bias-free process, and impartiality of RP becomes really important, so that this process does not only benefits the creditor but also all the stakeholders involved. So the lack of independence that hinders the goal of the IBC, that is value maximization of the assets of the corporate debtors, was highlighted in the Binani Cements case. So in this case, because of the partiality of RP, there was a better resolution plan was discarded, which as opposed to a plan which only benefited the creditors. So there is a code of conduct for the insolvency professional, but it is silent and does not have any specific provision where the RP and COC should not be a related party or they should be completely independent. The code does specify the requirement of disclosure of any personal or pecuniary relationship, but there exist two problems with it. First, the code is silent on the breach of it, and secondly, if there is a majority creditor, he can appoint a non-independent RP as well. And the second issue is between lack of independence between the resolution applicant and the resolution professional. Such has been highlighted by previous researchers as well, and was noted in the Ruchi Soya Industries Limited case, where there was a conflict of interest because same law firm represented the RP and one of the resolution applicant, that is Adani Wilmar. So therefore, the lack of lack of standards, ethics, and proper framework for the functioning of the resolution professional will hinder the goal of corporate rescue, as it will discourage resolution applicants, especially foreign bidders, to submit a resolution plan. And as noted in the panel discussion today, there is a need to have multiple bidders and for value maximization of the assets of the corporate debtor, so as so as to have a CIRP process that benefits all the stakeholders that are involved and not only the creditors. The third problem is that of the information asymmetry. So even this problem was highlighted to an extent in the panel discussion today, where the promoters are ineligible to submit a resolution plan. However, the corporate ownership pattern in India is concentrated, and they possess the vital information which can prospectively lead to the corporate rescue of the distressed company. Though there is no denial that the promoters or the existing management might be responsible for the company's distressed position. However, insolvency is a economic failure and not a moral failure. Therefore, the code using one size fits all approach regarding the treatment of promoters and management can lead to can cause an hindrance in achieving the goal of corporate rescue. So the suggestions with respect to this is that India can adopt provision similar to UK, where there's a insolvency practitioner code of ethics for which has objectivity as one of its principles, mandating the RP to not allow bias, conflict of interest, or undue influence to override his professional or business judgments. Further, the conflict of interest could be countered by information barriers such as secure filings or confidentiality and terminating relationship. Further, a penal provision similar to Section 184 of the code could be implemented. So, thank you. The professor would conclude the paper.
Thank you. So with this, we talked about how the institution of RP and COC can be made more accountable, more transparent, and not just focus on arriving at the end goal, but also the process through which we go there and arrive at the end goal. And with this, we would leave with a question, which is that to what extent we can be inspired by company law when we talk about discussing the governance standards for RP or COC. Because the issue is that what is the role of directors when the company is alive or is an ongoing concern is sort of split between COC and RP when the company has entered into troubled waters. So to what extent we take clue from the way we have designed the institution of directors, etc., to apply to the governance standards for COC and RP is something that leaves us thinking, at least leaves me thinking. So with this, we would like to conclude. Thank you so much for your time.
I will just start with one question. Maybe you are proposing this under the code of conduct, these provisions of SEBI and RBI. I think disciplinary provisions you are. What provisions you are saying that they should be made part of the insolvency system or the?
We are not referring to any specific provision. However, given that most of the times the corporate debtors are banks and intermediaries, there are already existing provisions on how they should be how they should conduct their business, and there are certain code of conduct for them. It can be tailored to suit the needs of the IBC and CIRP process as well. What we are specifying is, given that there are multiple institutions which govern the creditors and also the CIRP process, it could result in multiple regulations. And also, like we have stated, that we don't want judicial scrutiny in the process, as a result of which we think the existing norms and regulations could be adjusted to be extended to the CIRP process as well.
So who should take action in case of violation of COC?
Right, that is the confusion that exists, and that's the lack that there does exist lack of clarity on that. However, we believe that given that judicial intervention is not the best way to go about it, that's why it shouldn't be made a hard law rather than like we should make it a non-mandatory soft law. However, we do not have the answer as to who should be the governing authority for the decision making of COC.
If there is like a fairness part of it, or the partiality part of it, or lack of independence part of it, or something related to lack of transparency, basically the judicial aspect of it, maybe we can give it over to NCLT. But of course, something related to commercial aspect of it or business aspect of it is something that NCLT is not the correct body to do. So I think our answer would be that if it is something related to standards, like we have for independent directors when there is company and there is business judgment rule to protect their commercial wisdom, something similar procedure at the stage of insolvency as well for the NCLT and by the NCLT for insolvency?
Yeah, so you have proposed a maximum haircut. So this issue has been discussed, I think, throughout yesterday and today. So let me just sum it up for you. So first of all, I think RBI Deputy Governor covered this. It was covered in today's newspapers also. This haircut is a discount which the market gives for dealing with the entity which has gone to the CRP process. So that is the first point. Second point was covered by MD SBI. So what you see as a haircut is not really haircut. It doesn't take into aspect various upsides which are there for the lenders. Third aspect is the denominator. How do you calculate the haircut? The realization by the claims. The denominator itself is flawed. Why it is flawed? Because the many times, especially the large cases, the account has ceased to earn any income for the financial creditor much before the time CRP is initiated. But when CRP starts, all claims are calculated as on ICD and filed as claims with the IP. So you see the denominator itself is flawed. So that's why the ratio itself is flawed. And it's very important for us who are in the IBC ecosystem to be aware of this and create awareness of this so that we are not carried away by this media hype which is created on this haircut. Thank you.
Let me just maybe add something to that if I have a minute. So point well taken, and that's something maybe we'll keep in mind as well. But I think with regards to our paper, our focus was, given that the COC does have some sort of unfettered power in determining the haircut in some ways, we thought that there should be some regulations with regards to that. Maybe maximum limit is not the way to go about it. However, we have highlighted how the unfettered power does result in excessive haircuts at multiple times. I think that was the focus. Right. Yeah, that's right. Right. That makes sense. We'll take into consideration that. Yeah, thank you.
I have a very small point. When I came in, you were discussing about some sort of code of conduct for the insolvency professionals. And you presented that on the lines of the UK, we should also have some code of conduct. I think we have similar code of conduct of the impartiality, avoidance of maintaining confidentiality or maintaining transparency, keeping arm's length distance, taking reasonable fees. A whole bunch of code of conduct is given in our regulations, and they are regulated individuals today. So what kind of governance in an individual structure you are suggesting, and what kind of more code of conduct are you suggesting? If you have any thought on that. Secondly, what kind of insolvency governance you are expecting from a committee of creditors, in the sense of an independent director you mentioned. They cannot be as independent as the independent director is supposed to be. They have a very clear conflict of interest, and that will be a perennial thing. That will be there. That is the basis of the whole process. So how are you suggesting? Very, very, very theoretical and principle-based suggestions you have given. How it will work insolvency governance in the structure of that committee of creditors institution, where they are having a very, very inherent conflict. How can you avoid that? So any practical thought on that in your discussion?
So I agree that these are theoretical suggestions, and you firstly asked that there are code of conduct for resolution professional, but I highlighted that the problem that exists is that the code is very silent on how would the court treat it when there's a breach of the code of conduct. And particularly one has to file an application with NCLT, and the entire process repeats itself again. So again, as throughout the conference it has been reiterated that time is of the essence. So we are actually looking for a code of conduct that would have a deterrence effect on RP. So one of the suggestion was to have a penal provision where the RP could be penalized, whether in terms of penalty or in terms of imprisonment, where he exercises his where he's partial, and there's inherent bias in the process.
And also, I would like to add that even in the present code of conduct, for instance, there are some lacunas. For instance, that at the moment, or even when the code was enacted, we have focused a lot on the independence from the corporate debtor, because we have sort of displaced them when the CIRP process starts. But the code of conduct is more silent on the need for RP's independence from even COC and its members. So that is one kind of example where we think there is some sort of lacuna in the code of conduct for the RP. That's number one. The second thing is that, thank you so much for raising the pertinent point that how can COC be compared with ID, independent director, because COC does have a vested interest because they are residual claimants at the end of the day. And this is something that I also mentioned or touched upon in the conclusion, that when we are thinking about something related to governance, it is something which is required to be explored, that to what extent we can compare maybe RP to independent director, but COC maybe to a non-independent director. So that is a sort of way forward for the query. Once we sort of acknowledge that there is a need for governance in the first place and focusing on the how part of the process and not just the end result. Once we do that, to what extent we can take or import principles from the ID jurisprudence or the ED jurisprudence or the NED jurisprudence is something that we leave open for further discussion. Thank you.
This concludes the evening session. Thank you to the panelists as well as the audience, and to everyone who raised all those pertinent questions. Tea and coffee would be served outside, and the concluding session would be held at PP Gupta Auditorium itself. Thank you. Here only, it's the same auditorium.
Joining us in the concluding session of this conference, I invite Mr. Sudhakar Shukla, whole-time member IBBI, to please conclude the conference with a few remarks.
Good evening. I need some attention from IU also. So this is a concluding session. I thought normally in international seminars when we go outside, it's a more of a feedback session than concluding, because you must have all noticed that there are some gaps still remain despite the scaling up the expectations and what we delivered. So even if that is not we are doing today, but our email numbers are with you, and we honest comments in the sense what you liked, what you don't like, and how it can be done better next time. Those things we will eagerly wait. So this feedback loop has to complete and give us confidence that we are on the right path, and we will move with this idea. So for conference, actually, I wanted to start with the words of Sir Norman Wisdom. he says, and this is the quotation, as you get older, three things happen. And I am also catching up the age, so as you get older, three things happen. The first is your memory goes. And he adds that, and I cannot remember the other two. So it was such a wonderful experience here. Basically, even I'm not that category that to forget everything, but I remember the hospitality. But I don't remember the hostility of the questions which came to the panel. So that is there. With hospitality already mentioned that, and I think it will be the case for everybody here, that our waistline has increased by inch or so in 2 days' time. So it is a remarkable commentary on kind of good food being served. So that a hand of applause to basically the kind of I thought rolled out was extraordinary from IIM Ahmedabad. But not only jokes apart, waistline increase, but more importantly, food for thought was very important in the sense it gives us vibration and it also keep us engaged and agile to upcoming challenges. And that's what we expect from the conferences like this. So this is the conference, and if you see the structure was very methodically planned. Whether you have noticed or not, but we had researchers, they were in the front line, they were presenting, but there was also in side by side panel discussions feeding you, all the researchers and the regulators, new questions to ponder and come up with more research papers in the domain of knowledge and wisdom which they were displaying. So, second round of applause is for the panelists who have basically made our day in making so many good suggestions, and I hope you all have must have noted down, but we have also taken note of. As a regulator, I may have some differences on what has been said, but on research question, there is no doubt whatever they said needs to be validated. So without validation, if I say I doubt, it has no meaning. So definitely that validation has to come from the researchers only, so nobody else can do that. So the questions which were raised, actually, I have jotted down some by the panelists and the questions and the presentations you made. First question, I am starting from the last question with this side raised about the haircuts. So many presentations were around haircut, how you understand haircut, whether it is good or bad. A standing committee report was mentioned. In standing committee report says there should be a threshold of haircut. I thought last presentation also suggested that. But as a regulator, again, I have a difference of opinion in the basically this threshold, if you provide, the market mechanism which we all so proud of will go for the 6. So either you choose a market mechanism to dispose of the stress assets in a more prudent manner, or you fix a limit within which all would be resolved, or they would be like, if you are saying 30% haircut is acceptable, if anything below 30%, it need not resolve, it will be lying in the lines that deteriorating the value over a period of time. Haircut is another story to tell also. Basically, one story was told by the bankers also, that the kind of dimension which we mentioned in the haircut is not fully a real story. It is not actually the claim. Claim is much less, but penalties and interest pile on. So that is surely a issue. How to deal with that? I will not say exaggeration, but some addition in terms of lambda, whatever you want to say, over and above the actual claims. And while settling, actually, when we say haircut, we are ignoring two things. And I, as a researcher, I am leaving to you this question. Two things are left out. One is basically guarantees. Guarantees come into play while calculating the claims, where they should not be. But guarantees are coming in the claims, and they do not come into the realization, because guarantees realization takes place much after resolution has taken place. So guarantees, we have to see how to track them. This conference has talked about avoidance transaction, I think, a lot. And avoidance transaction is again one element, another element you can say, which is missing from the haircut debate. So haircut debate is not conclusive in itself, because many parameters, denominator, numerator, everywhere there is an issue which research question can answer better. So I thought haircut issue is important, but we have to be seen that, and somebody here mentioned the Videocon case where complete tonsure was mentioned, that my question to that fellow is that if person is going with a bald head, where is the question of haircut? So quality of asset is very important. And if quality of asset is zero, definitely there would be 100% haircut, and that was happened in 2021 to two IT companies owning 8,000 assets, 8,000 crores of claims from banks, were operating from the matchbox offices, no assets. And that office was rented premises. One room, rented premises, no assets. You tell me, where is the magic wand you can create value out of it? Nobody can. So it is theoretically you can say that, oh, haircut, we are also bothered. We are always been in front to get the flakes for this, that haircuts is happening. Second question which I deliberated is delays. And this was basically some good suggestions have come on automatic admission. That is again a question for the regulator to the government, basically that how to make admission process at least automated, or maybe through different route. And even the Madam Judge also said this, that it could be a single member bench. So if judiciary itself is demanding that reforms have to focus on single bench dispensation with regard to admission, then that should be adhered to. Next important debate, and in many papers it has been mentioned, 29A. And panelists were very candid and upfront in saying that 29A disables promoter and it should be avoided. So just I wanted to leave a thought with you. I'm not giving any recipe. I don't have any. But a thought is basically 29A does not debar promoter. This thought I want to leave because this is a misnomer to say that 29A debars promoter. It debars ineligible people. So ineligibility is the main criteria, and promoters, because it was mentioned that who are like even advisor to PM advisory committee also mentioned this, that basically if somebody has not done any fault of his own and is still gone broke, so why to penalize? So I just want to clarify that he is not being penalized. Our 29A does not debar him from participating and getting back the firm. So that issue I thought was some clarity was required. Section 32A, again, our perspective is different, but like Supreme Court brought, and I am not advocate, so I thought maybe I'm erring in my reading of Supreme Court judgment, but it is very clear that no Hydra head should erupt in the context of statutory regulatory applicants, that resolution applicant, that SRA should not be troubled for the misdeed of the promoters. So this is a clear position of law. But still it is being agitated. How two ministries can sit over it and resolve is a issue, but this is what the new direction is. So I thought the territory which we have covered and resolved, I think we are opening up new grounds for litigation. On ACs actually, debate was there whether we provide something, we don't provide something. But whatever data you got from here, from the panelist on behavioral change, is a 19,000 companies, CDs, whatever you say, and 6 lakh crore realization is basically cases pertaining to OCs. This is the settlement before entering, and promoter is cognizant that if he does not settle the OCs, then he will be taking the company to the NCLT, and bankruptcy process will begin. So that again a research area. When I think even IBC is trying to put up some research ground on that. Basically, whatever has been withdrawn, what exactly proportion is for OCs and what is financial creditor. So that is there, but normal perception is this is OC driven, and that's what we get the feedback from the various CDs also, that this is how it is being done. Then we heard about effectuating IU's position, and surely a lot has been said by MD and ESL here, present here. So suggestion has come from the dais basically for early warning signs. And that early warning signs have to be like some mechanism has to be prepared. And we were saying, we were discussing with IU that why don't you have entrepreneurial index on lines of CIBIL. So any entrepreneur can see he is red or green. Not only banks, but they can also see. And we have the data to support this, but perhaps mandate requires more enforcement so that they can begin this work. But definitely this is a good suggestion. Early warning systems are required so that we should not face the cases of insolvency a lot. We have been on IBC also, we got some flakes here, and we accept with gratitude and all most humbly that basically peer review and third party evaluation, though we have done, but it should be of regular nature. We should not praise ourselves all the time that we have done this. It is the evaluator who has to say it, and they have suggested a evaluation wing. Definitely when manpower increases in IBBI, we would be trying to get some semblance of evaluation wing within IBBI. So that is what has been suggested. Independent audit, of course, this was said, if you are not doing evaluation, you get it independent audit done. So this is again would be on radar, how to do, when to do. And most important last point I thought, which I noted from the discussions, was there is some capacity constraint on behalf of basically IPs and valuers. So they don't have kind of training which investment bankers have to run the company as CEO, and other professionals can handle better. So definitely this is one area where we can look at how to strengthen the training needs of the insolvency professionals and your IPs and valuers. So these are the points I have noted. And I just wanted to end with the thought that, again, to the researchers, because this is a research conference, that IBBI has very robust system to promote research. You have presented your papers here. We have asked you that we can publish it. Whosoever will say yes, we will publish it. But apart from it, you can keep on engaging with us, because we have a policy to engage with the researchers. So we not only provide you the data, but we also provide you some amount of money also to carry out your research. So it is data plus some resources so that that credible research can come out. So many of you, I would be encouraging that be in touch with us. If you have some credible proposal, we will be trying to see that your proposal is adequately funded within the limits which are provided by our regulations. So I thought that's what I wanted to say. If I have left something, you can add. But thanks again, because this is the last point, because basically first day itself, it was clear that IMA has to be knowledge partner of IBBI. And for this, I need again a round of applause for IIM Ahmedabad, that they should come forward for the partnership, which is long lasting. It should not end with a seminar or begin with seminar. I think it has to be hand holding, should continue for longer time. Thank you very much.
All right, thank you. We had a good 2 days. The quality of presentation, the speakers, the participants were exceptionally high. We never thought we would have full audience. When we decided the conference to go ahead, we were benchmarking with online conferences. Normally, around 10% of participants turn up during online conferences. So we have a full house, even today, even now, it's a full house. So thank you so much for coming. A round of applause to you first. And we have just face of two institutions. The real work is done by someone else. From IBBI, Mr. Ritesh Kavadia. Please, sir, can you stand up? Dr. Anjala Guru, she could not come. She contracted COVID. Dr. Jairam. And Mr. Das, he is the man behind. And all the officials from IBBI, we have a lot of officials from IBBI. If you can stand up, people can see, it would be nice. Yeah. It's a full strength. I think close to 90% of IBBI staff is here. All right. Okay. Okay, I haven't completed. From IMA, again, Abhiman and I are just, we are teachers. We can only speak. The conference is completely handled by Sindhu and Vaishali. Is it there? Yeah. It's their conference. We are just the face, and we have an volunteer is Purvi. We have Devesh, Nirmohi, Varun. Did I left anyone? Okay, all right. So yeah, these are the people who made sure the event happened and a successful event as well. All right, that's a small conclusion from my side. Again, we are open for collaboration. This is not the end, as WTM said. We encourage collaboration with us. We don't have the funds as IBBI, but we can host. We can engage in an idea. Please write to us. We don't have any single email ID. You can look at the website and write to faculty and staff. And we hopefully will respond. Our responses can be delayed depending on the classes. Anything else? All right. Again, thank you for WTM as well. Thank you. Yeah, one more thing. We have two guests, international guests, Professor Laura Cordis. We have Rebecca Perry from UK. And both of them came to India for the first time. Yeah. And this is not a good time to be in India, especially in Gujarat. Yeah. Please come back again. We are again welcoming you back to IMA and to India. Thank you again.
Thank you, sir. With this, ladies and gentlemen, we close the two-day conference, international conference on IBC. We at IBBI, on behalf of IIM Ahmedabad, extend our heartfelt gratitude to all the distinguished dignitaries and invitees. We are grateful to you for your invaluable contribution, enthusiastic participation, and very patient hearing. And thank you for making this conference a resounding success. And we hope that your support will continue going forward as well. Thank you very much.